Welcome to Baker's channel where stories unfold, covering trials, dramas untold. Grab your seat, settle in, start the show. Courtroom clashes, the fun we bestow. Baker's channel, action's hot, dramas and fun, all we got. Discuss, debate, break it down. Baker's channel, just the best in town. Lawyers spar, tensions high, sparks fly. We laugh, we learn, dive into the why. Join the chat, have your say, it's your place too. Every twist, we're here for you. Baker's channel, action's hot, draws and fun, all we got. Discuss, debate, break it down. Baker's channel, just the best in town. Stay and please, like, join the crowd. Baker's channel, we're live and loud.
Good morning, good evening, good afternoon, wherever you are, whoever you are, what if anything you are. And welcome to this Monday morning, where we will be diving back roughly a year ago into the Ashley Benefield trial. It's also popular known as the Black Swan case. It's about a young woman who was a ballet dancer, and she met an older gentleman. They got married really quick, within a week. His buddy performed the wedding ceremony. He came with, I think he had one or two kids to begin with. They had a kid. They kind of split up. At some point, he got so mad he made a new hole in his ceiling. She moved away. They found each other again. I believe she was pregnant when they were deciding to move one more time. Her mom and kid left the house, and he got some new holes in him in the back. But she claimed that she did it in self-defense because she was so afraid of him. In Florida, they have what's called stand your ground, that you are allowed to protect yourself. And they had a hearing a year ago because she claimed it's self-defense, and they had a hearing under the stand your ground law. The first part of it is missing. It's not me who moved too far ahead, but the lawyer is already speaking as we get into it. So that's what we're doing today. What do you say, Jamie?
Sounds good. This one's been continued for a long time, so I'm very curious about it.
And hopefully it'll be starting next Tuesday. They're seating the jury Monday, which fits us perfectly because there's a Karen Reed hearing Monday. Schönen Nachmittag, Helene T. Wie geht's? We are keeping our eye on another case that we might be able to cover this week out of Florida. A former radio host who were maybe unalived by her former boyfriend, current boyfriend, baby daddy. It's kind of weird. He has a tendency, like Sarah Boone, to send letters to the judge telling how good a person he is. But they should be seating a jury today. I have my lead investigator trying to figure out if it'll be streamed.
Good job. Hi, everybody. Welcome.
I'm actually angry at my barber because he clipped it way too short, way too high. But thank you. I just had a hairdo today.
It looks nice.
Hey, Flash fan. It's been a minute, yes, but glad you're back.
Welcome back.
Well, she did put the holes in him, but we have to figure out if she did it legally, because you can legally do it if you are fearing for your own life.
Yeah.
So that's the thing we're going out. Well, thank you for being here, Melmac. That's the planet that Alf is from.
Melmac?
Yeah, I'm pretty sure Melmac is the planet Alf is from.
I don't remember what planet he was from. I used to watch that show too.
Well, we're going to see it live today, so maybe we can see. Yeah. I look hip. Oh, my.
You look hip.
I didn't say that. Jar said that. And I believe Jar when she says I look hip.
Mm-hmm.
Jamie, I was right again. Sometimes you should listen to me.
It's too difficult to listen to sometimes. No, I'm kidding.
Why is it referred to as the Black Swan case? Because at the time this happened, well, not at the time, right before this time, there was that famous Mila Kunis, who's the other chick? Natalie Portman movie where she was a ballet dancer who had the black swan. She was the white swan when she was normal, and then she became the black swan. She thought it was two different people. Didn't watch the movie. I think it was something about she was schizophrenic or something like that, and she thought someone was trying to get her job or kill her or something like that, and that was the black swan. But in reality, it was all in her head. Something you can't say to American ladies, I've been told by the White Rabbit.
But this chick was like really a professional ballerina and stuff like that.
He was, and he helped her. He financed her the American Ballet Institute, I believe it was called.
Yeah, they
Natalie
bought
Portman.
a ballet studio together. And then it went bankrupt, right? Yeah.
I don't look that much into cases, Jamie.
I think it did because I was reading about it.
Well, it's the suitcase had a black swan in it. I didn't watch it. Well, I don't listen to you, Wolfstone. It went bankrupt. Okay. Cindy
Yeah,
Lou
because I
Woo,
think that contributed to a lot of their fighting and stuff. So
yeah, but let's try and get a feel of this case. I don't know if we're gonna watch all the pre-trial today or maybe tomorrow too. Jamie wanted to start so late today, so it's her fault.
sorry.
But let's get into it and see.
I didn't realize it was this long.
No, you never listen.
No, I don't.
Did I see Sarah Boone is going pro se? No, Sarah Boone was forced to go pro se because the judge made a ruling because she had been through 8 lawyers so far.
Mm-hmm.
She was an actual ballerina, yes. But let's see if
reasonable. So to that end, as the court is aware, we established a prima facie case that the force used was justified. The state stipulated to that, and Your Honor signed an order so designating it. At that point, the burden shifts to the state to establish that the force used was not justified. That's what the statute says, and that's what the case law holds. The standard that the state has to meet to do that is clear and convincing evidence. So that leads us to what I think is a very appropriate consideration, Judge White, which is what are the parameters of a motion such as a stand your ground motion? I would suggest to the court that was pretty well defined in the second DCA case of Bowie versus State. I'll give the court the site at 292 Southern 3rd, 471, and specifically page 483, second DCA case 2020. The court there pretty much stated that the inquiry for the court is to entertain any evidence which establishes that the force that was used was not justified, which means, Judge White, that any other inquiries are irrelevant, specifically motive.
Random bus stop people, we are watching so please don't spoil it for us. I didn't watch it. Hey, Brian M.
Your motive, a lot of times at a trial, is not required. It's never an essential element, but when it is available, it's a very powerful tool for the state to present to a
seating jury Monday.
Jury. Abuse allegations, also irrelevant, as is Ms. Benefield's psychological state. Why are they irrelevant? They're still, of course, subject to the rules of evidence, even if the court entertained them. But the question then is, why would they be irrelevant? And it's our position, Judge White, that they're irrelevant simply because they are not material to the stand your ground statute's requirements. As the court knows, the issue is, was Ms. Benefield in a place where she had a right to be? Was she involved in any criminal wrongdoing? And did she have an objectively reasonable fear of great bodily harm or death? So the case law supports exactly that. One of the benefits, Your Honor, of being in the Second Circuit is we have very well-defined case law on stand your ground. And I'll cite to the court two things in particular that should apply across the board to this hearing, respectfully. The first is in Riggins versus State, which is in our brief. It's at 344 Southern 3rd, 625, page 626. Also a second DCA case in 2022. Therein, the court held that the trial court, this is a quote, the trial court is to assume all facts as true. Secondly, I would cite to the court, also in our motion, the case of Jefferson versus State, 264 Southern 3rd, 1019. Again, a second DCA case, 2018. Here's what the Jefferson court had to say in upholding the stand your ground motion and immunity filed by the defense. Quote, we are mindful that there will be situations.
It's in the scroll on the bottom, but it's Florida. And if again, newcomers, it's the Florida v. Ashley Benefield. It's also known as the Black Swan, but this is a stand your ground hearing they had last year,
where the accused is the only available.
And those people who are whispering that gets picked up by the microphone is worse than on Bev's sighing.
Witness to the events leading to an act that is claimed to be justifiable use of force. This may result in great difficulty for the state to overcome the accused's prima facie claim by clear and convincing evidence. But our result here is mandated by the text of section 776.032, subsection 4, stand your ground. In closing, Judge White, I think that the state will be unable to demonstrate in any capacity, much less by clear and convincing evidence, that Ms. Benefield, knowing what she knew on the day of this incident about DB, which is the objective standard, Douglas Benefield, was not justified in using deadly force to prevent great bodily harm to herself or death. Thank you.
Thank you, sir. All right, State.
State calls Tommy Benefield.
Judge, I suppose now we're into our omnibus motion and then you read the
And you're talking about your omnibus motion
Yes, sir.
under, hold on one second. I'm looking through. I'm going to go ahead and put whatever it is on the record related to
Yes,
Tommy
sir.
Benefield.
Number two, yeah.
Number two.
I had lodged an objection to any Benefield family member testifying without personal knowledge of or participation in the events immediately preceding the alleged homicide. I then followed that up with a discussion about testimony by non-expert witnesses who lacked personal knowledge and cited the Florida Evidence Code. And I also included in the memorandum for Your Honor the following. As the court knows, in a homicide case, the accused has the absolute right to open the door or keep it closed as it relates to character evidence. Only the accused can inject character evidence, after which the state is permitted to rebut it. It is the same thing with a witness's testimony under 90-404, Your Honor. Mr. Benefield is limited. The state can establish that Douglas Benefield had a reputation for peacefulness once it's attacked. The rule is very clear. So it has yet to be attacked. Mr. Benefield can only testify as it relates to the rehabilitation of character by the state for peacefulness to his reputation in the community. Mr. Benefield did not live here in this community. He can only testify to his personal perception of his cousin's reputation for peacefulness, which the Florida Evidence Code does not allow. That's our objection, Your Honor, respectfully.
Thank you very much. State.
And Judge, the state does not intend to elicit testimony about reputation.
Okay. This is a great example of what I was saying when we were talking about the hearing is, I've heard your objection. I'm going to reserve on it.
This is a bench trial. They don't need an opening. It's a stand your ground trial. And we didn't get the full start with it because there's not recordings of that. Good morning to you as well, Whiskey.
Hey, Whiskey. Hey, Marissa.
Because I don't know what these witnesses are going to say. I don't know quite where we're going. You guys know the case so much better than I do. So for now, I'm going to allow it, and I'll reserve at the end for, so keep making your objections. I'm going to reserve on those, at least this one. Some of them might be a more clear call.
It's a stand your ground hearing in the Black Swan case. Did she have the right to do what she did? She put two new holes in her ex-husband, kind of maybe claim. Well, we haven't really heard the claims yet, but she claims she had battered spouse defense.
Mm-hmm.
Hey, Ray.
But we'll pour it all in the pot and see what we get.
Understood, Your Honor, and I might say I'm quite comfortable with the court proceeding that way. I have no doubt.
Thank you. But let me say this. Having sat on both tables, you make every single objection as we go that you feel you need to make. But I understand completely you have just a general objection to all of that character evidence, the background. You want to focus on that particular day.
Yes.
Got it. Yes, ma'am. Okay, thank you.
Tommy Benefield.
I can hear it fine.
Yeah, it's loud for me too.
Will stand right here, so face forward, raise your right hand in front.
Do you solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth?
I do. Switch this. And see the black chair, stay about 12 inches from the microphone, please.
Hello, sir. Morning, Judge. My name is Judge White. I'm presiding over this hearing. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. You adjust up, down, left, right, wherever you're comfortable. If you just speak in a loud, clear voice, it'll pick everything up.
Yes, sir.
Good morning.
Good morning.
Let me just.
I don't know. It's I don't know. Maybe someone knows. I didn't study that hard. I didn't know there was going to be a test today. Jamie, you didn't tell me we had to do a test today.
What are you talking about? Justice
She's
Conway?
asking where in Florida. I didn't know questions would be that hard. I thought we would do our normal stuff. Said his hair looks kind of like the dad from what's the one with Kevin and the girl who turned hot later.
What are you talking about?
That TV show, The Wonder Years or whatever it's called.
Yeah.
Yeah. That.
What about his hair?
His hair looks like the dad from that show. I thought we were just doing what we normally do, our humor stick, and then we'll wing it. And I'm pretty sure if Mo was here, she would say that shirt looks from the 60s as well.
Oh my God, you're ridiculous.
Welcome, Shannon, 1989. And you came just about the right time when we made fun of nothing. Remember not too long ago when there would be like 12 of us watching the Broken Baker's Moth Mouths. Now look at you. What the hell? Dave, I'm live. You can send me a message at some bit. Thank you.
I heard
Leslie.
it beep and I'll look at it too.
Yeah.
Yes, can you see?
I can, Your Honor, it's being blocked a little bit by the photo.
If you need to readjust yourself or reposition, please feel free to do so. Yes, ma'am, I'm sorry.
Please state your name.
Tommy Douglas Benefield Jr.,
How do you spell your names?
TOMMIEDOUGLAS BENEFIELD Jr.
And what was your relationship to the deceased Doug Benefield?
First cousins.
And how close were you?
We were close our entire lives, and I was instrumental in him going into the Navy when I was in the Navy. Both naval officers, both flying off aircraft carriers, both did other work for the government, and then all the way through his business career and his dual career in the government and in private. Probably talked weekly to monthly, depending upon the times of our lives.
Okay.
I visited his family multiple times in Charleston.
And let me just ask,
yes, ma'am.
before he died, where did he live?
Well, he was in an apartment down here at the very end.
But before he moved to Florida, where did he live?
Charleston, South Carolina, 701 Preservation Place.
And where do you live now?
I split time between Jacksonville, Florida, and Atlanta, Georgia. My wife and I have a spa business in Atlanta, Georgia, and I work 2 weeks a month in Honolulu, Hawaii.
And what is your job?
I'm a flight instructor for Hawaiian Airlines, teaching pilots in a particular airplane.
So let me ask you a little bit about Doug. At the time that he was murdered, how old was he?
He was just 1 week short of 59. He's born October 5th, 1961.
And how tall was Doug?
5'9", 5'10".
How much did he weigh?
I'd say 160 to 170.
And you already said before he moved to Florida, he lived near Charleston, South Carolina?
In Mount Pleasant, a suburb on the north side of the river.
Okay. And just before he moved down here to Florida, who did he live with in the house?
Just Eva and himself, except for the time that Ashley was living there previously.
So you said Eva. Who's Eva?
Eva is his biological daughter, first daughter, with his longtime wife, Renee.
And how old was Eva at around this time?
15, I believe.
So a teenager.
Yes, ma'am.
When did you first meet Ashley?
It's a bench trial. It's not a jury trial.
I had an overnight. I was flying for Southwest Airlines, had a change in a schedule. They sent me to Charleston, just me, not the rest of the crew, to take a plane into Charleston. And I texted Doug and said, hey, I'm going to be in Charleston tonight. Let's go to dinner. He texted back, great. April 14th, 2017 was the date.
You seem to remember dates well.
Yeah, but trust me, the judge have been in that situation before. And he also just said, you'll give all the objections because I'm not that into this case. So this will be very different than what we see. There will be less theatrics and the objections will probably be better as well. But it's a bench trial.
I was
So
thinking
no
the
jury.
same thing though, because like that's where my brain goes. I'm like, did she just say that?
Yeah.
Yeah, I get it now. I mean, yeah.
So, but it's the same as when we do it here, that we don't get the theatrics because we're not 12 new people who just sat on a jury. They kind of know we know what's up. So that's the difference.
You have a very good memory, ma'am.
Okay. So you remember the exact date was April 14th?
Yes, ma'am. And I keep a diary and a flight log, so I know exactly when it was.
So did you in fact meet up with Doug?
Yes, when I got into Charleston, ahead of the hotel, I texted Doug.
This is a pre-trial hearing from last year. I don't know how long the case in chief is going to be. Some people are now saying they're supposed to start Friday. I saw they were seating jurors the 22nd, which would be Monday. But I don't know how long it is. So, sorry, Jedi Jess. I was halfway correct. But it's still a stand your ground hearing. Sorry. Again, I'm not a lawyer. This is not a LawTube channel. This is a jury channel.
Again, and he said, Ashley's not feeling well. Could you take Uber up to Mount Pleasant to the house?
Overruled.
Did you know who Ashley was?
I had never heard of Ashley at that time.
So he spoke it like you knew who she was?
Yes, ma'am.
Did you take an Uber to their house?
Yes, ma'am.
Once you got to the house, did you meet Doug
I met Doug and Ashley together.
and Ashley. Was that the first time you'd ever met the defendant?
Yes, ma'am.
Did you speak with both of them together about their relationship and how they met? I'm assuming you were basically like, who are you?
We spent 4 hours together.
Okay.
We started at the house. I got her short life story, their life story together at that time.
So their life story together at that time, did they say how long they had known each other before they got married?
Yes, ma'am. It was almost a sense of pride for both of them that they had only known each other 13 days.
And how old was Ashley at the time?
At that time, Doug was 54 and she was 24, I believe.
So a 30-year difference
Yes, ma'am.
between them. Did, and I think you already answered this earlier, but did Eva live in the house with the two of them?
Yes, she did.
Did the defendant ever mention that she had a job?
No, ma'am. It was only past history stuff and what she was doing temporarily in the 2016 timeframe.
Was she interested in the ballet?
Yes, ma'am. She was a former ballet dancer. And by this time, they talked about the American National Ballet they had founded in February.
So let me stop you
Yes,
there.
ma'am.
So was Doug interested in the ballet?
The way a husband is, proud of his wife, supportive, knew nothing about the ballet except its existence, I think, prior to that.
And prior to this meeting with Ashley and all this, had he ever expressed any interest in the ballet?
No, ma'am.
Okay. So you mentioned February. So they started a ballet in February?
So there's an old ballet that was defunct called the American National Ballet. When Ashley wanted to start a ballet and make this a special ballet, a diverse.
Daniela Fonseca, I can't tell you what the criteria. Maybe Jess can tell you because she is actually a lawyer, but it's a hearing to figure out if the trial goes on. So it's like a pre-trial hearing to figure out if she had the right to do what she did, or else they will then go on to the case in chief, and they can still use the same defense, but the judge threw it out. But probably someone who is smarter than me can tell you. We just started, Jadzia. This is a pre-trial from last year. It's a hearing about the stand your ground law in Florida, if she had the right to do it. The case is supposed to start either Friday or Monday.
Non-judgmental, non-stereotyping ballet. Doug found a name and found an old ballet, and that's, I believe, February 27th of 2017 is when they founded it on paper.
So a couple of months
I'm
before
sorry,
you met.
Susan. Continuing relevancy objection. I don't want to keep.
Understood.
So you mentioned that was February of 17. So that was roughly 2 months
Yes, ma'am.
before you met Ashley. And how was the ballet being paid for? Did they discuss that with you?
Doug did. They both did.
Okay.
Uh,
Ashley did as well.
she talked about it.
Yes.
She understood what Doug was having to do to raise money and to put money personally into it. Doug was very, very good in all his businesses about doing the founding paperwork and establishing an LLC. And he had done the same with the ballet. He had built a website. It's typical of Doug to build it all himself from scratch.
And you said he put his money into it.
I know he put his money all the way till he ran out.
And then did he also have other money?
There were investors, including his business partners and other donors through the process. Yes, ma'am.
Okay.
Thank you, Jess.
So it was actually formed in February of 17, but was there a formal launch of the ballet?
So the night I spent with them, they talked about the upcoming events. There was an informal launch in May. There was a formal big donor party that I was a part of, brought all my business partners, a lot of veterans that I work with, to a McKee House event in August, I believe 12th of 2017. So that's the ballet that I learned when the event was coming out, and planned on being there and bringing all my people.
Okay. During this time, 2017, at some point, did Ashley and Doug decide that they were going to have a child or try to have a child?
That wasn't a part of that first meeting night. We talked about everything else and caught up on everything that we hadn't known. But it wasn't a part of that night. We ended up leaving the house, going back to my hotel, having dinner together. I'm a master trainer in a medical device. It's a pain relief device. It helped her, helped him. And then they headed back home that evening, but there wasn't any talk that evening about having a child.
Was there talk later on specifically with the defendant about the child?
Certainly. Vasectomy reversal is a very intrusive surgery for men. And when they made the decision they were going to do that, he and I talked about it at the time, in particular because of my medical device background, that could help him.
Okay. So they decided as a couple that they were going to have this vasectomy reversal to try and have a child?
Yes, ma'am.
Okay. And did the defendant, in fact, get pregnant that year?
He had the vasectomy reversal, and 3 months later, she got pregnant, I believe, because we talked about it later, that the conception date was July 10th of 2017.
And at some point shortly after that, did she move away from their home in South Carolina?
Yes, so August 12th is when we had the McKee House event, the big donor event, introducing the other members of the staff of the ballet and everyone involved. Ashley and her mother, Alicia, were there. I was there. And 2 weeks later, I believe on the 26th or 27th, they made the decision together that it would be better for her because of her morning sickness to go live with her mother because Doug traveled for work and was busy. And that was what was presented to me by both of them.
And her mother lived in?
Lakewood Village here in the Sarasota-Bradenton area.
In Florida. Okay.
Yes, ma'am.
And so shortly after that, did Ashley move?
I believe on the 27th of August, because Doug called me both on the way down and the way back.
Did he help her move?
Oh, yes, ma'am.
Did he move with her?
No, ma'am.
He stayed in South Carolina?
Yes, ma'am.
So that was August of 17.
Yes, ma'am.
Did the ballet eventually go under? And when?
So the ballet opening, the actual launch to the public was September 18th of 2017. That's a landmark date in this case in my history because it's the date Ashley and her mother went back in the house and got her stuff and she filed against him.
Okay, we're not going to talk about all of that.
I'm sorry.
So he paid for the ballet school until it went under. But the day it started, she filed for divorce. Did I understand that right?
I missed that part, but I heard about it when it went under and everything.
Because it's the date Ashley and her mother went back in the house and got her stuff and she filed against him.
Okay, we're not going to talk about all of that.
I'm sorry.
Then why did he keep paying until it went under and he used all his means for it?
Oh, wow. Maybe he thought that she wasn't really going to go anywhere.
That's,
Mm-hmm.
yeah. Well, he is a flight guy, so he apparently keeps both a journal and a flight record. I didn't understand what the flight record had to do with it. That's weird.
So shortly after this whole time, we're going to skip ahead, did the ballet eventually collapse completely?
Yes, ma'am. I'll answer it more directly. I apologize. So they launched it publicly on September 18th. The biggest performing arts center in Charleston is called the Gaillard Center, Big Performing Arts Center. And they actually held an opening performance on December 7th of 2017. And the dancers had been paid through December 15th. And by the end of the month, everything was finished.
Okay. So by the end of December 2017,
everything's done.
It was defunct.
Yes, ma'am.
Okay.
So 3 months.
During the time that you encountered Doug and Ashley together and talking to Doug, how did he act about Ashley?
He was completely in love, completely supportive, starstruck, visibly, physically. You could tell by the way he treated her, took care of her on the opening night that I met him, met her, and then it continued through the entire relationship until I never saw them together after the separation.
Okay. And when was that?
Well, physically, August 27th of 2017, when he drove her down.
So you never saw them together after that you can remember?
Well, I'll leave a caveat on that. I spent a weekend down here with Doug, Ashley, her mother, spent one night in the home where Doug was killed or murdered. And I don't remember that date. It could have been after the separation, probably was, but I just don't remember that date. But that would have been the only time that I saw them together after that August 27th period.
Thank you. I have no other questions. The defense will probably have some questions. Thank you.
Cross?
Thank you, Doug.
And
Do that.
let me just say, I completely understand that based on my evidentiary ruling so far, how do I say this? I know you probably wouldn't have asked a bunch of questions, but certainly for your cross-examination and any proffers of cross, I understand it's going to be broader than what it might have been.
Maybe not.
All right, maybe not. And please, sir, feel free you can question from either podium, wherever you feel more comfortable.
Thank you.
I like this judge so far.
Yeah, he seems pretty chill
Yeah,
about
really.
everything.
Relaxed, but still on top
Good
of
morning,
it.
Mr. Benefield. I'm Neil
Yeah.
Taylor. I'm appearing on behalf of Ashley Benefield. I regret that I need you under these circumstances.
I understand, Mr. Taylor. Thank you.
You were a pilot,
Yes, sir, still am.
and consistent with being a pilot and listening to you and your detailing of events and dates and times, it's pretty stereotypical of the discipline that a pilot generally brings to their profession. Would you agree?
Yes, sir, you want the best people up front that work like I do.
All right, and you've told us that as a first cousin, you were very close with Doug Benefield.
Yes, sir, I was closer with Doug in our adult lives than my own brother, who was still alive at that time.
All right. Now, Doug was not a pilot,
Yes, sir, he was.
a commercial pilot.
No, sir, a Navy pilot.
Okay, not a aviator, not like the second seat, but the actual pilot.
So in a multi-crew plane that he flew, the S-3 Viking,
Yes, sir.
he started out as a naval flight officer out of training, and then he became a second in command, which is like the first officer in the airline world, actually at the controls. And that's how he finished his flying career in that airplane. So he flew the plane, he flew in the front of the plane, and not always in that position.
Okay. Now, being as close as you were to him, you were aware, were you not, that he was
The S3 Viking, if anyone is sitting out there and thinking, what kind of plane is that? That's a sub-hunter plane. Just for people who might be interested in military stuff.
an accomplished, among other things, martial artist?
I never saw that personally.
Were you aware of it?
I knew that he was a wrestler in high school.
Actually, he was on the judo team in high school, was he not?
Well, he was a state all-star wrestler, which is I'm very aware of, but I was not aware of the martial arts being a part of it.
So as close as you were, he never spoke to you about his accomplishments on the high school judo team
No, sir, more about the wrestling.
or his training in the military for martial arts.
He had the same training. The military doesn't train in martial arts.
Did he confide in you the training that he went through once he left the service through the private sector in conjunction with servicemen, both active and retired?
Not specifically, because we don't talk about that stuff if we're in really special programs.
Okay. Tell us about the physical condition Doug Benefield was in. He was built pretty well, was he not?
He was in terrible condition the night I met Ashley. He was in pain from his ejection from an airplane in the Navy that led to back surgery that year in 2017. He was not in good condition at that time. He became in good condition after he bought the device that I am a master trainer in, and it brought him back to health.
Yep.
He was in very good condition when he was regularly going to the CrossFit. I'm sorry, I don't mean CrossFit. Some fitness facility called Iron Tribe, which is a Christian-based workout facility. And I believe the last pictures of him on Facebook are in that gym. He was in very good shape at the end.
You saw the pictures?
Yes, sir, I've seen the pictures.
Okay. And they accurately depict the shape that he was in at the time of his demise?
Yes, sir.
Why is
Now,
he so angry?
you've told us that he was, I think the words that you used, Mr. Benefield, was starstruck with my client, Ms. Benefield.
Yes, sir, I would say that.
You're married,
Yes, sir.
happily so.
I'm very happy.
How many years?
Just over 4.
All right. Do you own a weapon, a firearm?
Objection relevance.
What is with these old guys getting married this late in life? Didn't you learn at the first marriage?
Or maybe he never got married before. I don't know.
Yeah, but being 54 years old and then have reversed vasectomy, and this guy was just married 4 years ago. I'm smelling a rat.
All overruled.
I own firearms, but I do not have a concealed carry permit like they did.
All right, and you're familiar with firearms from your time in the Navy, I trust.
Less from the Navy than after.
Okay. Have you ever fired a firearm inside your home? Intentionally?
Not intentionally or unintentionally.
Did your cousin Doug ever tell you that he admitted to firing?
Objection, Judge. This is part of what we were not going to get into.
So the objection is relevance?
The objection is relevance, and that there were certain complaints that this defendant made against the victim that were denied by Judge Moreland in a hearing, and this is one of those.
Okay. So is there a written agreement not to get into this, and that written agreement delineates everything, or
No,
is
but
this?
I thought we were not going to get into the specifics about it, other than it was shooting into the ceiling.
Well, I intend to stay within the four corners of my motion, but I think it's fair cross-examination based on what he's testified to, his intimate knowledge of Douglas Benefield.
Okay. I don't know. I don't know what the agreement was to get into or not get into. I don't know what the relevance of this is going to be. It may be relevant. It may not. But again, I don't have to unring a bell with the jury here. So for now, I'll allow it.
Thank you.
I may decide later it's completely irrelevant. I don't know.
Understood. May I?
Yes.
Have you ever fired a firearm inside your home intentionally?
No, sir.
Have you ever considered firing a firearm inside your home intentionally to intimidate your wife?
Objection,
speaking-
relevance of this question.
Hold on. Let the question finish. Let the question finish. Go ahead. But sir, hold on. There's going to be an objection.
Yes, sir.
This is ridiculous. That he want to bring in. Did you ever threaten your wife? Because that's what he did.
That's what he did. Yeah. Through
This
this
is-
guy, like, no.
Yeah.
Come on.
And again, there's no jury there. It's just the judge. The judge know that you will claim, or she will claim that he fired the gun, the pew-pew, into the ceiling to scare her. Why is she standing here? And this is a family member. I don't like this. I really don't like this.
Hi, Ariel.
Hey, Ariel.
I haven't seen you in a minute. How you doing?
She was 24.
Yeah, because they only knew each other 13 days. That's what he said.
Yeah. Yeah, I think this is absolutely. And again, there's no jury there. You don't need to play the circus. No, the jury isn't out. This is a pre-trial hearing. It's what's called a stand your ground hearing. It's the judge will hear their arguments, hear their witnesses, and then he will decide if the case can move forward. She can still use I acted in self-defense, or if it's so clearly self-defense that the case will get tossed. It's a Florida thing. Candons, don't let it happen again. No, they got back together again later. So, yeah.
Go ahead and finish your question.
To intimidate your wife into not speaking any further.
Thank you, Tammy. I was listening to Metallica earlier at the gym.
Go ahead.
And what is the relevance of whether he
I just need objection, relevance, sustained.
Did your cousin ever share that with you?
My
Objection,
cousin,
hearsay.
Overruled.
my cousin admitted both privately.
Is the answer yes?
I would like to answer your question and be very accurate, sir, like I've been all along.
I understand, however,
Say
Mr.
yes
Benefield,
first.
this is
Yes, sir.
cross-examination.
Yes, sir. He inadvertently fired a gun in his home.
No, he testified under oath that he intentionally fired.
Objection, is there a question?
Improper impeachment. Go ahead, sir.
Did
Sustained.
he ever acknowledge to you that he intentionally fired the
No,
weapon?
sir, he did not.
Did he ever
No, I haven't said Canadians today. Said I've been to the gym and listened to Metallica.
tell you that he threw a loaded gun at Miss Benefield?
Perhaps we talked about that. I don't remember that specific event like I remember the inadvertent firing.
Did he ever acknowledge to you that he punched the dog in the face so hard that it rendered the dog unconscious?
Are you
That's not what
kidding me?
happened in his story to me.
Were you there?
No, sir. You asked me if I talked to him.
Did he ever acknowledge to you that he
This
punched the dog in the
guy.
face so hard that it knocked the dog out?
He admitted hurting the dog, but that's
Why?
not a detail I remember.
Is the answer to my question no or yes?
Would you restate the question, please?
Did he ever admit to you punching the dog in the face so hard that it knocked the dog unconscious?
No, sir.
Did he ever tell
I'm
you that
mad.
he regularly carried a loaded firearm?
Of course.
All right. And
Yeah, we don't like him
clear,
now.
it was
He's
a
innocent.
firearm that was also cocked. All that was necessary was to pull the trigger.
I don't remember that detail, but I'm sure that he carried it appropriately or he wouldn't have carried it.
Okay. You don't know whether he carried it wrapped or not.
No, sir.
Did he acknowledge to you that he placed a tracker on Miss Benefield's car?
No, sir.
Did he acknowledge to you that he was caught at night by a neighbor peering into
Objection,
Miss?
Judge. Counsel is testifying just to find out if this witness has the information.
Correct.
If he
So-
wants to call a witness, fine.
Your Honor, he's testified.
Hold on.
He can't.
The way cross-examination works
Yes, sir.
is that the attorney is allowed to ask his question.
Yes, sir.
Generally, it's going to be yes or no. If you could agree with it, you agree with it, and then you agree with it in total,
Or not.
or no.
Yes, sir.
And if it's a question about, do you know, you know or you don't.
That's right.
And State, I understand what you're saying on the counsel's testifying. That's another issue. Obviously, if there was a jury here and so forth. With me, I'm not going to be influenced by the question. The witness can say, yes, that's true, or no, it's not. I know that. I don't know that. So go ahead.
Thank you, Judge. Did he admit to you and acknowledge that he was caught by a neighbor of Miss Benefield's at night, standing in the neighbor's yard, peering into Miss Benefield's window?
I don't remember that from him.
Is that something that you think you'd recall?
Yes, sir.
Is that something that you would expect of the Douglas Benefield that you knew as well as you did?
It's a possibility, not a regular habit of his.
Did he acknowledge to you, Mr. Benefield, punching
That's a weird
holes in the
answer.
drywall of their home out of anger?
I'm aware of one, not many.
And finally, did he acknowledge to you beating up his first wife, Renee, on their honeymoon?
I'm not aware of that.
Boy.
When he lived here in Bradenton, Mr. Benefield, I want to be clear about something. At no time, to your knowledge, did he live in the same residence as Miss Benefield?
I know that they were on the lease together in the final apartment, but I don't know if they ever were in the apartment together, but they were on the lease together.
Okay, so my question to you is, did he reside in a separate apartment here in Bradenton?
He had an apartment in Bradenton. Yes, sir.
Well, we don't know if it's true yet.
I don't believe I have anything further.
Yes, sir.
Well, he went from, oh, he has everything. That sounds good.
I mean, this stuff
And again-
sounds bad, and if it's true and they can prove it, it's pretty bad.
Yeah. I would say putting a dog puncher in front of the jury, and if she's anyway likable, that'll be uphill. But again,
Yeah.
this was the first witness. Half of this would probably not be allowed in front of the jury. So let's see. The dog is now living happily in Vermont.
So sad.
Ariel, I don't know anything about the lady going to trial. I don't know anything about the guy. That's why we're watching this today, so we kind of have an idea.
Yeah. I
Redirect.
don't know.
Your Honor, give me one moment.
Yes, I was going to say, if you need a moment, go ahead and do that. Hold on one second.
Yeah. I heard that too, Stacy. That's why.
Well, let's review it together today then, Carrie.
Your Honor, something for for the court to consider at a later time. If the court would take a look at 90-806 of the Florida Evidence Code regarding hearsay, it states that once hearsay has been admitted and allowed by the court, the opposing party is entitled to move into evidence any testimony of the witness referred to, the non-testifying party, that exists. So in other words, during the state's examination of Mr. Benefield, wherein hearsay statements were allowed, the defense is entitled under 806 to move into evidence the entire statements of any prior statements made by Mr. Benefield, the deceased. If the court will take a look at that rule, I'll address it later on.
Okay, so the doctrine of completeness? The doctrine of completeness?
Yeah.
For that particular statement?
It's actually separate from the doctrine of completeness, but pretty much the same thing. It basically says when hearsay is allowed, the hearsay statement in any capacity or any statement of the non-testifying witness may be admitted into evidence by the adverse side.
I guess it'll just depend on what the statement is and when it was made and the relevance and sure.
Yes, I'll address it with the court at a later.
Okay. Yes, ma'am, redirect.
Just for the record, Judge, I completely disagree that that's what 9806 says. And in my direct examination of Mr. Benefield, I was very specific to only get Ashley's comments, not Doug Benefield's comments with reference to hearsay. So just that will be my response to that. So the defense asked you about this punching a dog issue.
Yes, sir.
And,
Yes, ma'am.
and you said that's not the story I got. What was the story you got?
The story I got was that Doug was sitting on one of his chairs with an ottoman. He always wore short shorts, bare-legged sandals, just like the night he was killed. And the dog jumped up in his lap because the dog was I picked up the dog after his killing. So I'm very familiar with Sully. Big dog, big nails, jumped up in his lap. And he was frustrated and it hurt. Aggressively pushed is one way, is what he told me.
Okay.
He admitted that was more than he wanted to do to the dog, but it was due to his frustration at the time. He pushed the dog off of his lap because it was cutting into his legs.
So at no time did he say he punched a dog?
No, ma'am.
At no time did he say that the dog went unconscious?
No, ma'am.
And the defense asked you if you were
No,
aware
that's
Doug
kind of
told
a
you that he
lame
put a
story.
tracker on
So
the defendant's
something
car.
did happen.
Were you aware of that?
No, ma'am.
Okay.
Yeah.
The defense also asked if you knew about Doug punching a
Yeah,
hole in
so
the
he
wall.
punched the
I knew
dog.
about one punch.
And what was the reason for that punch?
Frustration.
You know how many times
The
I've been
defense asked
scratched?
you if
I've
Doug
never rolled
regularly
off
carried a
and punched my
firearm. Did Ashley regularly carry a firearm?
We had a beagle that was getting old, or my parents had, and I was holding my second youngest nephew, I think, at the time he was a baby. And that beagle had, it couldn't hear that well and it couldn't see that well. And I stepped back with the kid on my arm. And I hadn't seen he was laying behind me because we had been standing and talking for a while. And I stepped on him and he just bit into my calf. And yeah, I didn't kick him or punch him or anything because I knew he was probably more scared than I was.
Well, yeah.
Of course you push them down, but forcefully push them down so they might have gone unconscious.
Well, it would be different if like they were like, oh, that never happened at all. But then when he changed the story into like trying to make it a little better, it kind of makes me feel suspect on him. So, but that's fine.
Yeah, to me that's just.
It still doesn't mean that she was allowed to do what she did, but it just puts into perspective some things. Yeah,
Yeah, it seems like he might be one of those who have a short temper.
a little bit.
Yeah, and Marissa is right. It doesn't work well with a jury.
No.
Even
mean,
the first
I'm
night
already
she met him
irritated.
in front of
Yeah, but you don't like people, so that's not a surprise.
Yeah, well.
the Secret Service in the area. Yes, ma'am.
So did she have a concealed weapons permit?
I understand she does.
And did Doug have a concealed weapons?
Yes, ma'am.
No further questions.
All right. Did you have any further questions before we let this witness go?
Yes, one. Mr. Benefield, where did you obtain the explanation about what happened to Sully by your cousin?
Both from Ashley and Doug.
Your Honor, now, again, I would direct the court's attention to 806. And briefly, if I may, Your Honor, I'll read to the court why I believe it's appropriate. Attacking and supporting credibility of declarant. When a hearsay statement has been admitted in evidence, credibility of the declarant may be attacked, and if attacked, may be supported by any evidence that would be admissible for those purposes if the declarant had testified as a witness. Evidence of a statement or conduct by the declarant at any time inconsistent with the declarant's hearsay statement is admissible, regardless of whether or not the declarant has been afforded an opportunity to deny or explain. Okay, so I think any statement inconsistent with this witness's repetition of a hearsay statement by Douglas Benefield is admissible. And I would suggest that the exhibits to our stand your ground motion clearly apply to that.
I don't know which exhibits we're talking
I
about.
don't either. And Judge, I would argue that the only person that elicited hearsay was defense counsel. So defense counsel cannot elicit hearsay and then try to impeach the hearsay that he elicited. So I would object and disagree with that.
Yeah, I don't know what are we?
Judge, Your Honor may recall that during
I'll be right back. I just
examination
spilled coffee on my
Ms.
hands.
O'Donnell, Mr.
Okay.
Benefield related conversations that took place with the deceased, Douglas Benefield. And specifically, there was a hearsay objection. The court overruled it and allowed it. That opens the door to 806, Your Honor.
Right, I didn't hear argument on it. Which specific statement was it?
I believe, among other things, Mr. Benefield testified to everything relating to the ballet. I believe he testified to statements about how enamored Douglas Benefield, the deceased, was with Ashley Benefield. Those hearsay statements alone, Your Honor, open the door to 806, so that any statement by Douglas Benefield that is inconsistent with that testimony is admissible.
I don't remember any statements where, you know what, this would probably be better. So we're talking about your testimony.
It's okay.
I'm going to excuse you to the
Yes, sir.
hallway.
No worries.
The rule of sequestration has been invoked.
Yes, sir.
That's a rule here in the state of Florida, probably other places too. That says once you're called as a witness, you're summoned as a witness, you're not to discuss your testimony, the questions asked, the answers given with anyone at all until you're released from your subpoena or the hearing or the proceeding is concluded.
Yes, sir.
So that rule has been invoked. So when you're outside, you can't talk to anybody.
Yes, sir. I understand the rule and I'll follow it.
All right. Thank you, sir.
Yes, sir.
We'll call you back in as soon as we can.
Yes, sir.
All right, the witness has stepped out. On that particular point, I got some pretty decent notes and I was listening. My notes are not that he said that, just that he observed that Mr. Benefield was starstruck. I mean, nobody clarified, how do you know that? Did he say it? Was it your observations? So I don't think that's necessarily a statement. What other statement in particular? There was one I overruled. I didn't see it as being offered, the truth of the matter asserted, so I didn't see it as hearsay.
Sure.
I know there was one of those.
My objection was on the basis of hearsay.
Mhm.
The court allowed it. And I think if you will, the danger of 806 and why it can be a two-edged sword is that it does not restrict the subsequent admission to anything relevant to the hearsay statement that is allowed. It rather sets up the credibility issue. And once a hearsay statement is allowed into evidence, then any other statement that the declarant made that is not available is admissible if the credibility of the declarant is being attacked. So, for example, on cross-examination, I question the witness about these violent acts by the deceased. Some he acknowledges were told to him, some he denies were told to him. If I have an admission, even though it's in a hearsay statement, if I have an admission by the declarant, it is at that point admissible according to 806 in evidence. It doesn't make a difference that the hearsay statement, Judge White, is related to the hearsay that the court admits.
So you're saying if one hearsay statement is let in, and let me also say, somebody might object to hearsay, overruled, doesn't tell you if I overruled because I don't see it as hearsay. It was a statement, but it wasn't offered for the truth. Could be that I went through the catalog of exceptions and found as one of those. So I wouldn't read too much into overruling a hearsay objection.
Sure, and I understand.
And 806, familiar with it, and it's when a hearsay statement is put before the prior fact or into evidence, that the hearsay declarant's credibility can be attacked or supported as allowed by the rules. I don't think it kicks open the door to any possible hearsay statement the declarant ever made on any topic at all.
Respectfully, if it goes to the declarant's credibility, I would say it does. And I think that the statute and the case law will support that because again, it's not tied to the
Well, I
relevant.
didn't say credibility. I said any hearsay statement. That's what I'm hearing, is that we can bring in any hearsay statement.
To the extent it supports
Or
an attack on the credibility. Yes, sir. Yes, sir.
that I don't disagree with. A hearsay declarant's credibility can always be attacked or supported pursuant to the rules.
Right. So it's our position then that any hearsay statement that supports or attack on the credibility of the declarant is admissible. And specifically in our motion, we have several of them and we appended them as exhibits. So I think that they are now admissible by virtue of 806.
I'm still not sure exactly which ones you're talking about, but state.
And Judge, I'm confused because at the base of it, the defense elicited the hearsay, and then he's trying to bring in hearsay to impeach from the hearsay statement that he brought in. I don't understand this, but 806 says that once a hearsay statement comes in, that other evidence can come in, which would have been used had the person testified. So I think we're still bound by the rules of what can come in. Just because someone may be impeached on one statement doesn't mean every hearsay statement they've ever said comes in. That's different than credibility. So
On purpose.
to be honest, Judge,
Next
I'm a little
one is the
confused.
evil one.
I am too. And let me make sure I understand. You had mentioned something, and I didn't want to get into it too much because the witness was here. And I think this was also mentioned, Mr. Taylor, I think this was also mentioned in the defendant's motion in limine, that there were some discussions about certain evidence not being relevant, and you were going to just talk about very surface level things. But it seems like we got, instead of a scalpel, sounds like we got a shovel out. We're going to start digging some holes.
Point well taken, Your Honor. Actually, the discussion was limited to the allegations of abuse. That is to say, both Suzanne and I felt, rather than going down the rabbit hole of litigating whether or not the allegations of child abuse against the daughter were true or not, we would not go there.
So the agreement was limited only to allegations of child abuse.
Yes, sir. And truthfully, we never executed an agreement, but that was a professional discussion that we had, and I'm confident that Suzanne will acknowledge that.
All right, state.
We did have that conversation about the child abuse allegations. I do not remember specifically excluding anything before the child abuse allegations. And if there was a miscommunication, I apologize, but I had assumed that that would be a part of the let's not go down rabbit holes, because the issues that have just come up have already been litigated and have already been ruled on by another judge. So I was under the impression we were not going to get into those that happened in South Carolina.
Yeah, again, I don't know as a part of the agreement. I can say this. So there's two general ways a hearing like this can go. And I'm talking very, very broad strokes. One is how I thought we had agreed to do this was that pretty much we're going to let stuff in and object as we go. And then I'll decide the relevance or if things are relevant or not relevant. And I understand that that means a lot of things come in that might not normally come in, and those things may be relevant or not relevant. So I'm going to listen and hear a lot more testimony and see a lot more evidence than I might not normally, but it's to allow you guys to just put on your cases. The other way is we take a step back from that, and I will grant or overrule objections as we go.
It is it's a battered spouse or unaliving case. She claims she was afraid of him, and she had an exit plan. They were packing up a house, and then she put 2 bullets in him. His daughter from the first marriage don't like her.
Yeah.
She has been very vocal about it. That she was, but again, she was 24 years old. She she could have, I don't even know how old the daughter is. But something smells fishy, but again, I haven't done enough studying so I could pass the test. I just looked into it and thought, well, that's interesting. And yeah, that's why this pre-trial stand your ground hearing is kind of interesting to kind of figure out what's what in the case.
Yeah.
I think they're private, but I'm not sure. She wanted full custody of the baby. It wasn't going to happen. Sadly, a lot of times when there's a custody battle, there's also accusations about.
Yep.
Yeah.
That's why we have to figure out what's true or not, because I mean it's crazy.
Yeah, she was 15, so she was closer in age to her stepmom than her dad was to his stepmom.
Yeah.
I personally think that'll take a lot longer, but it'll also limit how much evidence is put into the record, and we can do it that way too. My rulings so far, I would think both of you would agree, have been very generous towards admissibility.
Yes, they did
Because
have
that's what I thought we agreed on. So, but if that approach is then going to be, well, Katie bar the doors, here it all comes, and we're going to spend tons of time. We're going to stop here. We're going to get off the bus. And we're going to spend a day looking around over here. Then we're going to get back on the bus. We're going to go a little way down. We're going to get off the bus. We're going to look all around here. I'm not doing this so I can have hours upon hours of testimony about somebody shooting a gun in a house, punching a dog, putting a tracker on a car, peering into a window, punching a hole in drywall, and alleged domestic violence in a prior marriage. I'm not going to hear hours and hours of testimony. So I need to know. I'll start with the state, start with the defense. Are we going to do the plan that we originally laid out, which is, hey, put your stuff in, right? And then I'll figure it out as we go. Or am I going to throttle this down and I'm going to start listening to more objections? Not that I haven't been listening, but take more of the approach of, no, we're not letting irrelevant stuff in. We're not going to have hearsay. State.
Judge,
13 days. 13 days.
would not want to continue with everything that we're doing now. I don't necessarily think that we need to completely curtail it, but I do think that some of it needs to be throttled down. If there's an objection, I think that you should rule on it appropriately.
All right, so that's a mix. All right.
So I take that to be the former position, which I agree with. I am quite comfortable. There's no jury here. I am quite comfortable with the court parsing the evidence when the time comes for the court to rule and author an appropriate order. And that was why I said I'll address it later. I wanted to make my point and move on. And I'm satisfied if we continue to go that way. I
All right.
It's going to be consistent with time savings and efficiency.
But it hasn't so far because we're spending a lot of time having this discussion now.
Yes.
So it hasn't been the time savings that I had planned. So I guess my question is, I don't know what statements you want to get in. I don't know what evidence that you want to get in that you're arguing comes in under 806, which, if I'm understanding your arguments, I don't think I read as expansively as you do. I think a hearsay declarant's credibility can be attacked or supported, if attacked, as if the hearsay declarant had testified, but that's still within the bounds of the Florida Evidence Code. I don't think it kicks open the door for every hearsay statement that has ever been made. But the second DC will tell me if I'm right or wrong. So let's call the witness back and we'll see if we're on the same page and we can go from there.
I believe we were at the end of defense cross, or I was at the end of my redirect. Were you going to, I don't know. I don't know if we need the witness back.
I will tell you this.
Agreed.
There was recross. The question was, how did you hear about Sully? And did you hear about it from Mr. Benefield or Miss Benefield? The answer was, I heard from them both.
So it's
Now,
on defense cross.
I'll just say, I don't know where this is going. I don't know how much you plan to get into defense. I've read, this is not the entire pile of what you sent me, but this plus everything else you sent, I've read it. I've read it. I understand, well, the portions of the depositions, I didn't get entire depositions. I've read it. I mean, I understand that, what he said about that, the incident with the dog. I understand what she's saying about the dog. I just don't know how far we're gonna go down that hole.
I hear you, Judge. We're finished with Mr. Benefield.
Okay, I don't want to curtail you. If you have any questions, I want you to ask your questions.
I understand. I appreciate it. We're on the same page.
All right,
I like this
All right.
judge.
so Mr. Benefield is done.
Yes.
Okay.
And he can be released.
That's my next question. After each witness, I will ask, can the witness be released from their subpoena? So, state.
Yes.
Yes, sir.
All right. So we're going to call the next witness, and can you let Mr. Benefield know that he is released from his subpoena? And who's your next witness?
I'm sorry.
Your next witness.
Oh, Stephanie Murphy.
That's a good thing about watching an year-old trial. We can just speed through all of this. Boom, 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 boom.
Yeah.
Do you solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth?
Okay, where did I put my notes? No. Hello, ma'am. My name is
Apparently, it was to
Jeff.
take care of her.
As the deputy said,
She had a
you
lot
have
of
15 inches from that
throwing up
microphone.
to.
It adjusts up, down, left, and right to wherever you need it comfortable. And if you just speak in a loud, clear voice, it should pick up everything.
Thank you.
Thank you.
Good morning.
Good morning.
Please state your name
Stephanie Murphy.
and what do you do for a living?
I'm an attorney.
What type of law do you practice?
I practice family law.
And do you work for someone or are you self-employed?
I'm self-employed. I have a firm in Sarasota.
How long have you had that firm?
I've had the firm for approximately 15 and a half years.
And were you hired at some point by Doug Benefield?
Yes.
Do you recall when you were hired by him?
I first met with Doug Benefield on March 13th, 2018. He retained me on a partial retainer the following day on the 14th of March.
Okay. And what was the purpose of him hiring you on that day?
On that day, I was retained for a limited purpose of communicating with Ms. Benefield with regard to the upcoming birth of their child.
Okay. So the defendant was pregnant at the time.
Correct.
And do you recall when her due date was?
I believe the original due date was April 8th of 2018.
Okay. And you said your initial responsibility was to communicate with her.
Yes,
So did you attempt to communicate with her?
I did. I sent her a letter via email on March 15th, 2018 at approximately 9:59 in the morning.
And without getting into all the specifics in the letter, basically what was the gist of it?
The general gist of the letter was that with knowledge of the upcoming birth of their child, Doug wanted to express his interest and desire to be part of the birth process, to be present if possible, but also wanted to communicate that if Ms. Benefield felt uncomfortable about that, he wanted to respect her space.
Runner for the record, object to hearsay.
Oh, yeah, I remember that.
Yeah.
Okay.
Is this being offered for the truth?
No, it's just basically being offered to show that this is how the communication started and that the letter was sent to Ms. Benefield.
Okay. Did you want to respond to that? I'll just say, I was not taking this as for the actual truth of this.
Yeah.
If it's intended to be for the truth of these matters, then that's a different issue.
No.
Well, I think it's obviously intended to quote unquote educate Your Honor, based upon the hearsay that this witness has to offer. So
Okay.
continuing relevancy.
Yes, sir.
Hearsay object.
Go ahead, ma'am.
Okay, thank you. Did you ever, let me back up. I don't know if you said this, but in what form did you send her this communication?
It was a letter that was saved as a PDF that was emailed.
Did you ever receive a response?
That's one of the things. I just read 2 articles about it. It seemed kind of sus. Almost immediately after she got knocked up, she went to live with her mom.
Mhm.
They had been estranged, and then she came back, I think, and she got knocked up, and then she went back to living with her mom. To me, kind of seems like kind of a gold digger move, but she wasted all his money on the ballet, so no gold to dig there.
Well, she immediately, like, she went and wanted him, she didn't want him to have any part of, like,
Yeah.
being there or anything, too. That was like a whole thing.
Yeah. we're gonna get into that later, India. No spoilers.
From her.
She never responded to me directly, no.
To your knowledge, did she ever respond to Doug?
No, not at that time.
At some time shortly after that, so the baby was born in, or when was the baby born?
Well, baby was actually born quite early. The next day after receiving my letter, she checked herself into Tampa General Hospital and then started a induction of labor process. And so the baby ended up being born about 3 weeks early, I think March 19th of 2018. I may be off a day or two.
So middle of March. the baby was
Correct.
born. To your knowledge, was Doug there?
No, he was not there. He had no idea baby was born.
Did the defendant file for an injunction shortly after?
Yes.
And what date was that?
My memory is that it may have been, excuse me, May 1st of 2018. It could have been in April. There was a bit of a lag between when she filed it and when we had knowledge of it because the injunction was actually denied, but a hearing was scheduled. So Mr. Benefield was not served.
Okay, so just to be clear, you said the injunction.
Why do you get put into labor 3 weeks early?
I've never heard of that. That's new.
I know in Switzerland they go by birth weight. So if I don't know, is it 40 weeks you normally carry a baby? But
Yeah.
to reduce the complications, if the baby is healthy and big enough, like a week before, they might induce your pregnancy there to make sure that there's not too many complications if the baby's too big. But why would you choose
Mm-hmm.
to go and have a baby 3 weeks early? That's
weird that they would. I mean, I'd like to hear why they allow that because usually the doctors wouldn't. Yeah, like you
Yeah.
said, everything looks good. Maybe shortly before, but that seems like
Yeah.
a lot.
Well, welcome, Ditch Pickle Huntress. Yeah, if she had if you, and that's why they do it in Switzerland, is to make sure you don't have complications because the baby gets too big and stuff can go wrong but that's the medical system. Someone just going in there and say, hey, can I just get going 3 weeks earlier?
Yeah, that's weird.
I get a feeling, Jamie, we're dealing with two types of people who we don't like.
Yeah, I feel like they both have pieces of this is crazy. This is a little crazy.
Yeah.
It's gonna be interesting.
Well, yeah, that could be funny if it wasn't his at all. In America, people just push out 12-pound babies or something. Well, I was probably around 12 pounds when I was born. I was, I think 5.25 kilos. So that's around that weight. That cost me a shoulder, but
God.
well, I have, as you can see, my shirt is really weird here. It's because my shoulder is messed up because of that. I was born with a broken shoulder because I was this big.
Yeah,
I think, but a
there's a
healthy
big
normal
difference when it's like twins and stuff. Yes, clearly.
yeah, a healthy normal baby that doesn't have any risk or complications. Why would any
Single
doctor
baby. Yeah.
Why would any doctor say, "Oh my God, yeah, oh, it fits your calendar today. Yeah, let's do it."
Yeah, that's weird. That'll be
Because a
interesting.
doctor has to sign off of it. It's not like she can just go in there and say, "Hey, give me the drugs and I'll take it." A doctor has to be there. They have to. Well, probably we'll hear more about it. Thank you so much, Sencat, for becoming a member. Shoulder distook. No, I just my shoulder was broken because I was so big. I didn't fit.
God.
I've told you this a million times, Jamie. Sometimes you should listen to what I'm saying.
I don't feel like we've talked about that happening.
we have talked about it more than once.
Maybe I just blocked it out.
Yeah, exactly. My mom didn't like me, and that's why she broke my shoulder. Stuff happens to big babies.
Denied. Are you saying the temporary was denied?
Correct.
Okay, so an injunction was filed, a temporary was denied, but it was set for a hearing, is that?
Yes, that is correct.
All right. Do you recall when the first hearing was set approximately?
It was shortly after we found out about the injunction. So I think we found out, meaning I found out on May 6th of 2018 that the injunction had been filed, which is how we knew that the baby had been born and what the baby's name was. And then the hearing was originally set for shortly after that. I think just a couple of days.
Okay.
Ended up getting continued anyway at Ms. Benefield's request.
Okay, so it was set pretty close in time, but it ended up getting continued.
Correct.
Before the hearing was actually held, did you end up filing something on Doug's behalf?
Yes, quite a few things.
And generally, what did you file?
Generally, it was a petition for a parenting plan unconnected with divorce and a motion for psychological evaluation. Those were the initial pleadings that we filed.
Okay. Ultimately, were these issues all to be addressed at the same hearing?
Ultimately, yes. Well, let me clarify. No, because then when the hearing ultimately took place, it wasn't the original petition for parenting plan unconnected with divorce. It was actually an emergency motion for temporary time sharing and parental responsibility. But both cases traveled together, and so pleadings or motions in both cases were heard at the same time.
Okay, so while the motions themselves may have changed, the two case numbers were heard at the same time.
Correct.
So at the time, Doug had an emergency motion for time sharing?
Yes.
And what, just briefly, what is that?
When there's a child, there's no such thing in Florida as custody anymore. Parents have time sharing with children. Ms. Benefield was withholding time sharing of their daughter from Doug. And so the appropriate way to seek time sharing was through the court versus taking matters into your own hands.
Okay.
He was also seeking parental responsibility, which is the decision making.
Okay. And when was that hearing held?
Thank you for being
It
here.
was held on 2 different days. It was
Thank
July
you,
30th
Yamaha.
and September 17th of 2018.
Actually, I got my herniated disc because I had the same degenerate curvature I inherited from my mom. So she broke my back twice.
Jesus.
Yeah, time sharing. That's something I think you have with condos.
Yeah,
that's a
yeah,
weird,
that's what I
weird
think of
place.
as a timeshare.
Yeah. But sometimes, if you're lucky, you can get to go to water parks after. If you just listen to a 2-hour boring interview about, I remember we did that once in Spain.
Free golf clubs. Yeah.
So you did have part of the hearing on July 30th, 2018?
Yes,
And did not finish, I'm assuming?
we did not finish.
What judge was it?
It was Chief Judge Diana Moreland.
And before that first hearing, was there a motion to recuse the judge?
It was a motion to disqualify Judge Moreland.
And was it granted?
No, they appealed that decision and filed a motion to stay pending appeal. That was also denied.
Okay, so the hearing continues.
Correct.
Then it continued again for the rest of the hearing in September.
Yes.
Okay. So I don't want to get into the specific facts of the allegations in the injunction, but if you could just tell us generally what were the topics, the injunction.
It was a wide range of topics. The most alarming was she had allegations that she was poisoned by heavy metals and that the baby had also been poisoned in utero. She alleged violence of a dog.
Oh, I'm sorry. I thought we were going to talk more about the poisoning. So
Okay.
Violence with a dog.
Correct.
Poisoning.
Right. Threats, and that he had discharged a gun in the home.
Okay.
It doesn't. I don't. I hope everyone is feeling better than me.
After this hearing, did Judge Moreland make a ruling?
She made a ruling at the conclusion of the second day in September. Yes.
And what was that ruling?
Her ruling was
I'm going to sustain as to her ruling on these issues. I mean, I'll hear.
And
Go ahead.
I'm sorry.
Put whatever you want on the record.
This we may need to have argument about, Judge. It is my argument, it's the state's argument, that the content and the manner in which, I have the order recorded, the judge made this ruling set the stage for the defendant's behavior later on down the road. Because she knew that this judge felt the way she did, and she had a hearing in front of this judge 3 days after she murdered the defendant. So I think it's effect on the listener, and I have some case law we can argue if you'd like, but this manner in which.
What's my timetable for this trial? Hopefully we'll start Tuesday next week.
Hopefully.
And I don't know how long it sets. Again, we don't study on this channel. That's Marissa's job.
We have no idea.
No, we'll be covering Karen Reed Monday. This is supposed to start probably. They're seating the jury Monday, so I'm hoping Tuesday is ready to go. I am looking at another case that might start tomorrow. That could be a short one, but they will have to figure out. Oh, I get Molly next week.
Molly.
Yeah.
Oh, how exciting.
This order was given is highly relevant to the defendant's, the effect on her.
All right. So you're not introducing Judge Moreland's ultimate order to influence one way or the other to prove that it was correct.
Correct,
It's the effect on the defendant.
correct. Whether it be right or wrong, the ruling, I'm introducing it for the effect on the defendant.
Yes, sir.
I don't have a problem with that. The problem that I have, which I think the court is well aware of, is the characterization of the presentation.
Right, absolutely. If it was for the purpose of, hey, judge, this other judge ruled this way, therefore, that's what we want.
Correct.
But if it's to show the effect, and yes, that one of the cases you had submitted illustrated that very point. So I get that. All right.
I want to make sure we're talking about the same thing.
Don't start now.
I don't have a problem with the state's theory that this decision prompted the subsequent action. What I strenuously object to is the statement by Judge Moreland, the characterization of the quality of the hearing. That I think should not be stated in this proceeding. I think it's irrelevant. The decision itself, I don't have a problem with. I can tell the court, well, let me just leave it right there right now.
All right. I don't know what the statement is. I'm going to have to hear it eventually, and then I just won't consider it, but it was,
Approach the bench.
yes.
This seems like a very contentious group of lawyers.
Yeah.
She's a small little thing. Oh, sorry.
Interesting. Yeah. Oh yeah, I forget they get to hear the sidebars.
Yeah. Is the beeping at your end?
I don't hear any beeping.
I don't know why sidebar with no jury.
Maybe because it's televised. I don't know.
Yeah, it could be because it's televised and they're talking about the kid case. So
Yeah, the custody.
yeah.
Because I think they've been fighting to keep that out. I don't know if it's going to come in or not. I can't remember. I think they have another pretrial hearing for all that stuff.
I know there's another. I don't know if it's part of this one, but there's one with her former shrink she lived with for a while. So I saw parts of that somewhere.
Listen to this. We got some new headphones, and as it invariably happens when you introduce new hardware into a system, we've got to get it fixed. So why don't we do this? It's kind of a good time for a mid-morning break. So why don't we take about 10-minute break? It's 10 after. We'll see everybody back at 10:20. We'll get this issue solved. Ms. Murphy, the room sequestration has been invoked. We're going to take a 10-minute break, so you'll be, I'm sure, milling about the hallway. I know you're familiar with.
Don't think that.
I love being able to like fast forward through everything.
Randy, why should she turn around? She should focus on the judge, not. Now they're back to arguing. Bum, 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 bum. I think for the first time ever, we are ahead of time schedule.
You know,
Normally, we're always 15 minutes behind.
that's true.
Was he also a rich man?
Okay, can you bring Miss Murphy, Attorney Murphy, back in? Thank you.
In an hour and a half, we have watched an hour and a half of court. That's a new record. We haven't talked enough, Jamie.
No, I mean, it's been interesting. I've been just
All
listening.
right, welcome back, ma'am.
Thank you.
Do you ready to try and discuss the case with you or anything about your testimony?
No.
All right.
So we were talking about the end of the hearing on September 17th, 2020, where Judge Moreland made a oral order.
Correct. She made an oral ruling at the conclusion of the hearing.
And was the defendant present to hear this ruling?
Yes.
She was in court then.
Yes.
All right. I'm going to show you State's Exhibit number 1. Do you recognize that?
I do. Those are my initials.
Okay. What is it?
That is the CD of the oral pronouncement at the end of the injunction and emergency time sharing hearing.
And you said these are your initials. So
Correct.
when you listened to it, did it accurately reflect your memory of what was said in that hearing?
Yes.
State would enter in evidence State's Exhibit 1.
Same objections?
Yes, sir.
Yes, sir. Overruled for the same reasons. I'm not accepting it for the truth, just the effect on the listener.
Okay. And then the state will publish it's about 10 minutes long.
I think Mr. Sessions start with that one thing, even though I find it very reticent to ever say, well, someone else investigated this, so there's no problem. But I do appreciate the fact that Mr. Sessions argues that people investigated and found that his client wasn't the perpetrator of any domestic violence, et cetera. Because I just read a report by a doctor that just indicated that he had done a full battery of psychological evaluations on Mr. Benefield in this entire case. And he had absolutely no concern of self-harm, domestic violence, or any other type of spurious activity on behalf of Mr. Benefield. Let me just go ahead and say as follows, that this court will find that as far as credibility is concerned, I would find, and I'm going to say this in the gentlest form I possibly can, that there is absolutely not a single scintilla of credibility that I'm attaching to anything that was testified to, at least in this hearing of Ms. Benefield. Court finds that it starts from basically the absurd of the conversations of what she would have had with a child searching the room, finding a shadow box, being so upset, but also at the same time the testimony where she said, well, they absolutely liked me a lot. They confided in me every conversation. I knew all these horrible things were going to happen because the girls felt good talking to me. We then move forward to the actual presentation that she's had in this courtroom since she entered into this courtroom, the turning on of tears when she thinks it's appropriate, then we move on to the entire insinuation that there is some type of poisoning going on in this particular case. There is not a single scintilla of credible evidence that Ms. Benefield has ever been poisoned or suffered from any illness of any poison. Court finds that Dr. Hilliard's testimony was suspect. I don't think that the court finds that he reviewed one record appropriately. And in comparison to Dr. Sawyer, I think his testimony, in a word, was bunk. I do find that Dr. Sawyer's testimony was quite informative and that his information concerning the answered questions that I had, how there were testing for certain metals on and then testing for certain metals that weren't there. Most important to this court was the explanation of the misinterpretation or the use of an improper range, which I think even in cross-examination, there was a misunderstanding that there is a range that these metals are in the human body, not just a single number. So that brings us to the following timeline. I have that in 10/20/2016, there's the respondent goes up there. They're at the respondent's home. Petitioner is up there. He's had back surgery. She moves back into the respondent's home permanently on December 2016. That in about January 2017 through, I'm going to say 5/8/2017, there appears to be a marriage in which there are arguments, but there is still a very committed relationship to the point where they're talking about having a reversal of vasectomy to have a child. Then on 5/8/2017, the clear evidence is that there is the vasectomy alteration or reversal, and that from that point, they begin to pursue having a child. The court will find there is one incident of alleged domestic violence, and I got to tell you, it is de minimis, even though it's huge. How it was executed, the shot into the ceiling. Court is going to find that at no time was the shot by Mr. Benefield at or in the direction of Miss Benefield. The court has seen Mr. Benefield testify, and the court finds that Mr. Benefield is taking on responsibility for that single misstep. But that is a remote type of domestic violence that has occurred. Subsequent to that, it is clear that Ms. Benefield continued to pursue a relationship and have child with this gentleman, that she had a lavish wedding, invited numerous people there, had many people that she could have confided in, saying, I'm in a hellish situation, things are out of control. Just last week, he shot a bullet in the ceiling. That's absolutely not what happens. It says she goes through with this lavish wedding. She goes on developing a ballet with her husband at that time, posing in magazines, portraying to everybody in the world that this is a very happy marriage, that we're going down, we're going to start this national ballet at a significant cost, both emotionally, physically, and financially to the parties. That she finally they finally find out that in July 2017 they have conceived a child, and that or they think that that's the date they've conceded in retroactive review, which tells this court that during that period after the shot, that they were still engaging in an intimate relationship. The court does not find credible any type of animal cruelty in this particular case, nor does the court find that the other incidences alleged of punching the wall were ever directed completely at her, nor were they meant for intimidation. Court's also going to find that at 3/2017, they do find about the pregnancy. It's confirmed. And at that time, because of illnesses due to the pregnancy, it is determined as a family, as well as because of the ballet, that they're going to move Miss Benefield to Florida from South Carolina. During all this period of time, what we have is a household that is continuing on. Miss Benefield being in the home, not making anyone alert. The medical records are devoid of any conversations between her and people that would have been providing protection, those being doctors, etc., indicating in the least that she has a type of poisoning that is appearing in her system, that she has been the victim of domestic violence, and or that this child Eva has been the victim of domestic violence. Then we go on, and suddenly we have she moves to Florida. But even in Florida, we have Irma come through. I think September 11th, that weekend. Mr. Benefield comes all the way down. He makes sure she has a generator if she needs for the storm. He then leaves, and she feels comfortable enough and well enough to go all the way back up to the home that she shared with Mr. Benefield to collect property and transport those items down to Florida for her own use, and without any fear that this gentleman's going to harm her when she's up there. Court will, one of the other things allude to as far as credibility problems were the issues concerning the split records that she's asking the Lakewood Ranch to have to, I guess, somehow cover any type of problems or contradiction there might be with the poisoning allegations, as well as the emails that were introduced today between the cousin of Mr. Benefield and Miss Benefield, I guess, trying to curry some kind of upper hand in the in either of these two cases against Mr. Benefield. Court's also going to find that the wife has at this time demonstrated a complete disregard for allowing Mr. Benefield to have any active role in the birth of his child and or the life of his child that he has now not had any contact with. Court's going to find there's been no violation of any injunction. The court did look at and has listened to the testimonies that were provided concerning the injunction that was entered.
Yeah, so far, this judge didn't find her believable.
At all,
not this
literally
judge, but,
at all.
yeah, the previous trial.
The custody case, yeah.
Yeah.
Quite frankly, it sounds like the court was, when you listen to the transcript, was actually telling both of them they need to stay away from each other. And then certainly there was no violation of it whenever there was the oral pronouncement, only be followed by a written pronouncement. Court is also finds there are some issues with the credibility of Miss Benefield when she's actively sitting here telling this court she doesn't like to have publicity, but at the same token, she's participating in articles concerning the alleged poison, etc. As far as the last comment on the poisoning, there is not one piece of evidence, like I said, that has been established that even if she was being poisoned, that there has been a suggestion of a nexus of the who, how, and where the poison. That would be rank speculation for this court to jump into the idea that because it happened, it had to be him, especially when I have, in all senses, not a credible witness is the only person that's asking me to speculate. So with that in mind, the court is going to find that at this time, there is absolutely no evidence. And I'm saying no evidence. I'm not saying by the preponderance of the evidence standard, that hasn't even been close to that there's been a indication that there's an immediate likelihood of domestic violence. There's only the one remote incident. And as of today, there's no reasonably prudent or logical person would think that you're the threat, that you're being threatened by immediate domestic violence. So for those reasons, the court is going to deny the request for an injunction in this particular case.
So after the judge's ruling on the injunction, which would be the defendant's motion, did she make a ruling on your motions?
Yes,
And that was time sharing with the child?
it was time sharing and parental responsibility.
Okay. And
What's the time sharing about a
was
kid?
the order, or what did the judge say could do?
There was
weird
a
thing.
temporary time sharing schedule that was increasing in frequency and amount. So it started with the first day that he was going to be able to meet his daughter, just a handful of days later. After a period of time of seeing her according to the schedule, then it jumped up to weekend time sharing, overnight sharing. Then there's another jump. And so he was able to take his daughter back to South Carolina for time sharing. There was also, I believe, some extended visits, maybe holiday related. But then the other main component of that order was with regard to shared parental responsibility, which again is the decision making. And Judge Moreland ordered that Ashley and Doug were to exercise shared parental responsibility so that they would have to confer and make a good faith attempt to agree on major decisions. But the court specifically ordered that Doug Benefield would have ultimate decision-making authority regarding health-related or medical issues. And the order made very clear findings about her extreme concern with regard to Ms. Benefield's medical decisions up to that point, which is why she ordered the ultimate decision-making authority.
And the concern was for the medical decisions for the child.
Correct.
So why is there an escalating frequency of visitation with the child?
Well, Doug had never even been allowed to meet his daughter. So she was, I believe, 6 months old by the time he met her. And so it's just appropriate that you don't just dump a baby with, who was that at that point, a stranger.
Okay.
So it was just to grow in a reunification, or a unification, I guess. There's nothing to reunify.
To get the child used to who she was going to.
Exactly.
So the first time sharing where there was an exchange of, and the daughter's name?
Her name is Emerson Grace Canny.
Okay. And can you spell the last name?
I believe it's Caney. I have to double check my file to be completely certain.
And where were these exchanges of custody to take place?
Well, according to the court order, they were to take place at Manatee County Sheriff's Office, and that's where the first exchange took place.
Were you present at the first
Yes,
exchange?
I was.
And did you arrive with Doug or were you separate?
We arrived separately. By the time I arrived, he was already there. We were both there earlier than the scheduled exchange time.
And was this the first time Doug was meeting his child?
Yes.
What happened during this exchange? Did the defendant ultimately show up with the child?
Yes, she did.
And just explain how that meeting went.
Okay. I had been sitting with Mr. Benefield and his truck, and when he saw Miss Benefield enter the parking lot, he moved the truck closer to the entrance to the building, and she was out.
No, I don't dismiss. I think both Jamie and I stated it seems like two really, really bad personalities.
Yeah.
Because he seems to have a lot of temper, and she also seems to not be truthful.
Yeah, definitely.
You can dislike her, and you can dislike him equally. It's I don't think you should ever, no matter how mad you get, discharge a firearm in the vicinity of people, especially in a closed room, because you can really F up people's hearing. I also don't think that you should do anything to hinder your kid having a relationship with the other parent, as long as he hasn't done anything to endanger that kid or you. And again, the judge said not a scintilla of evidence. So I don't know. I feel both of them might be kind of bad people. And as always, when we start the trial, we start with the basis of innocent until proven guilty.
Mm-hmm.
In front of the building with the child. Doug and I then approached Miss Benefield, and I hung back a bit, and Miss Benefield saw me, looked at me, and then immediately said, "Are you dating her?" She was very indignant, very upset. And then they responded to that question. Of course, I said no. And then they proceeded to have a conversation where Doug was trying to engage with Emerson, talking to her, ultimately was able to hold her. And Ms. Benefield was in very close proximity to Mr. Benefield, probably less than from me to the judge's bench, especially when she transferred the baby over to his arms. they kept talking for 5 or 10 minutes or so, and I kept waiting also there. Then Mr. Benefield turned to me and said, okay, we're going to go. Ashley's going to come. And so I pulled Doug aside. We had a communication about it. I warned him that it was not a good idea given all the allegations that she had raised up to that point. And he said that he was aware of the concerns. He agreed with me, but he wanted Emerson to be comfortable, and he thought having Ashley there, as she was insisting, would help Emerson be a little bit more comfortable. So then I watched them.
That's how I got my second child.
Strap Emerson into the car seat in the back of Doug's truck. She got in the back seat, and they left. I, of course, just left in my own vehicle.
And approximately when was this?
This was September 21st
September 21st of
of 2018,
2018.
just a handful of days after the hearing.
So from this point on, at least from your perspective as the family lawyer, was there sort of a peace between the two?
Well, there was. In fact, they had an agreement that we memorialized into a joint stipulation to expand the time sharing that Judge Moreland had ordered. So within a handful of days after seeing his daughter for the first time, Ashley and Doug had a written agreement signed by both attorneys and submitted to the court that said you get to see the child even more, exchanging the child anywhere they agreed. If there was no agreement, the exchange default would be at the Manatee County Sheriff's Office, but more frequently, not supervised by her. And that then was the norm for quite a while.
And how long did that last approximately?
About 11 months, I would say. From September of 2018 until August of 2019, they were together all the time. They were Doug's time sharing was always with Ashley present, so they were certainly behaving as a family. They were quite active on the social scene.
I was going to say, did you ever see them?
I did. They were in magazines. I think they were even in SRQ magazine at some kind of ballet gala event together.
Oh,
So
boy.
at some point, this peace did not last.
Yes, it did not last.
About when did things start to go downhill?
Unbeknownst to Doug, they were about to go downhill in August of 2019. He was scheduled to move in with Miss Benefield and her mother. So he'd kept an apartment or a little condo here in the Sarasota area, but his lease was running out. So they had agreed that he was going to move into their home.
We haven't heard anything about that yet.
They moved all of his things inside to their home, emptied the storage unit of his contents into Miss Benefield's home. And the day he was scheduled to move in, as he always said, she ghosted me. She didn't answer the phone. And so I think it was August 16th of 2019 was the day that he was supposed to move in. And then suddenly everything changed.
Okay. So
Just for the record, you want a continuing objection to hearsay and relevancy.
Yeah, we're getting pretty in depth with this whole situation.
okay, and I can move along.
Okay.
So at some point, did Ashley start filing complaints
Yes.
against Doug?
Yes. She started again. Yes.
And how many complaints were there, if you recall?
I would say a half dozen. They started, I think, in December of that year. And then they just kept on going for another 4 or 5 months. And they were complaints about the child.
Okay.
They were
So
not about her.
not about her, complaints of abuse of the child.
Correct.
Okay. And at some point, did Ashley file for another injunction?
Yes.
And were you involved in that?
Yes.
I'm sorry, as a part of that investigation concerning those complaints and that,
Well, I would say aggressively pushing a dog down and afterwards saying, oh, it was worse than I thought it would be, or I intended it to be, and doing this inside your house. I know in the other guys, it's customary to take a desk pop, but still, you don't do this inside your own house. 1, it makes a hole in the roof. 2, that thing that comes out comes down again. It probably won't come down anywhere near you, but someone else could get it in the head. So he had some issues as well.
Well, clearly, because
Hey, boy.
what context are you shooting a gun into the ceiling of your own house?
Yeah.
Obviously, you're pretty upset.
No, he violently pushed the dog off his lap. And
Yeah,
he told his cousin, we heard that before, that he did it was way more aggressive than he wanted it to be.
Mhm.
So I could see him having some temper problems, but we don't know much about this guy.
Request for an injunction. Was a psychological evaluation ordered?
It was not ordered by the family court, but there was a psychological evaluation that was put into place through CPS. And I believe it was Detective Moreland.
Okay. So at some point, a psychological evaluation of both Doug and Ashley was ordered.
Yes.
And to your knowledge, Doug participated in that.
Oh, yes.
Who was that doctor?
Dr. Brad Broder.
At some point around this time, did Doug file for divorce?
He did. In November of 2019, we filed a motion for leave to amend and then a amended petition for dissolution of marriage.
Was that your case number? Did it run along with her injunction case number as we talked about before?
Yes, they were companion cases.
Companion cases?
Yes.
Okay, thank you. When was it set for a hearing?
Again, it was a hearing that was set and then moved a couple times. So I think it was originally set for hearing in May of 2020, moved to August, and then moved to September of 2020.
And do you recall the date in September?
It was scheduled for September 30th,
Okay.
2020.
Were you ordered to mediation first?
Yes. At Ms. Benefield's request, she filed a motion for mediation. The court entered an order of referral to mediation.
Okay. And during the mediation, were you present at the mediation?
Yes, we were all present via Zoom, but not in person because it's during COVID.
Okay. But the defendant was there
Oh,
via Zoom,
yes,
and Doug was there via Zoom,
yes,
and the mediator.
yes. As well as Ms. Benefield's attorney was also present.
And who was that?
Faith Brown, at the time, she had been let go from her prior attorney.
Okay. So what did Ashley say at the mediation about their relationship?
Both of them said,
Sustained.
What did Ashley say? It's the defendant.
This is during a mediation? Is there some exception? Mediations are generally private and confidential.
I can move on. I thought it was a hearsay. You're saying something else.
No, I'm assuming, you tell me what your objection is.
Objection, it's.
Okay.
Yeah, I mean, I don't, unless you have some case law that there's an exception to the general, I'm going to say secrecy, but the privilege, the mediation privilege. I'm not aware of any case law, but you may have some that there's an exception in a criminal prosecution.
I do not, Judge. I'll move on.
Well, if she gets it in there, she gets it in there.
At some point after the mediation, did Ashley agree to drop the injunction?
oh, she'd agreed to drop the injunction before the mediation, but it wasn't just that she was going to drop it. It was a quid pro quo situation.
And what was the quid pro quo?
That he dismissed his divorce case and again, another emergency motion for time sharing for the parenting plan, and the joint motion to release the psychological evaluations conducted by Dr. Brad Broder.
Okay. And in fact, were those things all dismissed except for the psychological evaluation release?
They were not.
Okay. The hearing that was set for 9:30, what was to happen at that hearing?
There had been a lot of discussion leading up to that, and the plan was that the September 30th hearing would not be held on the injunction, because the agreement was that once the psychological evaluations were provided, then the injunction would be dismissed and the family law case would be dismissed.
Okay.
So the 30th hearing was supposed to be the joint motion for release of psychological evaluations.
Okay. And what day was Doug murdered?
So that he was murdered on Sunday, September 27th, 2020.
3 days before this hearing was scheduled.
3 days after the mediation, 3 days before the court date.
And who was the judge scheduled to be at this hearing on the 30th?
Chief Judge Diana Moreland,
So the same judge that had heard the rest.
same judge.
In all of the times that you dealt with Doug, did he ever have what I would term like an overly angry demeanor towards Ashley in your presence?
No, which is kind of a source of conflict with Doug and I, actually. He was very passive, very accepting, and always looking for excuses or reasons. Not angry, just surprising. He was also very suspicious of her, but never angry.
Okay. And did he always blame her for everything, or?
No, not at all. I think he often blamed Dr. Hildegard Staninger, who was related to the Carlson labs, who obtained involved with the poisoning allegations and the lab results. But no, not always Ashley. He was always trying to look for some explanation as to her conduct.
Thank you.
She shot him in, I believe, the back of the one leg and then one in the arm that went into his chest cavity. He survived for some time. Well, not some time, but he survived and was brought to the hospital. Was never able to speak. So they again, this is a stand your ground hearing. So she admits she did it because she was afraid of him. Is
Yeah.
her defense, and they are claiming it wasn't a self-defense. And I could see a problem with her shooting him in the back of the leg in front of a jury.
Mm-hmm.
Because again, in a it's kind of like the Courtney Clenny case, where she claims she chucked a knife at him at 10 feet distance, and still it penetrated 6 inches into his chest. No, 3 inches, I believe. But still, that's either the luckiest thing ever, or she is a master knife wielder.
Exactly.
Bye, Jamie. Hi, Jamie.
Sorry.
But at least that's and funny enough, on his tattoo of her, but that's on the front of the body, but self-defense on the back, to me, could be a good thing, not a good thing in front of a jury, unless there was a struggle. Yeah, I didn't read anything about that.
I thought it was he pushed her up against a wall or something, but
Yeah, it didn't
Yeah.
say that in the articles I read, but
so
um,
I mean
We'll-
that
we'll
was her
see.
claim at least.
yeah, but we'll learn more about it as we get along.
Yeah.
Other questions?
Thank you.
Great, Cross.
Good morning, Ms. Murphy.
Good morning, Mr. Taylor.
You practice family law,
I do.
and you've been doing it, I think you told us, approximately 15 and a half years you've had your own firm?
I've been practicing family law for approximately 21 years, but I've had my own firm for about 15 and a half years.
Okay. And in the course of your practice, have you had the opportunity to represent both petitioners and respondents in domestic violence injunction actions?
I have.
And have you represented them, Ms. Murphy, strictly in family court, or have you also continued in representation in those cases where the disputes end up in criminal court as well?
Only in family court. I do not practice criminal law.
Okay, so on those occasions you were referred out.
Yes.
It's the nature, is it not, in family court matters that the litigation is often, shall I say, spirited?
It can certainly be the case.
Okay, it's not unusual.
It's not unusual.
Would it be fair to say that the litigation can sometimes, depending upon the parties, be quite aggressive?
Never to this level in all of my 21 years, but it can be aggressive.
All right.
This was extreme.
And it can also be determined, can it not?
I'm afraid I don't understand that question.
Litigation, in general, in family court matters.
Determined meaning,
Determined meaning neither side lets up. You have two people who fundamentally develop a real dislike for one another, and they just pour their heart and souls into the litigation.
yes, unfortunately that happens.
Yeah. You know, they shoot more family lawyers than they do
You know,
criminal.
I've heard that. I think there's more violence on the family law floor than on the criminal floor.
The litigation can often be petty as well, can it not?
Sometimes.
Yeah, where you get two parties that are arguing over a pet turtle, for example.
Right. I mean, this was the opposite of petty, but
Yes.
yes, it certainly can be.
All right, and you are, of course, like all of us, an advocate.
Yes.
And in this case, you were an advocate for Doug Benefield,
Yes,
and he paid you, did he not, to be his advocate?
he did.
During the hearing that we heard, the ruling for which I think it's a safe bet that the petitioner did not prevail, but would you agree with me that Judge Moreland did recognize that your client, Mr. Benefield, had fired a gun in the home when Ms. Benefield was present?
Yes, she said that in her
Yeah.
ruling.
And she also recognized that he had apparently punched holes in the drywall.
She did say that.
And in fairness, I believe Ms. Murphy, she dismissed the firing the gun in the ceiling of the kitchen as too remote in time.
I believe that's what she said, yes.
And as to the punching of holes in the wall, I think she said it was not directed at Ms. Benefield, but just out of frustration.
I don't remember that she said that. She certainly could have.
Okay. Having just recently heard it. So in cases of domestic violence injunctions, would you say what percentage of your clients are females and males that seek domestic violence injunction protections?
Well, I can't tell you if it would be my clients. I think in the cases in which I'm involved, the majority is the female client is seeking an injunction against the male.
Okay.
That's not necessarily indicative that the female is always a victim of domestic violence, because men can also be victims of domestic violence.
Yes. Now, through your 21 years worth of experience in family court, I'm sure you've come to learn that there are some stereotypical factors that seem to be rather common with a lot of abusers. Would you agree?
I do not necessarily agree with that. No, there are different types of abusers.
All right. Would you say that it's reasonably common in those instances where you've represented females seeking domestic violence injunctions against males, that the males are often controlling?
That is sometimes the prevailing foundation for why the domestic violence occurs, but not always.
Is that a yes?
No, it's a no, not really.
It's a no, not really, as opposed to sometimes?
Sometimes.
Okay. I'll take sometimes.
Okay.
All right. Have you had experience in those instances where you've represented females seeking protection from domestic violence, that the males are sometimes jealous and very possessive?
Judge, I'm going to object to this line of questioning as irrelevant.
I think it may be. I don't know. The witness can certainly say yes or no, or agree or disagree.
That is one of the most rare reasons for the domestic violence in the cases that I've had in which I've represented the women. So jealousy is usually not a factor or a major factor.
So you've seen it?
I've seen it, yes, but not often.
That was my question. Have you experienced in representing some of these females seeking protection for domestic violence against males that they have employed a strategy, which obviously has not been successful, of appeasement over the course of time, and finally it builds to a sufficient crescendo that they end up as a client of yours?
I have seen that.
Okay. And by appeasement, we mean, do we not getting along, going along for fear that the reprisal will be greater?
Yes, that is true for both the female victim, if you want to use that word, as well as the male victim.
Mm-hmm. When you bring a petition for protection against domestic violence in the family court, are you foreclosed from returning and seeking a second petition?
Do you mean if a petition is denied, can you then file a different petition on the same allegations?
Not on the same allegations.
Okay, then, no, you're not foreclosed. You can file as many domestic violence injunctions as you like.
Correct.
No, regardless of how many times they've been denied.
Correct. So in other words, you've had a domestic violence petition denied, and then
This attorney isn't an expert in DV. This is a family law expert. Why he's asking those questions is what you should ask him, because he is using her knowledge of the of family law to try and make some scientific level of what DV looks like. She can only speak about what she sees when she's either defending a person who claims there was DV, or she is defending a person from someone who claims they did DV. She has absolutely no expertise in this. She's not there to talk about if he had done any DV. That's not, she was just representing him in a child custody case. So don't put all your anger on her, because this guy is asking questions to try and imply that every single DV case is the same and she should know that, and that there's a straight line. It has nothing to do with that. Her job was to make sure he got as much time with his daughter as possible. Are lawyers always good guys? No. Lawyers are most of the times defending a-holes. That's their job. Because when you need a lawyer, something's gone wrong. And lawyers will fight for the people who pay their check. So, of course, she wouldn't come out and say, yeah, oh, whew, he took her around the house, left, rights, all the time. But he was a good guy when he didn't hit her. Of course not. That's not her job. She is there to advocate for him having as much time as possible with his daughter. While her defense lawyer is asking her about domestic violence. Oh, shit, I can't say that either. Is what you should be asking him about, because she's not there to testify about any DV other than she was in a courtroom where the judge said, nope, that wasn't DV. So it's him trying to get answers to a question she has no knowledge about, which I find weird that the judge will let them do.
Yeah.
I don't get it.
2
This is
months
different.
later, there are additional
Yeah, the biggest a-hole attorneys are often the best.
acts occur. You are entitled to go back to family court and file another domestic violence petition.
Of course.
And in fact, have you done that on behalf of clients in the past?
I just want to clarify, I don't file petitions for injunction. So a party would file that on their own, the clerk's office. So my involvement is usually after an injunction has been filed. That is when my involvement begins.
And have you represented people who have gone to court multiple times? Or do you only go one time?
Oh, no, I could go multiple times. I just don't think that I've ever had a situation where I've represented the petitioner who has made multiple injunction petition filings. I've represented several respondents who have been themselves the victim of spurious litigation and abuse of the injunction.
Not the same way as they don't give you a strike for saying words like this, but if certain words will make sure that you don't get the advertising money that you could have gotten, because then you'll be put in you have three different types of monetization. Red, you can't make money. Yellow, you can only make money from some advertisers, and green, you can make money from all the advertisers. And these advertisers pay per 1,000 views a video gets. And sometimes we use all those stupid words like pew pew and self-deleting to try and stay out of the yellow and stay in the green. Because even though we don't grift hard on this channel, it's still nice that YouTube pays my, well, doesn't pay that well, pays my internet. But and I think they put me in yellow a lot of times because I don't run ads other than when you click on and before I end. If you watch on the rewatch, there's ads on them.
Process by repeatedly filing injunctions.
When Mr. Benefield was living here in Manatee County, he had his own apartment. Is that correct?
He wasn't not living here full time, but yes, he had an apartment at times during.
Actually, one of those days I stayed green and Valhalla went yellow. And the other day, I think it was the other way around.
This period of time.
You're not aware of any point in time where he resided with Miss Benefield in the home where the shooting took place?
My understanding is that he did not.
I don't believe I have anything further. Give me a moment, Your Honor.
No, the prosecutor asked her if the judge made a ruling, and she heard that, and she said yes. And he came up there and asked the same question: did the judge rule that? And then he kept going on about in a typical family court case. That's different than what the prosecution. And again, I could understand it if you had a jury there. You just have a judge, and the judge already said, "I have read all your petitions." Just let go of the theatrics and move on, because this judge have probably seen more DV cases than any of the people in the room, because funny enough, a lot of the violence I do as a juror as well is boyfriend or girlfriends who really like to show love with their fists.
That's all, Your Honor. Thank you.
Thank you. Redirect?
No.
Can this witness be released?
Yes.
Mr. Taylor? All right. Maybe release Mr. Thank you very much. Take away your next witness.
The state would call Amanda Conlon.
Yeah, I don't know how pre-trial hearing can be 8 hours, but it is. I hope there's a lot of breaks in it because I'm getting hungry. We're gonna get a video.
Put this down here, face the court, raise your right hand, and sworn.
Do you solemnly swear or affirm the testimony you shall give in this case to be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Hello, ma'am. As the deputy said, just make yourself comfortable. That microphone adjusts up, down, left, right, however you need it.
Jamie, I'm gonna heat up some food.
Speaking a loud, clear voice, we should hear
I'll be
everything.
done for 2 seconds.
Okay. Good morning.
Morning.
Please state your name and spell your last name for the record.
It's Amanda Conlon, CON-LON,
And how are you employed?
Sheriff's Office Crime Scene.
And how long have you been so employed?
16 years.
And can you explain generally your duties as a crime scene technician?
To document the crime scene through photos, video, sketches, collect evidence, process evidence.
And did you obtain any education that helped you with that position?
Yes.
And what was that?
I went to St. Petersburg College for crime scene.
And did you get training once you began working with the sheriff's office?
Yes, we're sent to training all the time.
And so that has continued?
Yes.
Thank you. I want to draw your attention to September 27th, 2020. Were you working that evening?
Yes.
And were you asked to respond to a scene at 11331 White Rock Terrace?
Yes.
And is that here in Manatee County?
Yes.
And do you know approximately what time you arrived there?
About 8:28 that evening.
And were law enforcement officers on scene prior to your arrival?
Yes.
And without telling me what you said, did you speak to them to kind of find out what was going on?
Yes.
After speaking to them, what, if anything, did you do first?
I went next door to the neighbor to collect a gun.
And are these single family homes?
Yes.
And where was the neighbor's home in comparison to the home at 11331?
Right next door.
And did you in fact go over there?
Yes.
Okay. And did you retrieve a firearm?
I did.
Who did you retrieve it from?
From the homeowner.
Was that a Mr. Saint or Sant?
Yes.
And did a law enforcement officer accompany you to secure the firearm or make it safe?
Yes.
Okay. And who was that?
Ackerman.
And did he in fact secure it?
He did.
Okay. And did you observe it to be loaded?
Yes.
And did you observe what type of what caliber it was and or what type of ammunition was contained in the firearm?
It was a .45 and Hornady was the brand of the bullets.
HORNADY?
Yes.
Okay. Thank you. Did you at some point enter the home at 11331?
Yes.
And was that as a part of the execution of a search warrant?
Yes.
And what's the first thing you do when you enter a crime scene?
Start taking photographs.
And do you document the entire scene first with the photographs?
Yes.
And then after you have documented the scene as it lays, what's the next thing that you do?
Then I would place down evidence markers of evidence throughout the house.
And those are the yellow tents that we often see in these photos?
Yes.
Okay. And is that the process in which you followed in this case?
Yes.
I'm going to show you what's been pre-marked as states 2 through 19. Will you review these and tell me if you recognize those items?
Yes, I recognize them.
And how do you recognize them?
They're photos that I've taken.
And with the exception of number 3, I believe that's a floor plan.
Yes.
And as far as 2 and 4 through 19, they appear to accurately depict the scene as you saw it the night you were there, September 27th, 2020.
Yes.
And then as to number 3, does it appear to accurately depict a portion of the home as you recall it from when you were there in September?
Yes.
Your Honor, at this time, the state would ask to enter states 2 through 19.
Got no objection.
Received.
Thank you, Your Honor. So let's first look at states 2, and I'm going to display them digitally before you. And can you tell me what we see here in states 2?
Let me just ask, instead of turning down the lights, Ms. Conlon, are you able to see these sufficiently?
Yes.
Okay.
It's a little difficult with the lights on for us to see it.
Oh, it is?
Yeah.
Okay, fair enough. Thank you. I didn't want anybody nodding off.
Thank you. Ms. Conlon, I'm going to give you a pointer.
And again, sir, if you need to reposition anywhere around the courtroom, wherever you need to go to see, please feel free.
Ms. Conlon, what is it that we see here in states 2?
It's a firearm.
And what firearm is that?
I believe it is the 45.
And is that it's back in your lab as opposed to when you collected it at home? Is that correct?
Correct.
And we see a magazine. It appears to have ammunition in it.
Yes.
And then the firearm, which has been locked back, and a holster. Is that correct?
Yes.
And then there's one round laying in this picture. Would that be if it had been in the chamber?
Yes.
Thank you. I'm going to show you states 3. This is the floor plan we talked about a moment ago. It's not the complete home. Is that correct?
Correct.
When you entered the home, how did you enter?
I entered through the garage, which would be right in this area.
So that the laundry room has what appears to be 2 doorways. The bottom one would be an exit to the garage.
Yeah.
So when you approached the home, you walked through the garage.
Yes.
And what observations did you make, if anything, of the driveway or the garage as you entered?
There was a U-Haul truck. There was a pod there. There was boxes. You could tell they were moving.
And when you entered the home, did the home appear to be furnished, or did it appear as somebody had already completed much of a move out?
There was still a couch in there. There was still some furniture, but the majority was being boxed up and everything.
And we see 2 bedrooms here. Were there only 2 bedrooms in this home?
No, there's a third one, and it's past the living room, kitchen.
So it would be the top of this picture.
Yeah,
correct?
it would be up there.
And how would you categorize that bedroom?
The master bedroom.
And then we have 2 bedrooms here on the left, one being a child bedroom and then one being Miss Benefield's bedroom. As far as you know, is that accurate?
Correct.
What did you enter the room called the child's bedroom?
Yes.
And what about it made you believe it was a child's bedroom?
Because it had kids' stuff in it, kids' clothing.
Did you find anything of evidentiary value in that child's bedroom?
No.
Did you enter the bedroom that we have on this floor plan marked as Miss Benefield's bedroom?
Yes.
And did you find Did you find things of evidentiary value in that bedroom?
Yes.
And did you document that bedroom in the remainder of these states?
Yeah. Yes.
Thank you. What I'm going to show you first is states 4. Oh, sorry. Can you describe what we see here in states 4?
I'm in the corner in the back, just taking overalls. There's blood on the floor, and there's a bullet hole right here.
And I think we have a close-up of that bullet hole once you marked it.
Yes.
That hallway there, is that the hallway we saw on the floor plan that adjoined that child bedroom?
Yes.
Thank you. And what is on the other side of this wall where you said I think you can actually see the bullet hole there. And then there's a socket on the wall. What's on the other side of that wall?
The bathroom.
Imagine that.
This is states 5.
crime
Is this
scene
the same
photos.
area in the bedroom?
Yes.
Yeah, we're back to a normal case.
And
It's weird to see it.
the item or the area there, that's a closet with bifold doors?
Yes.
And when you entered the room, was the mattress up against the wall like that?
Yes.
Had anything been moved or touched to your knowledge prior to you taking the pictures?
No.
Where are you standing in this is state 6. Pardon me. Where are you standing when you take this photo?
I'm in the doorway.
Where the one we saw, the bathroom would have been on your right?
Correct.
And we see tent markers here, 1 through 6. Is that correct?
Yes.
Can you tell me what was at tent markers 1 through 4?
1 through 4 are casings.
And did you collect those items?
Yes.
And do you remember the caliber of those casings?
The 45.
And were they also the Hornady?
Yes.
Okay, I think I'm saying it wrong, but
I might be saying it wrong too.
and then I see here there's a black tripod thing there in this top picture. What is that?
It's a light.
Okay, and that's something you placed or another crime scene tech placed there?
Yes.
And how about number 5? What is that tent marker number 5, which is near that tripod?
A projectile.
And then number 6, what is number 6 marking?
Blood.
For those of you who was here during the Karen Reed trial, what you see here is evidence markers. That's something real police uses. What you see on this big screen is photos of the evidence markers establishing a shot, so you can go back again to the crime scene and say, oh, I was standing in this store. This is where the evidence was. I know from the Karen Reed case, you might not understand what this is, but this is how a normal case looks. Because in the Karen Reed case, they would have taken a picture of the house on the opposite side of the road and said, yeah, it's clear she did it.
It is weird to see.
So,
Marking everything.
yeah, it's amazing to get back to a normal case. Yeah, imagine how much more easy it would have been. Yeah, this is actually police work. Yeah, I'm sorry. No, solo cops isn't actually police work. They don't use that. Yeah, and it's probably not even snowing in Florida. Probably not. Yeah, I know it's a big shock to all of you sitting there and saying, oh, so they marked where they found the evidence? Oh.
Mm-hmm. And you
Yeah.
see like thousands of pictures. They just go through nonstop.
Yeah,
Like that's
making
it's weird to see.
establishing shot, making a diagram so you can see where everything is, instead of saying it's kind of in that area. What, if anything, was maybe, I don't know, who drove the ambulance? Exactly, and it's cheaper. So you have 300,000 for a kitchen at the police station.
I'm going to show you states number
Oh, stop it.
7.
Never.
Is this the projectile you said was at state or at number 5?
Yes.
Okay. And did you collect that item?
Yes.
Now, states 8, I think you're looking back towards that wall in the hallway. Is that correct?
Yes.
And can you tell me what it is at state 7?
The hole right there.
And I'm just going to zoom in so you can. And there appears to be something below it other than your sticky number 7.
Yes.
And what is that?
It's a ruler.
Is that just for scaling?
Yes.
That's another thing. They put rulers by all the evidence instead of just kind of putting it somewhere, maybe on some of it.
Thank you.
Mm-hmm.
I'm sorry, I got ahead of myself. Did you find any other holes other than state 7? There was a, what did you call it, bullet hole?
Yes.
Yes. Did you find any other holes that corresponded with state 7?
Yes.
Okay, and so can you tell me about those?
So they would be in the bathroom in the cabinet. So I marked the one after that 8, and then 9 was the exit hitting the cabinet door, and then 10 is the actual on the other side of that cabinet.
So 8 would have been the back of the cabinet?
Correct.
The
Yes.
opposite side of 7?
Yes.
And then it traveled through the cabinet door, which you did as 9 and 10?
Correct.
And then did it ultimately land or strike somewhere and come to a stop?
Yes.
And where was that?
It's right outside the bathroom door.
So I'll show you states 9. Is this the frame of the bathroom door?
Yes.
And if you could just tell us what we see here.
It's going to be the projectile inside that hole.
And you marked that 11.
Correct.
This is states 10. What do we see here in states 10?
The trajectory rods, just to show the path of the bullet.
So those are something you placed there to make sure that was the same bullet that went through those holes at number 7 and 8, 9, and 10?
Correct.
And did you ultimately dig the projectile out of tent marker 11?
Yes.
And I believe states 11 is a close-up of that hole prior to your digging it up. Is that correct?
Yes.
And then what do we see here in states 12?
That's the bullet that I dug out at 11.
Thank you. Did you find any other holes anywhere else in the home?
Yes.
Okay. And where was that?
The living room.
And did you document that?
Yes.
I'm going to show you states 13. Can you kind of orient us in the home? Or if I can switch back to the floor plan if it would help. But.
No, that's the front door by 16. So it's like right in the living room area.
And now that wall that we're looking at, is that, I see a window, so that's an exterior wall of the home?
Yes.
And where would the bedroom be in this photo, or not in this photo, but where would the bedroom be in comparison to where this photo was taken?
Behind me.
And what is this small brown item? I believe we see it in states 14.
It was struck by the
They are seating the jury Monday, is what we hear.
bullet.
And it's some kind of canvas thing.
Yes.
So this is states 14. And then states 15, is that the bullet that traveled into the living room wall?
Yes.
And you collected it?
Yes.
I'm going to just go back to states 3. If you could kind of show us on this diagram where that bullet strike was.
It would have been right here.
So that's the door we saw and the window we saw in the
Right.
corner of.
Yes.
Thank you. Did you find and collect any other firearms in this home?
Yes.
And how many?
2 others.
And where were they located?
One was in the bedroom with the blood, in the closet, in a backpack.
And so I'm showing you state 16. Is this the closet you're talking about?
Yes.
And where's the backpack?
Right there.
And then I believe state 17, is that the firearm in the backpack?
Yes.
Thank you. You said you found 2?
And then one was in the kitchen pantry.
And I'm showing you states 18. Is this a portion of that kitchen pantry?
Yes.
And where was the firearm?
It was below that picture.
Thank you, Cindy Lou, for becoming
Yes.
a member again.
And so we see a basket here, and then this is another
That's
basket.
when, yeah, that's when, yeah.
And so states 19, that's a firearm.
Correct.
Okay, and you collected both of them.
Yes.
Were they both loaded?
Yes.
Did you locate any cell phones in this home?
Yes.
And did you collect them?
Yes.
I'm going to show you what's been marked as states 20 and through 22. Judge, these are entered by stipulation number 2. But are these photos you've seen before?
Yes.
And is it your understanding that they were taken by first responders when the victim was still on scene?
Yes.
And I didn't ask you, but when you arrived, had the victim already been taken away by EMS, to your understanding?
Yes.
Okay. Were you ever given any information by law enforcement to help you in your investigation about why there was a drag mark?
Yes.
And what was the information that you were given?
That's they had pulled him out to start working on him.
And
T-Rex, we will probably get 25 to 30 weathermen talking about the weather, because yes, the weather is always important. We know that's the only important thing. So when the trial starts Monday, they expect 3 to 4 weeks of talking about how sunny it was that day in Florida. Yeah, we need the inverted photos.
is it your understanding these pictures were taken in the bedroom prior to that?
Correct.
Your Honor, the state, they were entered by stipulation, the state would ask to publish.
All right.
20 through 22.
Ma'am, can I please have
Oh,
20 to
I'm
22?
sorry.
I have them here if you want on the screen or not, either which way.
I can look at them here.
Okay, thank you.
Okay.
On the night of the incident, did you have any involvement with the defendant, Ms. Benefield?
Not that night, no.
And was it your understanding that another crime scene tech took photos to document her appearance on that night?
Yes.
And who was that?
It was Megan.
And Your Honor, I believe these are entered by stipulation number 4, but Ms. Conlon, would you take a look at states 23 through 26 and tell me if those are the photos you understand? It's Megan Dvorak, is that
Correct. Yes.
she took those?
Yes. These are Megan's pictures.
And Your Honor, the state would ask to publish them. Would you like me to do it on the screen or would you like to just look at them?
You can just reach your camera. Just to confirm, there you are. 20 to 22 and 23 to 26 are stepped in.
Yes.
All right, they'll be received.
Thank you, Your Honor. And Ms. Conlon, later, were you asked to document Ms. Benefield's appearance again?
Yes.
And do you recall what date that was?
It was the 1st.
Of October?
Yes.
And where did you go to do that?
At the sheriff's office.
And did you in fact take photos of her.
I did.
I'm going to show you states 27, 28, and 29.
Yes.
And are those the photos you took of her on October 1st, 2020?
Yes.
And do they appear to fairly and accurately depict her appearance that night?
Yes.
Your Honor, the state would ask to enter 27 through 29.
Any objection?
None, Your Honor.
Received?
And while you were there, did you observe any injuries to her body?
Some scratches, light bruising.
And this is 27, is that taken October 1st?
Yes.
And then this is 28, are those the scratches you were talking about?
Yes.
And 29?
Yes.
Show us the pictures.
Did Ms. Benefield complain of any injuries to you that night?
She never spoke.
Thank you. I don't have anything further, Judge. The defense may.
And Judge, I just want to correct something before the defense does cross. The picture that came in as State Exhibit number 2, it was my fault. I switched the pictures on accident. That firearm is the one that was found in the backpack in the closet, not the one that was found in the neighbor's house. But all the testimony about the neighbor's house.
I think this case will be dismissed just because they did such a poor job. They put evidence markers down. It looks like they have a chain of custody. They took photos of everything. I think it's going to be dismissed because that's not how police works. I know that. But some scratches and some bruisings on her, so that could indicate a scuffle.
And the gun being at the neighbor's house is accurate. It's just the picture is a different gun.
Okay. And are you going to need the pictures? Or do you want the lights back up?
I think for right now, we could have the lights back up, Your Honor.
Absolutely.
I may request that they go down.
Just let us know.
Do you want the hard copies?
No, Jack. Deputy Colon,
I'm not a deputy. Just as a crime scene tech.
crime scene tech. How shall I address you? Miss Colon?
Yeah, that's fine.
I have a few questions for you. No heavy lifting. I first want to ask you about crime scene. Your purpose as a crime scene technician is to arrive and document as accurately as possible the circumstances that you find.
Yes.
And traditionally, ideally at least, you should be the first one that enters the crime scene, if you will, so that what you document is an accurate depiction of how it existed at the moment.
Correct.
All right. In this instance, that wasn't particularly possible, correct?
Correct.
All right. And in fact, before you arrived, Douglas Benefield, who subsequently was deceased, he was moved in an effort to be worked on by not only the deputies on the scene when they first arrived, but by the EMS people as well.
Yes.
All right. So in your documentation of this scene, anything that might depict certain things could have been modified based upon prior efforts inside the crime scene.
Correct.
Now, you told us approximately, I realize going from memory is difficult. Did you write supplementary reports?
I did.
Okay. Do you have them with you today?
I do.
Good. Can you tell us approximately, feel free to refer to your notes if necessary. Can you tell us approximately what time you arrived on the scene?
Approximately, it was 8:28
8:28
in the evening.
in the evening, PM.
PM. Yes.
And your reports, Ms. Colon, would they document what time the incident was reported or alleged to have occurred?
Not in my report, but I had the notification time that I was called, which
Yeah.
was going to be 1937, which is 7:37 PM.
7:37.
Correct.
Okay. And would it be fair to say that notification to crime scene goes out pretty much immediately?
Correct.
All right. Because once again, you want to be first on the scene to be able to preserve it.
Correct.
Okay. So in this case, assuming that the incident occurred sometime close to 7:37, you arrived approximately an hour later.
Correct.
All right. You said something in your direct testimony that was interesting. you had entered the residence pursuant to a search warrant.
I have to wait for the search warrant. The residence I entered was the next door neighbor's residence
Yes.
to collect the gun. But
Yes, but for purposes of the incident where the shooting took place, you entered after being notified that the search warrant had been secured.
correct.
Okay. So this is what I want to establish. If you got notified of this incident at 7:37 and you arrived and entered at approximately 8:28, approximately an hour later, somewhere in between that time, a search warrant was drawn up and provided to a judge who signed it to allow you to enter.
Correct.
That's some pretty fast work, no?
That's pretty typical for our agency.
Okay, so in other words,
They're pretty used to writing them pretty quick.
okay, so the incident happens, bing bang, you put the search warrant together and you're in.
Yes.
Okay. Now, just so we're clear and there's no confusion, and I don't mean to imply in any capacity that there was any sleight of hand involved. The actual weapon that was pictured in the slide was the gun that came out of the backpack,
Correct.
which I think is a 6 Hour,
The backpack was a 380. Yes. 6 hour, I believe.
380,
It was a 380 in the backpack,
right, not the 45.
not the 45.
Okay. And the photographs that were taken of Miss Benefield, some were taken that evening, correct?
Correct.
And then there was another opportunity to take a second set of photographs a couple of days later on October 1st.
Correct.
And why would there have been a second set of photographs taken on October 1st?
To see if any more bruising would come up, better pictures.
Yeah, in other words, a lot of times bruises are not readily apparent immediately and they develop over the course of a day, 2, 3 days.
Correct.
Okay. Now, give me just a moment, please.
Yeah. Where's the lead investigator? We need a lead investigator to tell us if there was any news on the phone.
Yeah.
2 phones was found. There must be news.
Okay. All right, Ms. Colon, I want to ask you a few questions with the help of my very able-bodied assistant, Mr. O'Keefe. And we're going to put a few of those photographs up.
Paul O'Keefe? Oh, I didn't know he had a job in Florida.
I want to ask you some questions about him.
If you're going to refer to any that are already in evidence, I prefer we use the ones that are already marked. If there's additional ones, then obviously you can lay the predicate or get a stipulation for admissibility.
Applause. No, we don't need applause. Boom, 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 boom. And thank you, whoever it was that said I could just hold down the left mouse button and it'll go to 2 times speed. I didn't know that. That was really nice instead of clicking everywhere. Boom, 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 boom. I hate those
They're looking
thermos.
for 23 through 26. Those are here. These are photos of Miss Benefield. And my notes reflect that 23 through 26 are photos from the night of the incident.
Yes. Thank you.
When you get up here, Elizabeth, to the rest of us, yes, it's so nice that we have a real police investigation. Yeah, Secret Squirrel. His able-bodied helper was named O'Keefe.
Good. All right, Ms. Condon, let me direct your attention to the exhibit that is now up on the Elmo. I want to ask you, with respect to Ms. Benefield's left side of the face, specifically the left eyelid, does that appear to be the same size as the eyelid on the right, or does it appear to be swollen?
Objection.
Yeah, I'm going to sustain. I mean, I can see that for myself. I don't need the witness to narrate what the evidence is, unless there's something specific that you want to draw out about it, but
No, that's fine. The only other question I was going to ask was about the left cheek, Your Honor.
okay. But I also think that she didn't take these.
I understand.
Okay, go ahead. So I'm going to sustain.
Okay. With respect, Ms. Cologne, to Ms. Benefield's left cheek, do you see that as swollen as compared to the right?
Yeah, I don't know if it's the lighting, but this seems very. This seems almost purple, but I think it's the lighting that's really, really bad. Because it also seemed like she doesn't have a tip of her nose. But it's really hard to see. I know Jess is working on all the paperwork that will be on Discord later, so you can all go snoop in it. I don't know if the photos are in there.
Right cheek.
Sustained.
All right. Next. This was a photograph that was taken when?
That was the first night.
Okay. And this was taken by you?
No, that was taken by Megan.
By Megan. Are you familiar with this photograph?
I am.
All right. Does this photograph, it's hard to depict in this exhibit under the Elmo. Does it show whether or not the scratch?
Objection, Judge.
Yeah.
Well, I understand, but let him finish the question. I don't know where he's going. It's not uncommon for lawyers to start this way and make a, not wrong turn, but left turn.
I'll
Go ahead.
withdraw the question.
No, ask your question, please, but I don't know where it was going.
I understand, but I also know what the ruling is, so.
If it's
yeah.
just to narrate
Out of
what's,
concern for the court's time.
yeah, I
understand.
mean, and then you can argue that, certainly,
I'll be able to argue it. too.
absolutely,
Yeah.
100%.
Okay, thank you.
Redirect?
Yes, briefly. Ms. Conlon, in your many years at the Sheriff's Office, you've responded to homicide scenes regularly.
Yes.
And is it your understanding from your experience that a lot happens prior to your actually getting called out?
Yes.
And so if you get a call out at 7:37, you can't say how long law enforcement had been on scene prior to your getting there, can you?
No.
Because in theory, patrol arrives first.
Correct.
And at some point, there's a determination that there's a homicide before the homicide unit gets called out.
Correct.
And are you next in line after the homicide unit?
Yes. Yes.
And you're not the person writing the search warrant. You just wait before you enter.
Correct.
Thank you. Nothing else, Judge.
Sir?
Nothing further.
All right, can this witness be released, state?
Yes.
Mr. Taylor? All right, need to release your subpoena. Thank you very much.
I don't know if, Fred, I didn't look ahead, so I don't know what they're going to bring in. I like to watch it.
Oh,
fresh
hold on then. All right,
quality.
ma'am, apparently you're still under subpoena. All right, so remain available. Thank you. Good.
That same call, Dr. Vega.
Oh,
I don't know
let me
if
check
it was
real quick.
near
Hey, Sarah,
the entrance
How are
door.
you doing?
I'm doing fine, thank you.
All right, if you need a break, you let me know.
Appreciate it. And Judge, it's my time to shows up on the screen and spoken to the family and they agree with that. Because I don't think you can, the witness needs to point out things. Why do you think?
I can see right here. I'm not going to get the way you present in your case, but I'm fine if you want to put them on the overhead, and I'm fine if the witness is sitting right here and Mr. Taylor could approach as well and see exactly where things are being pointed to without putting up the photos. Either way.
Just to remind Your Honor, we have the Daubert motion pending as to this witness.
Correct.
Do you solemnly swear or affirm the testimony you're about to give in this case to
Yeah,
be the
if
truth?
the
whole
gremlins
truth,
get
and
into
nothing
the
but
food.
truth?
Yes, I do. Well, Dr. Vega sitting down, the way I read the motion was specific to one particular injury.
Correct.
So let's do this. When we get to that,
Fedorowski, you get your doctor now. So it's a real trial.
point, and please feel free to disagree if you want. I think when we get to that point object, so it's preserved, you have your contemporaneous, let the testimony finish, then you can cross on that, and then whether if I let it in, it's all there. And if I agree with you that the foundation hasn't been laid, or it's otherwise not admissible, then it's still proffered and it's in the record. Would that be okay?
Yes, sir.
Okay. Well, sir, make yourself comfortable in the chair, 12 to 15 inches from the microphone. Loud, clear voice will pick up everything, and it does adjust up, down, left, right. Thank you.
Thank you, Your Honor.
Good morning.
Good morning.
Please state your name
My name is Russell Scott Vega. The last name is spelled Vega.
and where do you work?
I'm the Chief Medical Examiner for the 12th District of Florida, and that includes Manatee County, where we are now.
And what is the 12th Circuit?
It includes 3 counties, Manatee, as well as Sarasota to our south and DeSoto County to our east.
And you said Chief Medical Examiner. So what does that mean?
That means in the medical examiner's office, I supervise the other medical examiners. I set policy. I basically manage the office.
You're the boss.
Yeah.
Okay. And what is your education to do the job that you have?
I started in undergraduate, majoring in physics and biochemistry at Florida State University. Then I went to medical school after that, University of South Florida in Tampa. After medical school, I did 2 years of training in general surgery and then 4 years of training in anatomic and clinical pathology, and then a year of subspecialty training in forensic pathology.
Hold on one second, I'm sorry.
Out of respect for the court's time and to Dr. Vega, whose credentials I'm familiar with, we're happy to recognize him as an
All right. Do we willing to stipulate or accept that stipulation?
Yes, I do have a few more questions about specific things that he's done, though.
Okay.
Okay.
No, just stipulate to it. There's no jury. You don't need to talk about, oh, I did 1,000, blah, blah, blah. Just get on with it. Everyone knows what a medical examiner is. Every trial should have that. Stipulate that he knows his job. Let's move on.
And how long have you been the Chief Medical Examiner, if I didn't ask you already?
It will be 20 years, October 1st.
Okay. As part of your duties as a Chief Medical Examiner, do you still perform autopsies and do the work that your other medical examiners would do?
Yes.
Okay. How often would you say you perform autopsies?
I'm on the schedule every month, so
This is absolutely redundant. It doesn't bring anything into the case because the judge knows what an ME is. He knows this guy. He knows he works with dead bodies. He has seen more dead bodies than I have, and I have watched a lot of Stallone movies. Just get on with it. I hate it. It's the same with Lally. How many kids do you have? I have 2. They are 8 and 10. Oh, you answered my question. How old are they? They are 8 and 10. So your kids are 8 and 10 years old. Get moving.
not necessarily on a weekly basis, but certainly on a monthly basis.
Okay. And over your career, how many autopsies would you say you've done approximately?
Yeah, I don't have an exact count, but probably in the 3,500 to 4,000 range.
Okay. How many of those approximately would you say are gunshot wounds or contain some aspect of a gunshot wound?
It's in the hundreds.
I don't know if she's again like Lally, she can't think on her feet and change it. They stipulated he is qualified. You don't have to do his CV. It's Rocky, of course he didn't. He just he went to Vermont with Chloe.
But I wouldn't be able to tell you more than that.
Well, we
Is
all
wound interpretation
it's because a bad prosecutor we all know is Lally.
part of your duties as a medical examiner?
Yes.
Okay. And what exactly is wound interpretation other than exactly what it sounds like?
It's being able to examine a body and identify injuries present on or in that body and be able to, in that identification, determine what the nature of the injury is, possibly what kind of implement, tool, or weapon was associated with inflicting that injury, and other things about the nature of the injury, such as when it occurred, or things associated with the circumstances under which the injury was sustained.
Okay. Did you do the autopsy of Doug Benefield?
Yes, I did.
And when was that?
That autopsy was on September 28th of 2020.
Okay. And generally on Mr. Benefield, how many wounds did you find?
I found 2 clear gunshot wounds, one possible gunshot wound, and then 2 other separate smaller injuries, one to the head and one to the back of the thigh.
Okay. Were pictures taken during this autopsy?
Yes.
Okay. I'm going to show you States Exhibit 30 through 38. You can just take a look at these. Why it's not coming on? Oh, because I think it's set back.
Come on. How can you stand rewatching those testimonies? They are so bad.
Do you recognize those?
I do.
And what are they?
These are photographs that were taken at the time of the autopsy of Mr. Benefield.
And do they accurately reflect the autopsy as you recall, parts of the autopsy as you recall?
Yes.
Statement entered into evidence, States 30 through 38.
Objection?
No.
Received? Are you going to publish them now?
Yeah.
Folks, the state is about to publish photographs that were taken during an autopsy. I would imagine that most people here probably have never attended an autopsy or seen photographs from an autopsy. I didn't see them, but I don't think they're the full autopsy.
No.
I would assume they're external
Yes.
photographs.
Yes.
However, for those of you who may have an emotional connection with this case, sometimes these can be very difficult to look at. So if you think that you might have some difficulties, I'm not worried. Sometimes I'm worried about a jury and an emotional response. I'm not worried about that. But just to avoid any distractions, if anybody thinks that they might have a reaction, please feel free to step out for a few minutes and then you can step right back in. All right, go ahead.
Thank you. I'm going to show you States Exhibit 30 just for, so we understand who we're talking about. Is this the patient, Doug Benefield?
Yes, this is a photograph of the decedent,
The decedent.
Mr. Benefield, from the essentially mid-chest up.
Okay. And I'm going to show you the next exhibit, States 31. Can you tell me what we're looking at here?
Yes, so this is the decedent's right arm and the right side of his chest. And this shows 2 injuries, really one superficial injury to the right arm. And I can use the laser pointer if you like. Okay.
That's not that bad. I'm not going to pull that down.
Subject of the motion.
Understand, I'm going to reserve on the objection. And once I hear it, then I'll make a final ruling. But yes, noted.
So we see 2 injuries here, one on the chest here and one on the right arm. The chest really is a more complex injury. There are really 3 components here. There is what was circular gunshot perforation here. There is an incision that was made by doctors who were treating him in life-saving measures that was made from the edge of the gunshot wound downward here. That was to insert a chest tube or tube to relieve pressure and blood from the chest cavity.
And I didn't ask you this, but sometimes people are pronounced deceased at a scene, and sometimes that happens at the hospital after medical intervention. And I think you've answered this, but which type was this?
This was the second type.
Okay.
Yeah,
So he had signs of medical intervention.
he did indeed.
And are you trained to identify that as opposed to an injury?
Yes, I am.
Okay. You can go ahead. So the top of that chest wound would be the bullet, more of the bullet entry wound.
That's right.
Okay.
That's right.
And then go ahead.
In addition to that, there's also there is some bruising that's evident in the skin around that hole. And then separate from that is the arm wound here.
Okay. So let's talk specifically about the chest wound first.
Yes.
So this wound, I don't know if you said it first or if I said it first, was an entrance wound. How do you determine the difference between an entrance wound and an exit wound of a firearm?
Well, there are characteristics of the hole in the skin itself that can be helpful in that regard. But the easiest way to be able to tell the difference between an entrance and an exit is if you have one hole and the projectile still in the body and you have a track between those 2 points.
Okay.
That's what we have here. So
Okay.
that helped me be very confident that this was an entrance wound.
That's the entrance wound.
If
Okay,
you have 2
so-
holes and no projectile, usually it's pretty clear, but it can be a little bit harder.
Okay. But in this case with the chest wound, was not difficult.
That's correct.
Okay. So this is States Exhibit 32. It's a closer up image of the chest wound. Can you just point out where the bullet injury would be.
Yes, that's right here.
Okay. And then State's Exhibit 33 is the back of Mr. Benefield, and there's a lot of discoloring at the top of the shoulders and the lower back. What is that?
Yes, so you're correct. This is his back, and for clarification, this is the neck and the back of the head, the left ear.
We can't see
And
the
there's
laser
this
pointer.
pink purple discoloration here, but especially up here on let's just say the shoulder regions. That's lividity. Lividity is the pooling of blood that occurs in the body after death. That part of what we see is not injury or in any way related to what happened to him prior to his death. It's
Okay.
simply essentially what we would call an artifact or a postmortem finding.
Okay, so this is the darkness that we're seeing here is just sort of a natural process.
This here
Mhm.
and this here.
Okay.
That's correct.
And what about this picture is not a natural process?
Within this area that's not discolored, and the reason for that is that there was pressure on the skin here that prevented the blood from pooling after death. So that's why it's more pale. But in the at least contained within that zone is this smaller, darker purple area. And that is not lividity or a postmortem finding. That's associated with injury.
Okay. Did you inspect that area to find out what it was?
Yes.
Okay, and what was it?
I could palpate, I could feel a lump under that area of the back. And upon further examination by cutting the skin and examining underneath, there was a projectile there.
Okay, so I'm going to show you States 34. What are we looking at here?
This is a photograph that was taken after I had done the incision and essentially uncovered the projectile that was in the subcutaneous tissue, the tissue under the skin.
Okay.
And that's the projectile right there.
And during the autopsy, were you able to connect the path of the initial hole to this projectile?
Yes.
Okay. And if you could just explain what it went from which side to which side?
So referring back to the photograph, if you will, we don't have to show it, but it was on the left side of the back. And the entrance wound that we saw was on the right side of the chest.
Okay.
So the path that the bullet took was across his chest from right to left.
Okay.
It was also somewhat from front to back. In considering a standing position, it was horizontal, roughly, meaning that the entrance wound was at the same height above the ground, if you were standing, that the bullet was found. So there was no significant upward or downward trajectory through the body.
Okay. So on that plane, it was fairly horizontal. It didn't go up or down much.
Yes.
Okay. So I just want to, I can either do it on myself or you can do it on me. So, or I can do it on me. Point to where the entrance wound would be on you.
So on me, the entrance wound is basically where I'm pointing now.
And then the exit wound or where the projectile landed would be where?
Back here. I probably can't point quite as accurately on myself there, but
Okay. So there was a definite right to left
definitely
motion of this projectile.
a right to left trajectory
Okay.
through his body.
So the next photo I want to show you is States Exhibit 35. This is a different wound. This is the arm wound.
I'm
Can
sorry,
you
this is-
tell?
This is the arm?
Yes, this is the arm.
Yes, sir.
All right, reserved.
And what can you tell me about what we're looking at here on the arm?
So the arm wound is a superficial wound. It's essentially a scrape of the skin. So the surrounding skin is normal, right? And in this area, the superficial part of the skin, what we might call the epidermis, and maybe a little bit of the skin underneath that, of the dermis underneath that, has been scraped away, and it leaves this red, irregularly shaped wound here.
Okay. And you said relatively superficial. So what does that mean?
That means that outside of the skin being scraped away, there's no deeper injury, there's no additional damage, there's no underlying injury to the bone or the soft tissues, there's no bruising. It's just this scraping of the skin, and that's it.
And being that it's superficial, does that limit your ability to determine where it came from or what it's from?
In this case, I would answer that yes. In general, sometimes the pattern or the nature of the appearance on the skin can give you a very clear idea of how that injury occurred. But in this case, it's a relatively irregular and what I would say not characteristic of any particular mechanism of injury.
Okay. If you had to make an educated decision about what you think this is, what is your opinion about that?
I think more likely than not, it is
I understand. I'm sorry, just, we have to get objections on the record. I'm
Sorry. Go ahead.
certainly
Reserved.
more likely than not, it is a what I would call a grazing gunshot wound. Grazing gunshot wounds are wounds that just barely scrape across the skin in their path rather than going into the body. And so they leave a scrape pattern on the skin where they do that. Grazing gunshot wounds sometimes, frequently, have a much more characteristic appearance. And this one did not really have those characteristics. But given that we have 2 clear gunshot wounds in the body, and this additional injury could be, by its appearance, a grazing gunshot wound, I think it more likely than not that it is.
Okay. And you said it's not typical of a graze wound. What do you mean by that?
A typical grazing gunshot wound looks like a furrow or a trough across the skin. It's long, narrow, and typically it has characteristic shapes at either long end and has skin tag tears along the long edges, if you will. And this really didn't have any of those characteristics.
Okay. So that made it difficult to determine exactly what it was.
Yes.
Okay. Then I want to move to the leg wound. This is State's Exhibit 36. If you could orient us, what are we looking at here?
So this photograph is taken with the leg turned, and you're looking at the back surface of the leg. And when I say leg, I'm referring to the calf. So the part of the lower extremity, which is below the knee. So this is essentially where the knee is here.
Facing away from the camera is where the knee would be.
Correct. And behind the gloved hand. So this is the back of the calf, and the body here is turned over. So it makes the orientation a little bit more, I'm sorry, the leg is turned over, so it makes the orientation a little bit harder to see.
Okay.
But this is the back of the right leg, and the injury itself is, the hole here that's between the 2 parts of the ruler.
I'm going to zoom in on this. So if you could tell us, can you tell, first of all, is this a gunshot wound?
Yes.
And is this an entrance wound or an exit wound?
This is an entrance wound.
And how you tell it's an entrance wound?
An entrance wound typically has a round or oval shape based on whether or not the projectile is going into the skin from a perpendicular, straight-on orientation or at somewhat of an angle. The angle creates the oval shape typically, and this is an oval shape here. It has some scraping or abrasion at the edges of the wound here, and those characteristics are typical for an entrance wound.
Okay. So you mentioned oval shape is indicative of a projectile coming at an angle?
Yes.
So that would be as opposed to maybe from side to side of the calf, it is at some sort of an angle.
Well, it could be side to side as a comparison, but the main thing is to think of it as not being at a perpendicular angle to the skin. So that angle, you could have an oval which is horizontally oriented because the angle is like that to the skin.
Yes.
Or you could have an oval which is vertically oriented, like this one is, because the angle is
Spacey.
Up and down, related to the skin.
So with reference to this entrance wound, assuming someone were standing, so that would be the normal anatomical positioning?
Yes.
Okay.
Yes.
So the angle of this entrance wound would be coming from which direction? Coming from where?
From below the level of where the hole is. So it would be coming from essentially the floor.
Okay. So if someone were standing and someone were laying on the floor, they could shoot up and maybe get this angle.
Yes.
We're not saying that's what happened. It could happen.
Yes.
Okay. So I'm going to show you the next, which is State's, I have to close it. State's Exhibit 37. What are we looking at there?
So this is the right leg seen from a different perspective. We were looking before at the right leg twisted from the left side of the body. Now we're looking at the right leg untwisted from the right side of the body.
Okay. So when you say twisted, as we're looking at that leg now, when you took the picture before, twisted this way, you mean?
Yes. And
okay.
Let me.
You can show.
It was rotated like this.
Perfect.
So that you could see the back of the leg.
Thank you. So now the leg is flipped back, and what are we looking at here?
So this is the right knee here. This is the right leg, right foot, and this is the exit hole for the gunshot that started with the entrance that we just saw previously. And that's just below, but basically on the side of the right knee.
And I have one more picture, a little closer up of this. So let me back up a minute. Where would the entrance wound approximately be on this picture?
So the entrance wound is back here at more or less this level, where we can't see it because it's on the underside of the leg. And even if this rail were not here and you could see the entire leg, you probably wouldn't see it because it's on the back of the leg, not the.
What?
Does this make sense?
I love his hair though, by the way. Sorry. I need to comment on that.
But he has an injury to his arm, which could be this, and then he has an entry wound in the chest area that goes in a downward trajectory to his lower back.
Yeah.
But then he has an entry wound on the left side of the calf going upwards to exit on the right side of the knee, coming from a downward from an upward angle.
Is he like running away?
How he said it came from a plane below. So how the pew must have been somewhere over here.
Yeah, that's weird.
Because this would make sense. She was standing next to him. It would be this side on me. So she would have had to have been somewhere close by in front. And then in a downward trajectory. But then does it make sense if he falls over? No.
I don't think so.
No, because if she's down, this is a foot. So if his leg was like this, it could look like that. But it doesn't make sense if he was standing when he was shot in the leg with the upward trajectory. Unless she's lying on the floor and going gangster.
Would it make sense if he might have been lying on the floor?
Yeah, that's what I'm saying with
Yeah.
if his leg was bent, so he's like this. And she clips him in the leg. I can't visualize how. Hopefully they will give us some pictures that make sense, because to me that doesn't really make sense.
No.
Yeah, how do you get that down? I don't. Yeah, kind of, but not. It looks like it came in through the top of the calf and then out right next to the knee. So, no, he's a fighter pilot. Well, not a fighter pilot, but he's a pilot, so he's probably not that tall. But still, in my opinion, it would make more sense if he was on the ground with his leg elevated to. I can't really get that to make sense. Maybe, yeah. Shot in wall also were inches. Yeah, to me that, yeah.
I mean, that makes a big difference.
Yeah, because if he was on the ground. Yeah, I don't.
It's a weird one.
Yeah. Oh, yeah. Carrie B got it. It just did. I forgot. It just did. That's why.
I just-
Yeah, he could be standing over her, but that how did you get the chest wound? It's two opposite angles that he's hit in. Because the leg is an upward angle and the chest is an downward. That's the thing I don't. That's why I don't get.
And it's through the arm into the chest. So
Well,
it's on the
he
side.
didn't say that. He just said a grazing wound. It could be.
Oh.
But he said it. He thought it was a grazing gunshot because there was also the holes in the chest. I don't know. Maybe they have a model so we can understand it.
Side.
Okay. And then the last picture that's a little closer up, I just want to ask you, how can you tell that's an exit wound?
As opposed to the previous entrance wound that we saw, which was an oval hole, this looks more like a tear in the skin, and that is characteristic of exit wounds. This tear is irregular and V-shaped. Exit wounds tend to have non-predictable, irregularly shaped tears in the skin, and this is pretty common appearance for an exit wound. And as I described previously when we were talking about the chest wound, being able to pair two holes together, the sort of features that make one hole an entrance and one an exit are amplified when you see the two together, and one is characteristic of an entrance, the other is characteristic of an exit. That makes it a much more certain determination. Sometimes you have two wounds, both of them can look more like entrances, and then it might be hard to tell which is which. They might look more like exits, depending on individual characteristics in that particular case. But in this case, pretty straightforward. The one we previously described looks like an entrance. This looks like an exit, so that's the pairing.
Okay. And the path went straight through.
Yes,
Did the projectile hit bone or was it just tissue?
it did hit bone.
Bone. Okay.
Yeah.
So if you could just verbally say, what was the directionality of this wound path?
So this wound traversed the leg in an upward angle from the back toward the front and also from the left toward the right.
Okay. So are you able to, let's assume that there were 3 shots. Let's assume that one's a graze wound. So one shot was found inside the body, one went through and through the leg, and then there was a graze wound. Are you able to say which one of those happened first?
No.
Okay. And why not?
Sometimes wounds that are in the same part of the body, especially say gunshot wounds through the head, the fracture pattern can tell you that. But if you don't have something like that, there aren't physiological features that allow you to time them unless there's been so much time between that there's healing, for instance.
Right.
So there was none of that here.
Okay.
So there were just simply no physiological findings that would allow me to tell which came first.
And also, do you have limitations on being able to ascertain where the shooter was versus where the victim was when shots were fired?
One thing that being able to determine an entrance and an exit through the body, or in the case of the chest wound, the entrance and the location of the projectile within the body, it allows you to determine the relative position of the gun when it was fired relative to the body of the decedent.
Okay.
So that gives you some of that information, but not all of it, because a gun can be held in different ways. It can be held toward the body or away from the body. It can be held at different heights and locations relative to the shooter. So some information, yes, but not. It doesn't allow you to tell you entirely where they were relative to one another.
If it can tell you where the gun is in relation to where the body is, it doesn't necessarily tell you where the shooter's body was positioned, only that the gun must have been at this angle. Is that what you're saying?
Yes.
Okay. So it's kind of confusing. So let me give you an example.
Yeah, but if the leg is bent, and he's, I can't really, I don't have the agility to do it.
How are you doing?
It doesn't make sense to me. Yeah, it kind of. If he's down on his stomach and his leg is bent like that,
Mhm.
and then you could get that trajectory. But then you wouldn't. Then the bullet would be in the floor. Because if you put it in this way and get it in the wall, it wouldn't have an exit wound that's higher than the entry wound. I can't make it make sense. I don't know
Doesn't make
anything.
sense to me,
I'm just guessing.
but I don't know either. Yeah.
Yeah, that's no, they were moving, Jonah. They were about to empty the house, and they sent his small daughter with her grandmother to the park, and then it happened. Yeah, I don't understand. If he had the first one and fell over, I can't get it. Other than him being up and she's down, but then again, the holes in the wall is low. That's the part I don't get.
Mhm.
Because that must have been in a downward trajectory to go into the wall that low. We saw how low it was on the wall. So it doesn't make sense to me. Well, maybe he knows
Well,
it.
we'll talk about the leg wound. It was right leg, correct?
Correct.
And it's going from here out here.
Correct. Yes.
At an upward angle.
Yes.
So if I were to be standing here, someone would have to be on the floor to shoot up my leg, right? At that angle.
More or less, yes.
Okay. How about if I were falling this way and someone shot? Could that angle be duplicated?
Yes, especially if you fell backward and really externally rotated your leg out to present the back of the calf to a gun that might be firing well to your left.
Okay. And is there a scenario that could work where the calf or the knee is bent in this direction and the shot comes from behind?
Yes.
Okay. One moment.
How?
Did you do any toxicology on Doug Benefield, on the body?
I took samples and submitted them to the lab for toxicology analysis, yes.
And were there any drugs or alcohol in his system at his death?
No.
I wanted to ask you a question about the chest wound. What organs did it hit, or what important things did it hit?
So the projectile path went through the chest wall on the right side, and then it hit the right lung. It went through the vertebral body or vertebral column of the spine. Did not appear to hit the spinal cord in that track. After passing through the spine, it then hit the left lung, and then went through the chest wall on the left side to end in the tissues where we found it.
And do you think that type of injury would incapacitate someone immediately?
It certainly could. These things are, it's not easy to, really accurately predict, because different people have different responses to the shock of the trauma and the pain and debility that would occur immediately. But there was nothing about the injury that would absolutely cause immediate incapacitation, like an injury to the a clear injury to the spinal cord.
Severed spinal cord.
Right. Or a severe traumatic brain injury, or
That makes even less sense, what she just asked him. If you're laying down, is there a way you could get it again? You need this angle. So your leg should be twisted how the hell? So your foot should be out here and your knee should be here. Then your knee should be broken. That makes absolute. I don't understand this one.
Mm-mm.
4. There's a motion hearing tomorrow morning. Well, Jamie has to get out of bed early then.
Maybe even a severe injury to the heart. Those things you typically would expect to have near immediate incapacitation from. This didn't have that. So
I need a Barbie doll to
potentially
do these
could there
kind
have
of
been
You
things.
do
some
need a Barbie doll.
activity, some ability
That is
to
right.
take some purposeful movements or motions or things? I think it's possible.
Possible, but probably not
Only
likely.
if you have
Not
a
likely
quick
to
mind.
do a great deal. I think in my experience, most people who suffer injuries like this do fall pretty quickly from the place where they're shot.
And were you able to determine the cause of death?
I was, yes.
And what was that?
I determined the cause of death to be the gunshot wound to the chest that we've been describing, with perforations of the lungs, and the medical term I use is hemothoraces. That's blood accumulations that are occurring in the chest cavities around the lungs on the right and left sides.
Okay. And I noticed that you didn't mention that you had mentioned earlier that there were a couple other injuries, one in the head and one, I don't remember where you said it was, but I noticed that those didn't play a part in that cause of death. What are those injuries?
So there was an injury to the back of the head, a typical scraping and bruising injury that we might see from someone falling and striking the back of the head.
Okay. So if he were shot and then did fall, it might do that to his head.
Yes.
And where was it located on his head?
Essentially what we would call the occipital protuberance, or the back of the head where I'm putting my hand now.
Okay. And what was the other injury you observed?
The other injury was a very minor injury to the back of the thigh, really barely noticeable. I don't really have an opinion as to what caused that injury, but it wouldn't have been anything that was debilitating or causing any problem, and certainly wasn't associated with the cause of death.
Okay. And is it possible that that injury was inflicted or he had that injury at a different time?
I mean, it's possible. I didn't see clear evidence of healing in that injury, but it could have occurred outside of the circumstances of the shooting.
Okay. So the cause of death was that chest gunshot wound. What was the manner of death?
Manner of death, I determined to be homicide.
Okay. Thank you. I have no other questions.
I can't get this to make
Mr.
sense
Taylor.
in my head.
Mm-mm.
And again, for my purposes, I consider your objections to the right bicep wound to be preserved, even though I know you're going to ask questions about it. I consider it preserved.
Yes, sir. Thank you.
Yeah, it's American Twister where you always have a pew-pew stick with you.
Afternoon, Dr. Vega.
Good afternoon.
Nice to see you again. I have a few questions I'd like to ask you. I want to start, if I can, with the wound to the chest.
Yes.
What made the projectile, otherwise known as the bullet, you said that the track of the projectile was from anterior to posterior, front to back, and right to left, correct?
Yes.
All right. Were you able to determine what caused the bullet to take the turn from right to left? Did it deflect off bone, a rib? Do you know?
There was no deflection. The trajectory of the projectile prior to entering the body did not change significantly in terms of how it passed through the body.
Okay. Now, if you were going to scientifically determine the trajectory of this bullet, which you've told.
No, right side of the chest ended up in the lower left back. And yeah, it did a little rattling around inside.
Told us is front to back and right to left.
That's typical.
You know from your examination that you recovered the projectile from the back of the deceased, correct?
Yes.
So you would be able to show scientifically the entry wound, which was approximately where the right below the nipple, and trace the path through the body where you come to find the projectile lodged in the back. Correct?
Yes.
All right. And with respect to the wound to the leg, from the interior of the right leg, which exited the posterior, the outside of the knee. You showed us the entry hole, and you showed us the exit on the outside of the right knee. Said that they were typical of these types of gunshot wounds, and you would theoretically be able to trace the path of the trajectory of the bullet from the entry to the exit, correct?
Not even theoretically. I mean, I was able to make that,
As a
that
fact.
track. Yes.
Okay, and I think to add even more measure to it, a projectile was recovered that was tested that had blood on it that came from the shot to the leg.
There was a fragment of projectile that I was able to recover from that path through the leg.
Yes.
Yes.
And if matched with the remainder of the projectile, which was in the room, it had a small piece missing, equivalent to the fragment that you recovered in the wound for the knee.
That's possible. I'm not aware of the analysis of the projectile that was in the room that I never examined.
Okay. Now, with respect to the wound to the arm, we don't really have any facts that we can lay out equivalent to the wound to the chest, for example, or the wound to the knee. Correct?
I think the observations are much more limited. There's much less data there to look at to try and make a determination.
Right.
Yes.
Which is why you can very candidly describe this as a probable grazing gunshot wound.
Yes, that's the terminology I used in my report.
Yes, because you weren't certain.
That's correct.
All right. And as you sit here today, you're not certain.
That's correct.
All right. So what allows you to conclude that it may be a grazing gunshot wound is your experience.
Yes.
Okay. Do you remember I had the privilege of sitting with you and taking your deposition?
I do.
That was testimony under oath.
Yes, sir.
All right. And we talked about the wound to the arm. And I had presented you with, I think, 5 medical authorities that suggested that these type of wounds are always difficult to determine, and you agreed with that.
I remember the discussion. I don't remember the specific number of people that you might have gotten opinions from or such, but yes.
But you would agree, as you sit here today, that they are difficult wounds to determine.
Yes.
Okay. And in fact, I had asked you at your deposition how you determined the nature of the wound, and you corrected me and said you hadn't really determined the nature of the wound, which is why you described it as possible.
Yes.
All right. I want to ask you a couple of questions, if I may, Dr. Vega, about homicides. Not all homicides are crimes, correct?
Correct.
We have what's known as justifiable homicide, where, for example, a homeowner shoots an intruder at night in their home. Example of a justifiable homicide, correct?
Certainly could be.
All right. And we have excusable homicides, where a law enforcement officer, and arriving on a scene, encounters the perpetrator who has a weapon, and the law enforcement officer shoots and kills the perpetrator. That's excusable homicide.
It sounds like it could be. Yes.
All right. Do the app?
I need one of these, Jamie. Because I just can't make it. Imagine what I could do if I had one of these, and no, I'll drill holes in it to show trajectories.
Well, no, you gotta get those little sticks that you can like stick to them.
Yeah.
You can
New
make it work.
toy. New
You
toy
can
for the
make it
streams.
work. Yeah.
That's yeah, I think we have you know, those cheap stores. I think they have them for like a hundo or something. Yeah, but IKEA is 45 kilometers from where I live, so, and that's just as bad as making Jamie drive to Dave's house.
Yeah, that's terrible. That's a terrible idea.
Yeah, I could use a straw to show trajectory.
Yep.
I need one of these now, Jamie. You know that? But I
You
need
do.
some wicks
And he's
for
got
it.
all bendy parts too, right? So then you can like
Yeah, it's
use it
a
for other
Quacky.
things.
It's a Quacky doll, so it can bend in all directions.
Yeah, that'd be perfect.
Yeah, I need this, Jamie. Why haven't you gotten to me?
I didn't know it was needed at this. Is he wood?
Yeah, it's wood.
Why is everything you guys like wood?
Well, Quacky figures are normally wood.
I
Hey,
don't know what
Zach,
that is,
missed
but-
you.
Hey, Zach.
Yeah, Amazon. If I have to order it off Amazon, it'll get really expensive because they have to bring it in from Germany. We don't
Yeah.
have a Danish Amazon, so I have to go. Well, Jamie, I have to get an allowance this month so I can buy more stuff for the channel.
Yep.
Since
I
of
need to.
defensive wounds, Dr. Vega, necessarily exclude aggressive behavior.
Well, I'm going to Copenhagen in the weekend, so
No.
at least I can
Okay.
get it over there.
So he could be the aggressor and still not have defensive wounds.
Oh,
I think that's
didn't know
possible.
that.
All right. It also does not exclude
I don't want to make
the
more holes in
aggressor
it.
being the one that initiates a confrontation, does it? The absence of defensive wounds.
No.
You told us, again, very candidly, that you cannot, at least in these circumstances, determine the order of the shots with any reliability.
That's correct.
You've previously testified, and I would assume it's your testimony here today, that the deceased was facing the shooter at the time that the chest wound was suffered.
Yes, although based on the right to left component of the trajectory, the weapon would have been to the decedent's
To the
right
side.
side.
Facing, but not directly.
Correct.
Okay. Your autopsy report, you have
Yeah,
it
I
with
could
you?
use
I do.
Okay.
a Quacky
You
doll.
might remember this off the top of your head in preparation for today's testimony. The examination was completed on September 28th, 2020, correct?
The autopsy was performed on that date.
Yes. The autopsy examination,
Yes, there are components of the autopsy, though, that were not done on that day. For example,
toxicology,
and the microscopic examination. That requires tissues to be processed into glass slides, and then glass slides have to be delivered. And then I look at them when I have the opportunity. I add those findings to the other findings that I got the day of the autopsy, and that all goes into compiling the final report.
All right. And you signed off on the final report, did you not, on November 3rd, 2020?
I did, yes.
Okay. As the medical examiner, and you're the medical examiner for not only Manatee, but also Sarasota County, correct?
And DeSoto, and right now Charlotte County as well.
Find yourself a little busy? Do you have a working relationship with law enforcement?
Yes.
All right. That's pretty much the nature of the position, is it not?
It is.
All right. Do the detectives and the law enforcement personnel generally wait to hear from you, or do they periodically check in and say, so what do we got, Doc? Do you have a tentative opinion that you can give me? Is there any of that takes place?
It depends on the nature of the case, but certainly some cases there may be no communication at all until our final report comes out. In other cases, there may be discussions at various points during the evolution of the case from the autopsy to the final report. It very much depends on the nature of the case, the needs of law enforcement, et cetera.
Sure. So for example, like a poisoning allegation, that may be something that you're not in a position to give any kind of tentative opinion until the toxicology comes back.
That's possible.
All right. And a shooting, on the other hand, if they were to call and ask you, I got one question, Doc, was he facing the shooter at the time he was shot? That's something that you might be able to answer earlier.
That's
Yes.
interesting.
All right. I would not expect you to independently remember whether or not on any particular case you got any calls from a particular law enforcement officer to ask such an inquiry. Is that a fair assumption?
On an individual case, it would probably be difficult to remember every conversation of that type, yes.
Okay. And the scalp wound that you told us about is the type of wound that you said is consistent with somebody falling and striking a hard surface,
Yes.
like a tile floor.
Yes.
Okay. So let me see, using this anatomical dial, if I can, for a
Oh,
moment.
there you go.
Let me ask you about the
Anatomical.
leg wound.
Oh, he
Yeah,
has
I
one.
put
I
Dr.
can't have
Baker-
one.
Yeah,
Jamie.
he has one. Is he have the little same one as you?
How easily you were able to put your leg up on the bar. Using this anatomical dial, if the individual that was shot was falling backwards and their legs went up in the air like this, as they went back, would the trajectory of that leg wound be consistent with a shot to the leg that would go on the inside of the calf and exit on the knee?
But why would his leg go up?
If the leg were raised above the plane of the body while the body was falling, there's probably a location at which that angle could be produced.
doesn't make
And I want to make sure I got the right predicate here, if you will. You're sort of assuming from the same position that the initial shot to the chest would have been fired. Is that accurate to say?
Well, again, like you, I can't say what the order was, but if there was a loss of consciousness and incapacitation and the individual were to start falling backwards, at some point in time, would the leg not be up where it would be consistent with that angle?
No, because then he would have to fall. He would have to fall. If this is his body and this is his leg, he would have to be on the ground with his leg almost. Because no. Yeah, like this. Who falls backward with a stiff leg? That makes absolutely no sense if he got shot in the chest and just fell flat. It's not in the movies where you just go stiff and fall backwards. It doesn't happen like that. That's a stupid. Nope, that doesn't make sense.
In addition to the body falling backward, the hip would have to be flexed and the leg would have to be brought in front of the rest of the body. If that were to happen, then yes, that angle could be produced.
The last question I have for you, Dr. Vega, is I want to ask you about the study of wounds. As a medical examiner, you're constantly called upon to examine various wounds and extrapolate how they were incurred, correct?
Yes.
All right. And that is, correct me if I'm wrong, a science in and of itself, is it not?
I mean, it's a field of study, so I suppose the term science is appropriate, yeah.
So we have, for example, crime scene people who study wound ballistics and the interaction between a projectile moving at a high rate of speed and human tissue and skin. Those are some of the things that you're called upon to interpret as well.
Yes.
Okay.
No, we don't need it, but sadly, that's how I do it. Because I'd rather talk about it when I can remember it and stop the case. And then we can don't talk over the evidence, because it's better to have an interruption than miss evidence.
Give me just a moment, Your Honor.
Of course.
And again, it's a year old. You're not missing anything. They already ruled on it. Does he have a massive growth on his neck?
Last question, Dr. Vega. Back to our
Yeah, looks like it.
scenario of the shot to the leg. Hypothetically, if somebody were to throw a karate kick with their leg or an attempt to kick,
That's funny
might
to
that
hear.
also be consistent with the trajectory of the wound to the leg?
That could actually work.
It would have to be a unique
I mean,
kind
yeah.
of kick to, from the front in a standing position, be able to expose the back of the leg. But I suppose it is possible if the leg were raised high enough that the back of it were exposed to the person who's facing that individual.
Well,
that
you
it could
do a
happen.
spin kick.
Thank you. Nothing further, Your Honor.
Or
Yes, sir. Any redirect?
No, thank you.
All right. Can this witness be released?
Yes.
Yes, sir.
All right. Do you also have him under subpoena? You're going to need him back.
Uh,
Usually when I say released, I mean the witness can go.
Yeah,
So-
we do not have Dr. Vega under subpoena.
All right, sir, you're releasing your subpoena. Thank you very much.
Thank you, Your Honor.
Is that yours? Is that our clicker?
That's your clicker. Yes.
well, if it was doing a spin kick, I could get the ankle to
All
work.
right. Yes, ma'am. Go ahead.
We have another witness that is ready to kick, or we can break.
I would just keep going through, but I'm known to do that and it's not well received. So how long do you think? I mean, I know for your direct, but I don't know how long the cross is going to be. So who is it?
It's a unit manager, the crime scene tech, Rich Talbot,
Oh, Mr.
and it's
Talbot.
just as to the stippling or lack thereof on the shirt. I have about 6 pictures.
Yeah, I think we can do that.
All right. Miss Sarah, can we do one more?
Yes, sir.
Do you stretch for a minute? Okay.
Thank you.
All right. Let's get this witness done, then we'll take a lunch break.
Thank you. I'm going to stay with Rich Talbot.
So she's just has to say there was no stippling on the shirt. Which stippling, wouldn't that be a good thing in a self-defense case?
Mr. Stand by here, face the court, raise your right hand, please.
Do you solemnly swear or affirm that the testimony you shall give in this case to be the truth, the whole truth, and nothing but the truth?
This is the Florida v. Benefield, also known as the Black Swan. We are start covering it next week when it starts up. We're just rewatching the hearing from last year about Stand Your Ground.
I don't mean to put you on the spot. Any issues with education, training, experience?
Maybe.
Okay, so let's go ahead and put that all on. Go ahead, ma'am. Sir, as the deputy said, 12 to 15 inches from the microphone, loud, clear voice should be fine. If you need to adjust it, please feel free to do so.
Okay, thank you.
Good afternoon.
Hello.
Please state your full name and spell your last name for the record.
Rich Talbot, Talbot,
And by whom are you employed?
Manatee County Sheriff's Office.
How long have you been so employed?
For about 23 and a half years.
And what are your duties with the sheriff's office?
I'm in charge of the crime scene unit, so I run the day-to-day operations of the unit. And that can entail anything from assigning and reviewing cases to responding out to a crime scene. I'm responsible for supervisory type issues. And then sometimes I also do crime scene processing as well if they need it.
So sometimes you function as a crime scene tech?
Yes.
Okay. And how long, your whole 23 and a half years, has that been as a crime scene tech or there in the manager?
Yes, I spent 2.5 years as a regular technician and I was promoted to supervisor.
And during the whole 20 plus years after becoming supervisor, you've continued to work as a crime scene tech?
Yes.
And can you tell me a little bit about your education to become a crime scene tech?
Yes, I have a degree in criminology, a bachelor's degree in criminology. And once I got hired here at the sheriff's office, they have sent me to, I have about 300 to 400 to almost maybe 500 hours of job specific related training courses.
And has that continued throughout your time at the sheriff's office, even more recently when you've been functioning as a manager?
Yes, a lot of the time was in the first probably 10 to 15 years that I was here, and then but our training goes more towards the newer technicians now, and now it's more supervisory type classes that I attend.
Yes, sir. And has your training included using an infrared camera?
Yes, I attended a training class for that.
And what is an infrared camera?
An infrared camera allows you to actually create a contrast between the surface that you're looking at, the item, may it be clothing or skin, and it creates a contrast and it takes some of the colors out of the item you're looking at, and the substance that may be on the clothing or on the skin, it enhances that.
And that's a type of camera the sheriff's office possesses?
Yes, we do have one.
And you have used it regularly over the years for testing?
Yes.
And do you have to use an alternate light source? That's a mouthful for me, I'm sorry. To take the photos, or is it something that the camera does itself?
No, the camera actually, there's filters put on the end of the camera lens, and we hold a small infrared flashlight that actually you shine on the surface of the object that you're looking at, and then the camera takes the picture.
I see. So we'll come back to that, but I want to take you back to September 27th of 2020. Were you working that day or on call at least?
I don't know, Christine.
And did you respond to a scene at 11331 White Rock Terrace?
Yes, I did.
And Was that as a supervisor?
Yes.
It's not called the Black Swan case. It's called Florida v. Ashley Benefield. It's just known as the Black Swan case on in the medias. So it's not. It is called. That's why I put in the Florida v. Benefield in the header.
But while there, did you assist crime scene tech Amanda Conlin in some of her scene processing?
Yes, I did.
And did that include the trajectory rods?
Yes.
And so on that date, were you present the entire time Ms. Conlin was there processing the scene and learning along with her?
Yes, I was.
Thank you. Did you at some point a couple days later return to the scene to do some additional work?
Yes, we did.
And what was that for?
That was to go out and complete a scanning of the crime scene utilizing a ferro-terrestrial laser scanner.
And was that completed by yourself or another crime scene tech while you were there?
The main person completing that was CST Rudolph.
On about a week later, I guess, on the 6th of October, were you asked to actually process some items in the lab?
Yes, I was.
And what were you asked, or what did you assign yourself to process?
Essentially, there was a shirt that the victim in this case was wearing at the time of the incident, and I was asked to examine that shirt for any gunpowder residue or anything like that, stippling.
And what is stippling? And let me ask you this. Through your time as a crime scene tech and the unit manager, have you dealt with a lot of gunshot cases?
Yes, we have.
And have you received training and experience in things such as soot and stippling?
Yes, the training and experience is a lot of different cases that have involved that.
Yes, sir. Okay, so what is stippling?
Stippling is small particles that are that come out of the end of the barrel of the gun, from the ammunition, and depending on the range of the gunshot, the firearm from the surface of whatever it's striking. It's basically small particles that will show a pattern of burn marks or little particles that are land on that surface.
Because correct me if I'm wrong, when a gun is fired, I call it a bullet, the projectile leaves the end of the barrel.
That's correct.
And with it, gunpowder, which has made it go bang, might also exit.
Yes.
And is it your understanding from your training and experience that at certain distances that gunpowder could land on a victim or clothing on the victim and leave some residue?
Yes.
It's a bit leading, so.
Okay. And so what is soot?
Soot is just a like a burn mark or something like that the powder is leaving on the skin or the clothing or stuff like that.
And would that be the same where the powder, just expand a little bit on the powder from?
The firearm.
Thank you.
Or from the ammunition.
Thank you, sir. And did you in fact process the victim's shirt in this case?
I did.
And did you document using a regular camera and or an IR camera?
Yes, both. We took photographs of the shirt with a regular camera, and then using the infrared camera, we took photographs of it.
And could you explain a little bit more about the process? You said there's different filters. Could you just explain so that we can understand exactly what that means?
Yeah, there's the camera kit that the IR camera uses comes with 3 different filters, I believe, and there's different levels of the light, the amount of light that it allows in from the infrared flashlight. So there's different levels of the filters that will allow it to see different light.
And based on the different levels of light and the different filters, what occurs to the item you're examining?
Depending on the filters, the more light that lets in, the more the the filter will allow more light in, and the shirt, you're looking at a shirt in this case, the colored background will fade away more using the different filters. You'll have different levels of the background that's taken out, and then the substance that's left on the shirt will absorb the light, and basically it creates more of a contrast between the substance that's on the shirt and the background color of the shirt.
And Mr. Talbot, I'm going to show you 39 through 43 was going to be our state's exhibits. Would you take a look at those pictures and tell me if you recognize them? I don't know. It's 39 through 44. I may have misspoke. I'm not sure if I said 43 or 44.
Yes, I recognize them.
And how do you recognize them?
They're the photographs that I took on the shirt that day.
And do they appear to fairly and accurately depict the examination you performed on October 6th of 2020?
Yes.
Your Honor, at this time, the state would ask to move in states 39 through 44.
Any objection? Received?
And may I publish them?
Yes.
Thank you. Mr. Talbot, there's a laser pointer there if you need it. And
Thank you.
I'm going to steal.
It is the voices in your head.
I'm showing you what's, sorry, this is States 39. Can you just kind of describe for the record what we see here?
This is just an overall.
This is the most CrossFit t-shirt I've seen in a long time. Don't do CrossFit.
All of the shirt on the front side of the shirt as we put it back together a little bit as much as we could. You can see the cut marks in the shirt where EMS cut the shirt off the victim.
So it's kind of a cross in the middle, and that's, you're understanding that's from EMS.
Yes, that's what I believe to be.
Thank you. And then what's the area of interest on this shirt?
This right here is the gunshot hole in the front of the shirt. I placed a white card in behind that just to be able to see the hole.
CrossFit is fine if you are very, 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 very experienced in training. If you're not, and you go to one of those CrossFit boxes where they have trainers that did a 2-hour course and is better at yelling than they are at training, there's a reason why chiropractors love CrossFit, and they never do it.
And I'm going to show you States 40. There was only one. How many holes did you find in this shirt?
Just one.
Okay. And so this is the same one we just saw in States 39?
That's correct.
Okay. And you said you placed a white card behind it?
Yes.
Okay. And so these two pictures that we've just seen, are those through a regular camera at regular light or not?
Yes, I believe they were.
Okay. And then after taking photos at regular light with a regular camera, what do you then do?
I then start using the infrared camera and just take some more of the same series of photographs, but not without the overall in it.
And during the course of that taking, are you changing those filters you told us about?
Yes, I changed the filters as I went through, going through each level of the filter to see what is going to show the best contrast.
And I believe States 41 through 44 is a sampling of those photos. Is that correct?
That's correct.
Okay, thank you. I'm going to show you States 41. Do you, ultimately, when you're using this infrared camera, if there were stippling and soot, what would you expect to see?
That's the sound you make when someone tells a really bad dad joke.
Oh my God.
I would expect to see the background colors of the shirt to lighten quite a bit, like where you see this dark right there and it's gray. It lightens up significantly. And if there was stippling present, you would see darker particles or powder burns around the bullet hole.
And in States 41, do you see any of those darker particles or bullet or burn marks?
No, I did not.
I'm going to show you States 42. It looks somewhat different than 41. And what accounts for that?
It's just a different filter, and the background on the darker area is lighter color now, and the gray shirt is lighter color even more to it, where it's almost towards a whitish color.
And did you see anything under this filter that indicated to you there was stippling or soot?
No, I did not.
And I'll show you States 43. Again, it looks a little different.
Yeah, and it is just another filter we used, and again, there was no other areas of stippling that we thought could be there.
And then finally, States 44. Again, a little different. Is this a different filter again?
It may be the different filter, but it's also a closer up shot, showing the bullet hole a little bit closer.
And now we see some faded portion there around the bullet hole. What is that? Is that attributed to anything?
In my opinion, it was attributed to just wear and tear of the color of whatever the color of the shirt is, and because you can see the wear and tear in another location of the shirt showing the same thing.
And was that location close to the bullet hole or somewhat at a distance?
Further away.
So after conducting this examination of the shirt using your infrared light, did you find anything that indicated to you there was soot or stippling on this shirt?
No, I did not.
Can I have just a moment, Judge?
Yes.
Yeah, is it 10 feet, 6 feet, 10 feet?
Through your time as a crime scene tech and subsequently the manager, have you been trained on or come to know through your experience generally how far should it or sibling exit, or how far away the gun would be?
I couldn't give you an expert answer on that question, but through my experience and with the medical examiners and some different firearms experts, I've heard that it's outside of 3 feet. Inside of 3 feet, you're going to start to see some of that stippling and gunpowder, maybe. So that's just the general thing that I've come up with, that I've known over the years to be at outside of 3 feet.
Thank you, sir. I don't have any further questions, Judge.
Cross. And do you want any of this, or?
Yeah, we can have the lights and.
Yes, absolutely. I was just saying, were you going to use the display?
No.
All right. Yes, sir.
Afternoon, is it a deputy or Mr. Talbot?
Mr., if you wish, that's fine.
Civilian?
Yes.
All right. So, Mr. Talbot, you've told us that you examined the shirt. It had no signs of stippling.
That's correct.
And stippling being the gunpowder residue that comes out the barrel of a gun when it's fired.
Yes, the small particles that will come out of the gunpowder.
Right. A lot of times it leaves like tattooing when it's in close range.
That's correct.
All right. And you've told us that stippling generally travels, I believe your words were outside of 3 feet.
Yeah, the distance, if you're expecting it to show up on the skin or the shirt or something like that, they would expect it to be somewhere around 3 feet. You'd expect us to see it there.
Okay. So would it be fair to say that what you're telling us by your testimony is that making believe that you are the shooter and I am an assailant, and I have previously on this occasion assaulted you, and now I am coming at you again to assault you. You're telling us that you shot me, and when you shot me, I was 4 feet or more away from you.
Potentially.
Yeah. That you chose not to let me get closer than that to assault you a second time.
Potentially, yes.
That's all.
Did they say 3 or 4 feet?
No, sir.
All
Thank you.
right. Can this witness be released?
By the state.
Yes, sir.
All right. So you're releasing your subpoena. Thank you very much.
Thank you.
All right. Let's take a break. And it's just a little bit before 1. I think we can be back by 2. It's a little bit after the lunch rush, so hopefully everybody can get in and get out. Does that sound all right? Sound okay? All right. The only thing I'll say is, folks, obviously, when you step out of these doors, I don't have any jurisdiction out there, but I'm going to ask that both sides just kind of go your own way, have your lunch.
1-2 steps. He could
All
cover
right, we
it.
are back on the record. It's about 1:59. Say, go ahead and call your next witness.
State Call Detective Justin Warren.
At least he looks like a
Swear
cop from
or affirm
Canton.
The testimony you shall give in this case to be the truth, the whole truth, and nothing but the truth.
Looks like looking at Brian Higgins.
Thank you. Hello, sir. Hello, sir. As the deputy said, 12 to 15 inches from the microphone. Okay. Adjust it how you need, up, down, left, right, and just loud, clear voice should hear everything. Yes, sir.
Oh, as a chubster myself, brother, you need a new suit jacket.
Aw, that's so sad.
It's way too small.
And Judge, we're ultimately going to need the screen.
And pull it down when you sit down. Just you.
Good afternoon.
Good afternoon.
Please state your name.
Detective Justin Warren,
How do you spell Justin and Warren?
Justin Warren.
Where do you work?
I'm employed by the Manatee County Sheriff's Office.
How long have you worked there?
Started March 25th of 2003, so just over 20 years.
What is your current position?
I'm currently assigned to the Manatee Homicide Investigative Unit.
What is that?
So basically, it's a unit comprised of detectives from the Sheriff's Office as well as other local municipalities. And whenever a homicide occurs within the jurisdictional boundaries of Manatee County, several of our units or detectives will go out to assist.
And generally speaking, when there is a homicide, do all of the members go out?
It depends. Sometimes for people on vacation, other times not everybody will come out. It depends on what the supervisor deems necessary.
But the majority of the time, do you have more than one detective there?
Oh, yes, ma'am.
Okay. And do you have what's considered a lead detective in cases that you do?
We do.
Okay. Now, what does the lead detective do?
The lead is essentially the person who will basically hand out assignments. Those other detectives that will be out at the scene, or they might be knocking on doors, talking to witnesses, they essentially report back to the lead and the sergeant.
Okay. So as the lead, even though you may be designated a lead, that doesn't mean you're doing all of the interviews.
No, that's correct.
Okay. Were you the lead detective on the case that we're here about today?
Yes.
Ashley Benefield.
Sorry, yes, ma'am.
Yes. On the date of the shooting, were you notified?
I was.
And around approximately what time?
I think it was probably around 7:20 or so.
Okay. So you were called at around 7:20. Do you know, was there a 911 call?
Yes, ma'am, there was.
And what time was the 911 call?
I think that was approximately 18:56 hours, so 6:56 or so p.m.
So you're there roughly 35 minutes, or,
Yeah.
or you come to the sheriff's office roughly 35 minutes afterwards?
Yes, ma'am. I started responding there.
Okay.
Yeah.
So I was starting to say that you went to the scene, but you didn't go to the scene first, correct?
That's correct.
Where did you go?
I went to the sheriff's office so that we could begin authoring a search warrant for the residence.
Okay. At that time, did the defendant, Ashley Benefield, come to the station?
There's nothing worse than having a jacket that's too small because you can feel it in your back, and that's why it's riding so high. He should really just pull it down. It'll give him some more room. And
Yeah.
it's all crinkly up here because it's too tight. It's you can see the arms and shoulders. He's like me. We have those I wish I could fit clothes, and he got one of those on today.
She was brought to the station. Yes, ma'am.
Okay. Was she brought to the station by other members of Manatee County Sheriff's Office?
Yes, ma'am. There was a patrol deputy brought her in a marked patrol unit.
Was she under arrest at that time?
Not by me, no, ma'am.
Okay. When you saw her, were there any other people with her?
When she arrived, it was just the deputy and her. But I was soon, actually, before I even met with her, I was actually approached by a female by the name of Faith Brown.
Okay. And did she have other people that joined her throughout the evening?
Eventually, 2 others arrived. Yes, ma'am.
Okay. Do you recall who they were?
Leland Taylor and a Miss Kimberly Kuhn.
And they're all 3 attorneys?
They are.
At the time, did you have a crime scene technician take photographs of her?
We did. We had a crime scene technician respond to the office. We actually obtained a search warrant in order to get those photographs and DNA and whatnot. But yes, we did.
And why?
We asked, and initially it was told by her attorneys that they would rather us get a search warrant, so we did.
Okay. And why did you want pictures?
So initially, when I saw her, I didn't notice any kind of injuries at all. I didn't notice anything about her clothing that stood out, whether it was ripped or torn or stained or stretched out, things that you would typically see during a physical altercation.
At the time that you saw Ashley Benefield, were you aware that there was a self-defense claim?
I had been aware of what had been said on the 911 call. Yes.
Okay. And what was said on the 911 call, and we have a stipulation to this effect, but basically Ashley went to a neighbor and said her husband attacked her.
Correct. And yes, ma'am.
So you were aware of the self-defense claim at the time?
Yes.
When you observed her physically, what was she wearing? Oh, I'm sorry.
Can I request that the stipulation be read?
Which one is it?
It's number one, I think.
Number 1? Okay, it doesn't mention 911, but that's ran to neighbor's house, called 911.
Well, Your Honor, I believe it says immediately
Mhm.
ran to neighbor's house.
Isn't that weird going to a neighbor's house and said, "Hey, can you call 911? I just self-defended my husband to death."
I wouldn't say that was weird. That would be weird.
But there was 2 mobile phones at the home.
I know, but maybe she just felt more comfortable going where somebody else was or something, you know? I
If
don't
my
know.
neighbor does that, he don't come in here. I don't want to be part of it.
I mean, it might freak the neighbor out, but maybe she just, I don't know. Maybe she didn't want to be
Yeah.
alone. I don't know.
Yes.
And hysterical,
Mhm.
just quite different from what was repeated.
Oh, okay.
Okay.
I've read it.
So anyway, I'm sorry, this is repeated, but you did understand that there may be a self-defense claim at the time.
Yes, ma'am. That's accurate.
So what was the defendant wearing?
Like if I remember correctly, it was like a I don't know what you call it. I guess like a crop top, tube top, something like that, almost sports bra kind of thing, and a pair of shorts, if I remember correctly.
Okay. So tube top sports bra kind of thing? Was it
There was some midriff that was visible,
exposed? Okay. And you said you looked at her clothes
I did.
and you didn't see anything torn or disheveled?
No, ma'am, I didn't.
Okay. And when you looked at her, did you see any injuries?
I did not.
Did you look specifically for injuries?
I was paying attention as we were standing there in the lighting, out in front of the office, and then on the way up to the interview room. And as we walked her into the interview room, I was paying attention to that. Yes.
Did you see her face clearly?
Yes.
Did you notice any injury to her face?
No, ma'am.
Did you speak with her attorneys about the need for documenting these injuries or,
Yes.
or lack of injuries?
Yes, ma'am, we did.
Okay. And that's when you got the search warrant, correct?
It is.
And did you have an opinion about what you should photograph?
So my initial opinion was to photograph everything to make sure that we did a thorough and accurate job in documenting any injuries or marks that may be present. And we actually even put it to her attorneys. And I asked.
Well, we have to pictures so we can determine, because some people could wear a sports bra and it'll be totally fine, and others not so much.
Them, I said, if you wouldn't mind, go talk to your client and try to help us determine if there are any areas of injury or any areas, because we're going to do DNA swabs of the skin as well, to try to pick up any foreign DNA, foreign to her. And
Any response, Your Honor? I think we're heading into a dangerous area.
Yeah, I don't know if you're going to start talking about attorney-client privilege information or.
No,
Okay.
no, I just,
Well, it could be the later pictures, because she had a few scratches to begin with, but you know it, when you bump your knee, it looks worse the next day.
wanted to get across that this witness asked the attorneys, where should I photograph? And then what the response was. And that's
Okay.
why.
All right, I'll overrule.
So you asked, should I pay attention
right.
to any areas?
Yes.
And go talk to your client and let me know.
Yes.
And they came back and said what?
Arms, legs, neck, and hands. I do believe that's the final.
Arms, legs, neck, hand. Did they ever mention, or did anybody ever mention to you eye or face?
No, ma'am.
Did anyone ever mention to you midsection?
No, ma'am.
Did you ultimately arrest her that day?
No, ma'am.
Why not?
Because she had made that claim of self-defense. We wanted to make sure we conducted an accurate and thorough investigation. There was obviously a lot going on here with her past history, and we wanted to make sure that we did a thorough job.
Okay. So you said with her past history, so at least you were somewhat aware of some previous reports.
Yes, ma'am. There were some reports that were in the Manatee County Sheriff's Office computer records database that we were able to view.
Okay. And did you ultimately get another search warrant to take pictures of the defendant 3 days later?
We did.
And why'd you do that?
Well, sometimes with injuries, they don't readily show up right away. Bruising sometimes doesn't come up initially. So we wanted to make sure that we did our due diligence again and check 3 days later, giving those injuries time to appear.
Okay. And have you seen those photos?
I have.
Do you recall how many photos were taken?
Of her in total?
Yes. Let me be more specific. So the first day and then 3 days later, there was more taken. So together, about how much were there?
100 or so.
Okay.
Something like that.
So a lot of pictures.
There were a lot, yes.
And did you at any time, either at this first meeting in the sheriff's office or after the fact, see anything on the defendant that appeared to be an injury?
There was a small scratch. I believe it was on her side. But that actually came up during an interview that we did later on, and it was very minor.
Okay. As part of the investigation, was Doug Benefield's phone taken into evidence?
It was.
And was that phone searched or downloaded to gather the information?
It was. It was taken to our technical services unit, and they did an analysis on the phone.
So you don't do that?
No, ma'am.
Okay. So once the information is downloaded from a phone, is it in some sort of a format that you can read it and search it?
They do use certain programs that allow you to search through and help organize what you're downloading. I don't know the exact ins and outs of it, but I mean, I'm capable of using the program and reading through it. But
Okay.
I don't know the technical aspects of it.
Did you review certain information, some information from his phone?
Yes, ma'am.
Okay. And did you find anything about a U-Haul on his phone?
Yes, ma'am. There was a confirmation email that a U-Haul was supposed to be picked up locally. Then I believe it was supposed to be dropped off in the Bowie, Maryland area.
Okay. And were you able to examine his searches on his phone?
Yes.
And did you find anything interesting about his searches?
Yeah. So one of the searches was actually, it looks like he was looking for a roommate. Like he was looking for a place to move into. It was like roommate finder or something along those lines. But in the Bowie, Maryland area.
And why did that seem of importance to you?
Well, some of the information that we'd received was that everybody believed he was moving in
Okay,
with them, and obviously this kind of contradicted that.
okay. Moving in with them, meaning Ashley
And
and,
her mother
her
and
mother.
their child.
okay, in Maryland.
Correct.
But wasn't that why they were packing up the house so they could move to Maryland?
That's what I thought.
I'm going all over the place with this case because I think he might not have been the best husband in the world, but I don't know. It's going to be interesting to see this case, I think, Jamie.
Yeah, I think so too.
Yeah.
There's so many unknowns.
Yeah, it's really it's one of those where you actually we've been going for 4 hours now, and I still don't have a clear picture of anything that happened. I just all the squirrels aren't running in the same direction right now.
Yeah, I mean, hopefully they square it away when we actually get to trial.
Oh, he's on here for a long time. Well, he's the lead investigator.
Yeah.
It's got Yeah, they didn't live together as it was, and then they did live together, and then it's really, really confusing, to say the least.
I am going to talk to you about State Exhibit 45, and I know there may be objections to this. These are the text messages. There is a stipulation, which I think is number three, that this does not need any further authentication, but I don't know if the defense has a further objection.
That's correct, Your Honor. We stipulate that it's authenticated. However, we still preserve any appropriate objections, one of which includes hearsay and two references.
And Judge, generally my response is that these are text message exchanges between the defendant and the victim for the 7 days right up to an hour before he's murdered. While there may not be anything, explosive on these text messages, that is the reason I'm putting it in, is that there wasn't any fighting going on. There wasn't any.
Question, Your Honor?
No,
I think she's just responding to the objection.
Yes. It is to show the nature of their relationship leading up to the incident. It's expected, and because of what is written in the stand your ground motion, the state feels it's necessary to show the tenor of their relationship and how the relationship was at the time in question.
Right.
So,
I guess my first question is, I haven't seen the text. I don't know what's in the text. I wasn't provided a transcript or a printout of the text. So I don't even know what the subject matter is. I don't know how many there are.
a few.
Oh,
Yeah, we were
Pete.
going to go through it, and the detective was going to help me read these.
Right. I don't know how to make a ruling when I haven't even seen them yet. Maybe they're hearsay, maybe they're not. Well, we've got defendant statements, at least for one side of it. So is the other side of the conversation being offered for the truth of those statements, which would then be hearsay, or is
No.
it just to show the natural flow of the conversation, the effect on the, I don't know.
Yeah, I do think, Your Honor, it has to be relevant to some fact in issue.
And then you got relevance. So
Yeah, and it is not.
And
I don't know how to make this decision without seeing them.
And I do have some further argument depending on what the actual objection is and what the response is.
So what I'm thinking is going to happen is that we're going to keep going pursuant to, subject to your objections, but I got to see them to even have an idea how to rule.
I understand. So, Judge, we can continue.
I left my quarter upstairs.
We can continue on as the court suggested earlier. I'm confident the court will rule.
All right, thank you, sir. So this is subject to any objections.
Okay. And if we could just dim the lights a little bit right in front, just the ones in front of the screen would be okay. And the state would enter into evidence States Exhibit 45. I don't know that I actually did it after the objection. Or would you like me to wait?
Yeah, we got to we have to wait on all of it.
Okay.
Now, ultimately, even if I don't allow them, I imagine you're going to want to put them in the record for your proffer and appellate purposes. But for right now, I'm delaying ruling on all that.
Okay.
Yeah, I like him too.
Now, you have a pointer right in front of you.
Yes, ma'am.
Yeah, if you wouldn't mind.
Are you
it's
live?
really hard to see on this screen, so I'm going to zoom in a little bit. Let me go all the way to the top.
he left his quarter so he could flip to see which one won it.
What are we looking at here? If you could just tell us what information is in this.
So this appears to be a timeline of text messages. Down here, it's telling what type, because there are different types of messages, instant messages, and depending if you have an iPhone, it might be an iMessage or an SMS. Over here shows the direction of the call or text message, whether it's an outgoing or it's an incoming. This would be the date that it was sent, and sent, and this would be the sent or received, I should say. Then this would also be the date and time. Then obviously direction from and to, then the owner's information of each phone.
So are you aware of the reports that came into the sheriff's office? We heard testimony earlier about it from Stephanie Murphy, that there were at least 5 abuse complaints against Doug Benefield, saying that he was abusing the dog.
There were several, yes, ma'am.
Okay. And were all of those complaints before this date of 9/20/20?
Yes, ma'am, I do believe so.
So I would like for you to just, I'm going to make it a little bit bigger. If I'm just going to have you go through some of these so we can get sort of the tenor of what's going on here. So the ones in light blue are from who?
Okay, so the ones in light blue are from Doug Benefield,
And two,
and they would be to Miss Ashley Benefield,
and the orange.
and the orange are from Ashley to Doug.
Yeah, it might be better, if you look up here, you might be able to video. Okay, so the first instant message is 9/20/20 at what time in the morning?
9/20/20 at 8:20 a.m.
Okay, and now it looks like there may be not a message necessarily, but an attachment.
Correct.
Okay, so now you've seen this before. So do some of these attachments work and some do not?
Some, yes, ma'am. Some of them do, some of them don't.
Okay, do you know why that is?
I think some of them are actually based on the internet, not something that's downloaded. So sometimes if you're not connected, the link won't work, and
Okay,
various other reasons.
so this is the first one. And what is this?
Looks like a Bible verse.
Okay. And that was from Doug to Ashley, correct?
Yes, ma'am.
Okay, and then if you could just go through the next few lines.
Okay. On 9/20, so the same date, 10:36 a.m. Loved an image. So typically with some images and posts, especially with iPhones now, they really have this thing going where you can actually laugh at an image or love an image, or you can do different reactions essentially. So as far as I'm aware, that's what we're actually says loved an image. I think it's a reaction to that.
Okay.
Most recent text message. 10:36 and 36 seconds. So 5 seconds later, she sends a message, good morning.
Okay. And then he says,
He replies with good morning.
and then within an hour after that, there is what looks to be an attachment. Is that one that you're able to open?
I'm not sure if that is or not. I don't think it doesn't have a line under it. So I'm not sure if we'll open that one or not.
Okay. So then the next text message is from,
This one's going to be from Doug to Ashley. It says, run, baby, run.
and if you could just continue down the line.
Sure. Then Ashley sends a message, laughed at a movie. Ashley sends some smiley face emojis. That's what they look like. Doug replies, ready to rock and roll, laugh out loud, question mark. That was at 12:20. At 12:31, she replies, give me a few, LOL, trying to round up the cats. It's like trying to teach ballet to squirrels.
Okay, so I'm just going to scroll up. What's the next entry?
So within, looks like within seconds, he responds, ha, that's funny. Give me a few, LOL. He's basically saying he liked this comment. So essentially, like I said, it's a reaction to the comment that was given.
Okay. And then he says, or the next entry is her. What is it?
So at 1:06 p.m., it says, OMG, or oh my God, I'm exhausted, LOL. You can come over now. Sorry.
And at this time, it's your understanding they were living in separate houses, correct?
Yes, ma'am. He had an apartment down the road. I believe it was called the Green.
Okay.
And then she was in a subdivision.
So this here is Ashley telling him you can come over.
Yes.
And he says,
sorry. He replies, need to video the rodeo. Okay, headed that way.
okay.
That's at 1:08 p.m.
And then she.
Is that a euphemism for smecks?
I don't know. I don't know what's going on. I'm trying to listen to the conversation. I'm like, what are they even talking about?
I need to video the rodeo. That sounds kind of like a.
Something about rounding up
Mike's
cats
comment.
and video in the rodeo.
But then at 1:20, what does he say?
So at 1:20, I'm walking around to back.
And she said,
I can let you in the front or whichever. He said, okay, front's good.
Come on, play. Play, please. Play.
Giggity, giggity, giggity.
I was waiting for it.
Then she gave him a little thumbs up.
okay, so that entry was at 1:22 p.m. The next entry is several hours later at 5:37 p.m., which appears to be from Doug. What does it say?
Me and XS boxes arrived.
All right. And Ashley's response?
Is LOL.
Mhm.
Then it looks like at 6:40, Doug sends some other type of an attachment to her.
Okay, and we'll view that attachment.
I don't even know what it's doing. I think it's giving you clues that I gotta guess. Get real. Real.
Working mother, not a working mother.
Working mother, not a working mother.
Not a working mother. I live in a
Slum. Oh no, it's running out of time. House. Real house. White. Oh, housewife. Oh, real house. Oh.
So the person on the left, that's Ashley, correct?
That's correct.
And then on the right, do you know who that person is?
That's her mother.
Okay. Then at the next entry is about 40 minutes after that one is what?
Let's see. We have, was there a response to that? I'm sorry.
I'm sorry. It looks to be a call log phone call.
Yeah.
Yeah.
So that looks, okay. So yeah. A call log, sorry. Incoming. It looks like there's about a 13-second call
From Ashley.
From Ashley
Okay.
to Doug.
And then the next entry.
Next entry is from Doug to Ashley. It's 9/20 of 2020 at 8:58 p.m. And it says, good night, sweet theta waves. I'll be done by 1 tomorrow and plan on joining the party.
And she does what?
She loved the message at 9:22 p.m.
And then said,
Then good night. I'm sorry. Good night. Huh? You sure want to come hang out at the slum? Or are you sure you want to come hang out at the slum? So basically indicating what they were joking about in the video.
on the video. Okay. And his response?
Yep. Be smashing at the slum.
Then skip
Smashing
down.
at
The
the
next one
slum?
is that she likes that message. And then the next entry is from Doug at what time?
That's at 7:36 a.m. on 9/21. So the next morning.
The next morning. Okay. And there's an attachment.
There is.
Okay. And we'll look at the attachment. And for the record, what is this?
That's another Bible verse.
Okay. And what's the next entry?
The next thing I see is at 9:55 a.m. Ashley loved an image. Then she says, good morning.
Okay. And what does he say?
Doug replies at 9:56, good morning. And there's some little emojis behind it here. Then later at 12:46 p.m., headed that way in about 30 minutes.
Okay. And her response?
Her response, that's at 1:09. Oh, hey, wow, you done for the day? Don't rush because of us. We're out for a walk now. Not in a rush to get started today. LOL. We'll have to round up the cats when we get home anyway.
And his response?
So his response at 1:13. Oh, nice. A little breezy, which helps. Getting an early start so can finish up early to come over and be with y'all and play with Emerson, free y'all up some. Just ping when good to head over.
And she likes that.
And she likes that at, 1:51.
And says?
Then at 1:51, a few seconds later, will do.
And then she also asks him?
2:47. Want to grab a can opener at Publix on your way over, LOL. I, of course, packed the one that we had.
Okay. So I'm going to run a little ahead. So this is the next day. If you could read that, what's at the top, that date.
All right. So we have an outgoing from Doug to Ashley on 9/22 of 2020 at 4:11 a.m. And it looks like it was an attachment that was sent.
Okay. And we'll look at that. And for the record, if you could say what that is,
It's another Bible verse
from Doug.
from
correct?
Doug to Ashley, yes.
All right.
Uh,
And then he says,
Sorry, then he says, good morning, hope you slept okay.
and her response.
Looks like she loved the image and then replied with good morning.
Okay. I'm going to scroll up.
So far, nothing really seems like they were in a bad relationship. And thank you,
Later on that
Lorelai
day
and
at like
Annie for becoming a member.
1:36, which is the top entry. And he says to her,
So Doug sends Ashley a message. Can you think of anything we need at Lowe's or anywhere?
and the next,
After that, at 1:42 p.m., it looks like Ashley reaches out to Doug via phone because there's a 48-second call.
okay, so it's a phone call.
Correct.
And then the next entry,
The next entry is at 3:23 p.m. and it's from Doug to Ashley. Headed that way in a few. I'd nothing need.
okay. And I'm going to scroll up. And then I want to go to the next attachments here at 9:22 at 9:27 p.m. What is that entry?
So looks like an image, or I'm sorry, some kind of
Hey,
attachment
Shelby.
sent from Doug to Ashley at
Shelby.
9:27.
Okay, and we'll look at that. And for the record, what is that?
It's a picture of Ashley and her daughter on the beach.
And the next entry is right after that.
Yes, ma'am. It's at 9:28 p.m.
And it also has an attachment.
It does.
Okay, and I'll open the attachment. What are we looking at, just for the record?
Again, it appears to be Ashley and her daughter at the beach.
So Doug sent these to her.
Correct.
I want to go to the next yellow square there. What is that? The
Hey,
same
Eddie.
evening.
Yes. So 9:22 at 9:30 p.m. Another attachment is sent.
And this is what?
This appears to be their daughter at the beach, and I believe that actually can't see who that is there in the background very well.
Okay.
But it appears to be the same location.
Didn't they say it was like 3 weeks leading up to it? I thought I heard she said 3 weeks leading into the accident or incident.
I thought it was pretty close, a lot closer, but you could be right.
Maybe it was 3 days. I don't know. But it was some time period. But again,
I mean, you
nothing has been
clearly hear them making
animosity.
plans. They're like making plans, and she's like going along with everything. So
Yeah, and he doesn't seem controlling or anything in it.
no, just seems pretty normal.
Yeah.
So then I'm going to scroll down until we get to the next day, 9:23 of 20 at 6:47 a.m. What is that entry?
So that is a message from Doug to Ashley, and it appears to be another attachment sent at 6:47 a.m.
Okay. And the attachment again.
It's another Bible verse.
And then after that, he says,
So at 9:23, he says, good morning. And at 9:28, he replies again and says, got email from Stephanie after she talked to Faith. Since order to mediate, we meet for 1 hour tomorrow to stop court next week. You dismiss injunction. We sign joint stipulation to dismiss dissolutions and hold until Moreland signs order for a report. As soon as she signs order, we file dismissal and
Yes.
we're done.
and what else did he say?
At 9:30, and we have joint session with Dr. Q Friday to wrap up our adventure in Florida and leave with understanding of double knots and red-blue inversion.
What?
And the next couple of entries.
Okay. 9:49 a.m. She loved an image. Then at 9:49, looks like 10 seconds later, good morning. Doug then actually, it says emphasized on good morning, so her response. And then Ashley sends another at 9:50. Okay, I'll reach out to Faith to follow up on all of the above with a thumbs up.
Okay. And then he likes that.
Yes, ma'am. So at 9:50, he likes that. At 9:51, and we're all done. Or I'm sorry, and we're done.
Okay.
At 9:52, Doug sends another message, and all in first 10 days of Jewish New Year, LOL.
Okay. So
And then she likes that comment.
we're going to scroll down to the 9:23 or 9:23 at 10:13 a.m. from Doug. What does that say?
9:23, 10:13 a.m. Doug to Ashley. So perfect outside.
And she loves a previous comment, but what is the next comment underneath of that?
So her comment at 10:14 a.m. says, "Oh yay, we should do Selby today."
Okay. And his response?
His response is at 10:14, "Oh yes." Then he responds, "Yum."
Okay. Then I'll scroll through some of this. The message at the top from 11:39 a.m. Who's that from?
So that's from Doug to Ashley. And the text is, "Stephanie just sent Faith joint dismissal of everything except injunction, which Faith has to do." Just a one pager.
And next?
Then he sends another text, "What time thinking Selby?"
And then she liked the first comment. And then what was her response to Selby?
So her response at 11:44 was maybe 1:30ish. "I'll text you when we are heading that way."
And then he says, let me scroll up here. There.
So at 11:44, he replies, "Okay, I can come pick you up too." 12:12, he again sends a message, "More time with my baby," a happy face. Then at 12:14, "Mediation tomorrow by Zoom at 10:30, and be quick."
Okay.
Fed.
Here. So the next entry I want you to read is from 5:53:38 on the same day.
Okay.
And what does he say?
So it's an outgoing message from Doug to Ashley, 5:53. "Do you want to get together tonight or in?"
I think it's supposed to show that there was nothing. They
wasn't
didn't
afraid
have
of
a bad relationship.
Because she claims to be afraid of him and things like that.
Yeah.
So
Yeah, so I think that's why they're putting it in there.
Morning before mediation and unify the instructions for Faith and Stephanie. Think we are going to need to keep involved until this is done or will drag out.
Her response.
Her response at 7:02 is, "Ha, okay, thumbs up."
And his response.
And his response at 7:05, "Thumbs up, prefer tonight, maybe run over Pandera or in morning or AM, sorry."
And she says,
At 7:24, she says, "Sure, can do Panera tonight."
and the next entry.
Next entry is outgoing from Ashley to Doug at 7:24. It says 8 question mark.
Okay.
And
He
then-
sends a thumbs up.
Yeah, 7:27, he sends a thumbs up.
Okay. And then they're telling each other good night. Good night, sweet dreams.
Yes.
And the next day in the morning,
So
7:00. Who is that from Doug?
yes, it is. It's from Doug to Ashley on 9/24 of 2020 at 7 a.m. And it's another attachment,
Okay. And for the record, what is that?
another Bible verse.
Okay. I'm going to scroll through. This entry here is 9:24 at 10:09 a.m.
Okay.
Can you read what that says?
9:24 at 10:09 a.m. It's from Ashley to Doug. It says quick and easy, LOL.
And his response.
His response, he emphasized quick and easy, LOL. Then at 10:26, so nice to experience quick and easy, finally, LOL.
Okay, so I'm going to scroll again. On the same date, 12:50 p.m., can you read this?
Okay, so yeah, 9:24, 12:50. This is from Doug to Ashley. It says, just to ponder while I finish up, thinking about getting all the cars up there. And I thought was to ship the Cherokee up there by transport, which is $900, and either tow my truck or tow your Jetta. The U-Haul plus the car trailer is about $1,000. That's for the biggest truck, which gives us plenty of room. The option is another pod and tow one of the cars behind my truck. Overall price about the same. U-Haul more flexibility, like taking things straight to storage.
And she says,
her reply at 127 is, okay, things to think about. Maybe best to have you drive the U-Haul and tow your truck behind. Mom and Cats will go in the Jeep, and I'll drive with Emerson in my car.
okay. I'm scrolling up again for the record. And the next day, 9:25. This is 2 days before the murder.
So 9:25 at 5:45 a.m., there's a message from Doug to Ashley, and it's another attachment.
And what is this?
It's another Bible verse.
What is the next entry?
So the next entry is 9/25/2020 at 6:03 a.m. It's from Doug to Ashley, and it appears to be another attachment.
And if you could read what this says? It's
Sure.
an attachment, but what does it say?
Live a life filled with love.
Okay. And he says, good morning.
Yes, so at 9:26 a.m., he sends her a message saying good morning.
Right. And then what is the next thing he says?
The next thing he says is at 9:27 a.m. and it says, Dr. Q is at 10:30. Do you want a chai?
Okay. And they go on talking about the tea. I'm scrolling.
And a bagel.
This is one day before. This is 9/26 of 20 at 6:43 a.m. What is this?
So this is a message again from Doug to Ashley, and it appears to be an attachment.
And what is that?
Another Bible verse.
And he says,
And he then sends her a message, good morning, at 9:40 a.m.
and she responds,
9:54, she loved the image. Then at 9:54 and 17 seconds, good morning.
okay. And then I'll scroll a little bit.
They get up hella late. 9:55 and 9:45. Don't they have a kid? How can they get up that late? When I had a kid, I was up at 6. Well, I still have kids, but still, when I had a little kid.
Oh. So this is 9/26/20 at 12:27 in the afternoon from Ashley. What does she say?
So Ashley sends a message to Doug, want to come pick me up and we can go get the truck.
And he says,
He replies, sure, heading that way. Then later, let's see, if, at 12:41, I be here.
And
Then at 9:04, good night, sweet dreams.
and she likes the image or loves the image. And
Yes.
says good night.
Love the image, and then replies good night at 9:23.
Okay. So the next day, 9/27, this entries at 6:42 a.m. What is this?
So this is
They
another
lived,
message from Doug to Ashley
She lived with
at
her
6:42, and it's another attachment.
And this must be one that we can't open. So he says after the attachment,
So at 10:02, he sends a good morning, some little emojis.
and she loves the image, and then
Love the image at 10:06. So then 10:06 and 10 seconds replies with good morning.
okay. So there are several short messages, and then at 1:03 p.m., this message appears to be from Doug. What's he say?
So Doug sends a message to Ashley, what y'all working on?
And she responds.
She replies, last cram, LOL, using the big boxes and getting the last loose stuff packed up and ready. That was at 1:15.
And then she also says,
She also says, how's it going over there? Making progress.
and his response?
His response at 1:18, loose stuff should be a chapter in our book, LOL. Got everything out and in garage, ready to throw on truck, except couch, AKA bed, pretty much emptied. Taking Sully to get his shots, then to doggy spa to get groomed and stay until ready to go.
And he says after that.
At 1:19, I'll come there and drop him off at 3.
And then she laughed at the message
Correct.
from him. She also liked the message, I'll come there after 3.
Yep.
And then what'd she say?
Then at 1:20 p.m., great. Could you run by Lowe's before you come over? Grab a few more large and mediums.
And he says,
Sure, I need a few too.
she likes that. And then she says,
She likes that. And then at 2:36, just to be safe, let's do 10 of each just for the last bits here.
and he likes that.
He likes that. And at 2:36, he also replies, okay, let me know. I'm sorry. Okay, let me know anything else if think of.
And then she says,
Tape. At 2:50, she replied tape, but then also LOL.
and he responds,
At 2:50, he says, ha, okay. Then at 2:51, just finished the vet, headed to the spa, LOL.
and she laughs. And
Correct.
then the next entry.
At 3:45, he advises that he's headed there.
And she says,
She replies at 3:51, okay.
then he says,
At 3:54, I'm out here out front. Or I'm sorry, I'm here out front.
and her response.
Her response is at 3:55, okay, 1 minute.
Okay. So he must have left at some point. This jumps 2 hours or an hour and a half. And the next entry is from Doug to Ashley and says what?
At 5:10 p.m., it says I'm about to head back.
Okay.
Then at 5:11, there's some kind of an attachment that's sent from
That we
Doug to
can't
Ashley.
And then at 5:11 p.m.
At 5:11, Doug sends another message to Ashley. Everything in except couch and 10 medium boxes and 2 cab, LOL.
And she laughs at that.
And she laughs at that at 5:14. At 5:14, she then sends a message to Doug, ha, OMG.
And he says,
And at 5:32, he sends a message back, trucker on the way.
and what time was the 911 call again?
6:56, approximately.
Okay, so what time was that?
There was a whole lot of, they didn't have a bad relationship.
I mean, that didn't seem all that.
When was Ashley arrested?
A little over a month after this occurred.
Okay. And why'd you wait so long?
we were trying to do an in-depth and thorough investigation, look at every aspect of what was going on. She had made a claim of self-defense, and we wanted to make sure that we did everything possible to either prove or disprove that.
Okay. Was a booking
Remember, they were planning to move and they weren't living together. That could be why they texted. And it's kind of like people who always update their Facebook about or their Instagram how great their relationship is. It's just before they end their relationship.
Yeah, it's usually phony baloney.
Yeah, the more people love each other on Instagram, the closer they are to a breakup. And it kind of seems like the same. Oh, good night, honey. Oh, good morning. I love you. It seems like a 16-year-old. And probably he. No, I don't want to speculate. But he's how much old? 30 years older than her. He absolutely don't understand her modern love language. And I think he just think I have to text her all the time. That's probably in his head. I don't know. I found it weird. Was she wearing shoes at the house? That's what we need to find out. I don't know.
I don't find it weird. I think like he was just, I don't know, he wanted to make it work.
Yeah, I think it's going to be very interesting because I've been watching this now for almost 5 hours, and I don't know. I don't know.
photo taken of her at the time?
Yes, ma'am.
Okay. And what was the date? Do you recall?
Not off the top of my head, Alex. It was a little over a month.
Okay. Beginning of November?
Yes.
Yes. Here. Judge, this is the certificate of business records that the state did a notice of for the booking photo of Ms. Benefield.
Okay.
Object relevance.
Relevance is she looks exactly the same as she did in the other two sets of pictures that were taken.
Okay. Go ahead, sir.
Same objection.
I'll overrule.
I'm just going to put this up.
I don't know. What number is
She
it?
I'm
looks
sorry.
like
David enter into evidence states 46.
something from The Walking
Such the
Dead.
objections that I've overruled received.
Okay. I have no further questions. Thank you. Oh, Judge, I don't know that we ever got a ruling on 45, but
No, go ahead and do your cross, and then I'll hear all of the
don't
argument.
let me forget. So
What was the number on that one?
45,
There we
the
go.
one that there's an objection?
Yes, 45. Okay.
Yeah, Medina, I think to us, we see even moderate Americans as very, very religious because we never ever talk religion. No one would ever run a we have a Christian party, but they're not. You don't even have to be a Christian to be a part of it. But it's called the Christian Party. So to us, all public religiosity is weird. We would never ever have our prime minister got punched just before an election not that long ago. They would never ever go out and say, "By the grace of God, I was saved." Like the thing we don't talk about, where he said it must have been the big guy who took care of me. You would never hear a politician in Denmark say that. That would actually be held against them. I think, because we are very, very private about our religious beliefs and how much and how little we believe. So you never ever, two things you never talk about in Denmark is your paycheck and your religion. It just don't happen. It's very,
I think
very.
it's all up. Very what?
I think it's a thing for us Scandinavian people. We don't like to talk about that because it's personal, and we are very close about stuff like that because it's a personal thing.
For sure. That's why I think like it would only seem weird it would only be weird, like if you were sending to somebody that, like, I don't know, I would make my example like me. Like, I'd be like, why are you sending me this stuff?
Yeah.
But, but if it's like two people that are like enjoy that sort of thing, then it's personal to them.
Yeah, our flag has the Nordic cross. All of our flags have it. But and we have a state-run church. Everyone who's not of a different religion is born into the church, and then you have to actively go down and say, I don't want to be a member of that church, and then you'll save. I think I pay 0.8% of my taxes goes to the church, and it's the Danish People Church. That's what it's called. But we just don't talk about it. My dad was the leader of our local church board and ran all the main board for, or what you would call it, for all the churches in my city for maybe 15 years, and you just don't you don't just don't have those public things. You don't swear on the Bible. You don't do stuff like that. I think a lot of us believe in a higher power and all of that, and are Christians, but we're just very closed about it. It's a weird. So for us, it's public displays of religiosity. Seems kind of weird,
Mm-hmm.
but that's culture.
Yeah, for sure.
So yeah, Jamie does need Jesus, but she can't remember who Jesus is.
Stop it.
Yeah, the cross we have in our flag is called the Nordic cross because it's in all the Nordic flags. Well, we actually talk more about politics than we talk about religion. We have evangelical Christians as well. Actually, where I live, we have a lot of, we call them free churches. It's churches that's not, that it's still a Christian church, but it's not directly connected to the People's Church. And we have a lot of them around where I live. We have Mormons, the Mormon temple in Odense as well. And then, of course, we have a lot of Muslims, like 16% of Denmark is Muslim now. So we have a lot of religious things, but then I think that's because they're talking about they want to have so they can call for prayers and stuff like that. And that's a big problem for a lot, even people who are very, very open to it and tolerant against stuff like that, because we just don't do it. It's and I think maybe it's because we also want to kind of harken back when we were Vikings and believed in all the gods. Nordic god names are really, it's often used for kids. Not that we also have a growing part of the population who are, it's called Asa believers, because the gods in the Nordic mythology was Asa gods. But it's just they are more open about it than a normal Christian. Yeah. No, Jamie is in the Midwest. Jamie and I just met each other randomly over on Dave's channel, and then Dave retired, and I was forced into slave labor under Jamie.
You love it.
Yeah. No, as my leader says, we don't believe every one of you are. No, but it's religion is way more. Actually, there's a book written about Denmark, I believe it's Denmark and Sweden, that's called Countries Without Gods, where a guy from America came over and looked at the phenomenon. But he found out because he said, oh, well, we must be atheists because we never ever talk about religion. And when he talked to people, he found out we might even believe more strongly about our personal beliefs in God than most of those who are standing there saying, oh, God is almighty, and we have to say it all the time. because it's such a personal belief, and we interpret our personal relationship with God. So he found we were actually more religious than American people because it's such a deep-rooted personal thing. It's something you have with your family. It's something. So that was he thought we were all would be atheists, and I think he came to the conclusion that 75% of us actually was at least as religious as Americans. So it's a fun book to read.
May I?
Yes, sir, absolutely.
Detective Warren, afternoon.
Good afternoon, sir.
So you testified that you were the lead on this case, and a couple of questions I think would be appropriate. The lead is kind of like the quarterback, no?
I have no preference in any religion. In this channel, we don't knock each other's religion, politics, gender, blah, blah, whatever. Lefty is allowed to be here, so everyone can be here.
You could say that, yes.
All right. And the lead is also the one with the most comprehensive knowledge of the investigation and how it's shaping up and where it's going.
The lead is typically the person that has the overview in mind.
So that's a yes?
I'd say we work as a team, but sure, yes.
All right.
Well, it's hard to tell because we were Christian in 9. I think they believe that we have a stone that a king put up that said, I, Hal, Bluetooth, Christian the Danes. And I believe they think that was put up in 946. But that was the royalty, and then it spread outwards after that. So Christianity took like 200 years to kind of become a thing up here, and we did it because the Germans were Christians. So we thought, let's better get to be Christians so they don't attack us.
And correct me if I'm wrong, but as the lead detective, you developed the theory of the case.
We all actually sit down and look at the evidence. Like I said, I don't go out to every scene. I go out to a lot of them, sure, but we have other individuals that do certain things. So it's really a group effort.
Well, let me ask you this. Do you remember sitting down for a deposition with me?
Yes.
And do you remember that was testimony under oath?
Yes.
You took the same oath for the deposition as you took this afternoon when you came in before Judge White, no?
Yes.
All right. Do you remember being asked the following question on page 9, paragraph 3? Okay, so as part of your responsibility as the lead detective, you would develop a theory of the case, would you not? Answer, sure.
My answer still sure.
Okay. Now, you've told us on a couple of occasions that you wanted to make sure you did a thorough and comprehensive investigation.
Is that a question?
Yes, sir.
Yes.
All right. And that is because you certainly wouldn't want to jump to a conclusion on any case, much less a homicide accusation.
That's correct.
All right. And as a result of that, you spent quite some time after this incident running down leads and doing the investigation so you could make a fair and objective determination of what, if anything, was to be charged.
Correct.
And that included you investigating self-defense and things of that nature.
Absolutely.
All right. So I'd like to ask Jack if he would assist me on this. I'd like to put up on the screen, if I can now, the warrant that you authored.
And Judge, no, Jack, is there impeachment here?
Yeah, I mean, is this impeachment?
Yes, it's coming.
We need to ask him the question.
Hold on, as to which question so far, the thorough investigation, which,
The thoroughness of the investigation, its objectivity and fairness.
okay. I think there should be some specific questions to impeach with the document. I mean, is there going to be an inconsistent statement or?
Yes, sir. Yes, sir. If you'd give me a little leeway, Your Honor, I think I will satisfy the court that the questions that I'm about to direct are appropriate, and I will tie it up.
All right. I'm not quite sure because he hasn't answered any questions about the search warrant.
What is
No, this is the arrest warrant.
The arrest warrant.
Yes, sir.
Okay.
I think the question needs to be a little more pointed. What exactly is this different than? What are you saying this is different?
Hold on,
from?
no crosstalk. Just Go ahead, put your arguments on the record.
I would like to know what exact statement is being impeached and what he's.
How do we swear in witnesses? The judge gave a speech saying, "You're here today to be a witness in a case, and as a witness in a case, you have to tell the truth. Not telling the truth can carry big consequences for you. First, the prosecutor will ask you questions, then the defendant's lawyer might ask you some questions, and it's important that you speak loud and clearly because we are on tape today." That's the speech that's given every time. If it's a police officer that said, you testified before? Yeah. So you know the rules about witnesses? Yeah. Okay. And then we just go. So we don't swear in a witness. It's illegal as a witness to lie in Denmark. So we don't have to swear in that we will tell the truth because you legally cannot lie. The only person who can, and that's a difference from America, if a defendant takes the stand in a case in Denmark, they can lie as much as they will want to do. In America, they can't do that. That's why they have to plead the fifth. But in Denmark, you are protected against. We can impeach you with prior testimony, but we can't hold you for perjury. You are perfectly allowed to lie all you want to do. So that's a big difference.
All right, thank you. Yeah, that's my question too. I'm not exactly sure what specifically you're impeaching from the testimony he's stated so far.
Okay, if the court will allow me to approach the witness,
Okay.
I think I can set the predicate.
All right.
Detectives, let me show you this document and ask you if you
Appears to be an arrest warrant. Yes, sir.
And whose arrest warrant is it?
Ashley Benefield.
And did you fill out and execute that arrest warrant?
I did.
All right. And that arrest warrant, correct me if I'm wrong, is a statement by you under oath that you took to a circuit court judge.
It is.
All right. And when we say a statement under oath, same oath again you took before you came into court this afternoon.
Yes.
And you represented to the judge that the facts stated in the attached affidavit to that arrest warrant were true and correct.
To the best of my knowledge.
Okay. Now, if I may, Your Honor, I'd like to put a select portion of that warrant up and ask him some questions.
Go ahead.
And I will demonstrate.
What's being impeached.
Well, I have to ask the question first.
Right, so.
Yes, sir,
generally
ask
the
the question and
courts
then you can
have to be in
impeach
this
him
one. So
after.
I need to know what the questions are, and then I'll need to see if that's materially different so that it could be used as a
Yes.
impeachment, as a prior inconsistent. I assume you're doing prior inconsistent statement.
Yes.
Okay.
And what I want to ask him about is first, I want to establish what he said in the warrant. And then I'm going to show that a select portion of the warrant is in fact not accurate.
All right, well, I think that's kind of putting the cart before the horse. I think we got to have the testimony here and whatever that testimony is, and then we'll figure out if there is a prior inconsistent statement.
Okay, I understand. So that is the warrant and attached affidavit that you actually served.
It appears to be.
All right. Now, everything that you had to say in there is true and correct based upon your oath.
Based upon everything I know to the best of my knowledge.
Would you tell Judge White whether or not prior to you submitting this affidavit, you authored two prior affidavits, two versions?
What do you mean two versions?
Did you author two separate and independent versions of that affidavit before you finally settled on the one that is before you?
I worked on the arrest warrants.
That man is the defense. It's two female prosecutors.
So I don't think I ever sent anything up. This was the first time.
No? Okay. So you know about Florida's public records law, do you?
Sure.
All right. And you know it applies to the Manatee County Sheriff's Office as well.
Absolutely.
All right. So let's see if you can identify this.
If I could just see it. Judge, first off, I would object. This is a conversation between me and the witness about drafting the warrant. It has nothing to do with what he submitted to the court. This is conversation between he and I about how it should be phrased. So I don't really understand what's being done right now.
Your Honor, these are two proposed prior warrants of the same version that was actually filed that are statements of this witness. And I'm going to show the court the difference between them and what was intentionally misrepresented and intentionally omitted.
To the court?
To the court that signed the actual warrant. In other words, I'm going to show that this witness has materially made prior statements inconsistent with that warrant, and that there were things intentionally omitted from that warrant that were previously included in the other warrants.
All right, so this is where I'm getting confused. If we're going to impeach with a prior inconsistent statement, I don't think you can start that process with an out-of-court statement and then impeach with prior inconsistent statements. It's my understanding we've got the testimony here today, whatever that might be, and then there might be prior inconsistent statements, inconsistent omissions, commissions, who knows? But I'm not familiar with this. Do you have some cases about impeaching a witness who hasn't yet made any statements using 3 potentially disparate out-of-court statements?
Well, I think, Judge, if I can break it down for the court, I think we've had a statement by this witness on direct to the effect that this case took time because this detective wanted to be objective and fair and make certain that a proper investigation was done. And I am going to impeach that statement by showing that he knew otherwise and had already concluded otherwise, and that the statements delivered today in front of this court are false. And I can do that through his prior inconsistent statements.
Can I have them?
Absolutely. Your Honor.
Possibly, if they were prior inconsistent statements, but
I don't know.
I would just also ask for a copy for the state. These were never provided in discovery. I just took pictures of one of them on my phone so I can at least read it, but the other one we've never seen except for briefly this morning.
Are you asking for a Richardson hearing?
I'm just asking if it's possible for defense counsel to provide us copies or something so we know exactly what's going on. We may have just gotten.
Can I suggest maybe, Your Honor,
Yes.
the court excuse the witness?
Sure.
And we take-
Detective Warren?
Yes, sir.
The rule's been invoked, so I'm
Yes,
going to
sir.
have you step outside.
Sure.
Please don't discuss your testimony with anybody, your answers, the question to ask, anything like that. All
Yes,
right?
sir. Thank you.
This is getting spicy now. So before he even asked him a question, he want to say that he lied.
Can I assist the court by leading the court through what I intend to establish?
Well, let me read these first.
Sure.
He just
It's
said,
the
let me read
highlighted
it.
portions, Your Honor, in particular, that I plan to go to
Highlighted portions of must be.
the proposed affidavit.
They're not,
Yeah.
first of all, Judge, we need to make clear that these are not sworn affidavits. These are emails. So these are not sworn to documents. It's just the proposed. This is the proposed body of.
Thank you, young
I
black
understand.
economist. Oh, Medina Finn asked earlier, I believe, what this case is about. This is a year-old stand your ground hearing. It's something special they have in Florida, where if you unalive someone, you can you have this hearing to see if it's justified. This lady claims she unalived her kinda on-off husband because she was afraid of him, and then they had having a stand your ground hearing. We're covering the case next week, so I think you can all kind of guess, even if I don't spoil it, where this stand your ground hearing will end. But we thought, because we really didn't watch this trial last year, so we wanted to get into it. And it's been interesting so far, I would say. We watched 6 hours, and it's been really interesting, actually.
Yeah, actually, it's kind of flown by. I didn't realize it's been 6 hours.
Well, it's only been 5, but we could speed it up for once because I didn't take an hour
Well, yeah.
lunch break.
But still, not that bad.
Yeah, I give her a break. I love Justified. That's such a great. I haven't seen
That
the
is
new
a
ones. I'm
great
afraid
show.
to ruin it.
I love that show.
Have you seen the new one?
Not the new one, the old one.
No. I really love the old one.
That's good.
I love that when the first episode, where he's doing all his white power crap. He goes up to him and says, "Yeah, I know it's just a stick." Apparently, that's the actor who said, "I don't want to portray a," and he said, "Well, we'll write it in." So, yeah. But Justified, that's a great show.
Mhm.
That's
Highly
I wish I
recommend.
could wear a cowboy hat. I want a cowboy hat.
Okay. Opponent?
Yeah,
You
so
want to
here's what I would,
impeach the detective with the
That's out of
highlighted
10.
portions of what I'm holding in my hands.
yeah, let me walk the court through it if I may. If the court looks at the proposed warrant of November 2nd at 2:06 in the afternoon,
Yes.
the court will see in the highlighted portion on the second page that the detective says the day before the shooting, Barbara Russell, Doug Benefield scraped Ashley Benefield with a box. Then if the court looks at the second proposed warrant, which is approximately an hour
on
and a half
accident?
later on 11/2/20 at 3:37 p.m., instead of Barbara Russell, her name is now removed and she's no longer an identifiable witness. Now it says the day before a witness, and it says Doug Benefield scraped Ashley Benefield with a box. Then if the court looks at the actual warrant that is submitted on 11/4/20, it says, Judge White, the day before the shooting, a witness, no longer Barbara Russell, explained that Ashley Benefield was inadvertently scratched when someone, no longer Douglas Benefield, but someone walked by her carrying a box. This witness before the court, Your Honor, sought a waiver so that he could speak with Dr. Russell. He got the waiver and he spoke with Dr. Russell. And Dr. Russell told him, and he admitted in his deposition to me, that she told him that Douglas Benefield was increasingly rough and would body check Ashley Benefield with a box, that he would slam it against her, and that it happened on the day of the shooting. And what is in those affidavits, both the actual and the proposed, is not that at all. When a detective comes to the court with a proposed warrant, it's not unusual that the court might ask some questions. And in this instance, if the court saw in the affidavit that it was Douglas Benefield who slammed Ashley Benefield with a cardboard box, the court might ask, being astute and street smart, a question such as, what was the relationship between these two? Are they siblings or are they husband and wife? And when told they are husband and wife, Your Honor might say, well, is there a history of domestic violence here? And if the answer to that was yes, then the court might say, could this be a self-defense situation? The point being that the detective might have left without that warrant being signed. I think this is clearly in contradiction to what he's testified to about a fair and objective investigation that went on for several weeks before he submits this actual warrant. So I propose to ask him about his actual warrant and then go back and go over the two proposed warrants to show what he left out and ask him why he left it out. And if he did not think that relevant to a judge that he was submitting the statement under oath to.
To prove or disprove what material fact? How is this material?
That this was anything but a fair investigation and a diligent investigation in direct contradiction to what he has told us here today. And just so the court knows, this is not my only point. I have coming behind it even stronger.
All right, final thoughts?
Just to be perfectly honest, I have no idea what we're talking about. The witness was not asked anything that was inconsistent with anything he said before. If the defense wants to try to disprove that it was a thorough and accurate investigation, then the defense can put on evidence in their own case. I don't think bringing in extrinsic evidence, I don't think the evidence is appropriate evidence to use for that purpose anyway. But even if it were allowed in, I don't know that you could do this extrinsic evidence at this point to impeach him for, I said I did a thorough job, but no, you didn't. I'm just a little confused by that. So I would object to any of this coming in at this moment. Sorry.
Yeah, both George Zimmerman, did he get his stand your ground? No, he went to trial. Yeah, and
Pretty much.
Travis Rudolph
True
also
effort.
had a stand your ground, which I think on the basis of what we saw in trial, he should have been granted it. So I think it's kind of like, what would you call it? In Denmark, we call it like it's just to put on an act to try and say, oh, we followed the rules, but they just take it to a normal trial most of the time either way. So yeah, so that's I think actually didn't Branca said every state kind of have a no duty to retreat rule. So I don't know. But I think, what would you? Yeah, it feels more like they're putting on a show in most cases because they wanted the judge won't grant it, and who have successfully had a stand your ground motion filed. Okay.
Interesting.
Vikings only until he goes away. Then when the kids takes over, it becomes so bad.
I just don't know what rule of evidence we're
My squirrel just saw
Goes
something.
directly to bias of this witness who testified on direct. I didn't ask the question. The prosecutor asked the question, why did it take so long for you to get this warrant? Because we wanted to do a fair and objective investigation. That was what he testified to. And I am going to show with his own statements that that was not the case. It surely goes directly to this witness's bias and motive. And I have additional very strong evidence, Your Honor, to support that as well.
All right. Well, whenever I start doing an analysis of these kind of arguments, what I want to hear is, well, what are you trying to do? Because that informs me to which folder to go to open up to see what's the predicate that needs to be laid and then what's the procedure for doing something. I don't see this as impeachment by prior inconsistent statement. Because I don't think, yes, he said I did a thorough job, but I don't think that is
fair
necessarily then opens the door to, well, why did you put a comma here and not here? And I'm being a bit melodramatic on that point, but because as I look at some of the highlights on the papers you've handed up, I mean, it's really a simple matter of just reordering some of the words. Now, on the issue of the Dr. Russell, I see we're in the 2:06 p.m. email, Dr. Russell is mentioned.
Correct.
In the 3:37 email, Dr. Russell's name is now a witness.
Correct.
And I'm trying to look amongst all the talking at the actual arrest warrant that was submitted. It looks like it was attested to November 4th of 2020.
Yes.
I'm not seeing the incident with the.
I can show the court. I have it more. Yeah.
Yes.
I think, Judge, what distinguishes it from something that's inadvertent clearly is not only is Douglas Benefield now removed from the actual warrant as being the one who scraped Ashley Benefield with the box, but now there is the statement that that whoever this person was inadvertently scratched her with the box. And that is in direct contradiction to what this witness was told prior to him filing that arrest warrant. He asked for
He was found not guilty, so yeah, he was actually innocent.
Waiver, which was given to him so he could interview several psychologists. He went and interviewed Dr. Russell. he acknowledged in deposition to me that Dr. Russell told him it was Doug Benefield and that he was becoming increasingly objective on that date by slamming a cardboard box into Ashley Benefield as he passed her in the hallway. And it was on the day of the incident, not the day before.
Right. But that testimony itself, you're just introducing that's what he was told, not for the truth of that's what happened.
Correct.
Okay, because that would be, how many layers of hearsay? Three or four?
No, look, I'm trying to show what he knew. Because he's the one who filed the affidavit, Your Honor.
Yeah, so I'll allow it for the very limited purposes of the fact that if you think that this shows that, and you're going to link this up, that he didn't do a thorough investigation, okay, we'll see.
I will link it.
But, I mean,
I'll link it up.
yeah.
I like this judge.
I don't know about you guys, but when I write an order, there might be 4 versions of it as I go through.
Well, Judge, at the risk of embarrassing the court, as far as Your Honor's authorship of orders, I have never seen an order like the order that the court wrote for the motion to compel.
Well, that could be taken 2 ways. couldn't it?
I've never seen a better order, Your Honor, or more thorough.
Enough of platitudes. All right.
I would just like to object to him using emails between he and I discussing probable cause as some form of, I don't understand.
Ms. O'Donnell, I'm not quite sure yet either,
Okay.
but we spent a lot of time on this.
Yes.
I want to keep plowing through. I think I'll be able to figure it out when we get to the end of this. I'm pretty sure I'll be able to figure it out and where this fits in, and I will put it in its proper place and give it its proper weight. All right.
Thank you, Judge. And just for the record, I have no intention of involving Ms. O'Donnell in this. It's
Yeah,
going
because
to
if
be,
you call her as a witness, we got a problem.
it's going to be limited strictly to the.
All right. You can, but that's a monkey wrench.
We're not going down there.
All right.
She's been very professional.
Yes, I'm sorry. I apologize. Yes, sir. He was standing at the door waiting on me. Oops.
Jack.
Yeah, we'll allow it. I tell you what, though, let's not plow this earth too many times. Let's plow it, make your points,
And move on.
get in and get out.
And I think you'll find I
All
will
right.
do
Thank you.
exactly that.
I have to do it again.
Giggity, giggity, giggity.
Just plow it and get out of there.
Just plow it too many times. Just get in and get out of there. It's
Giggity, giggity, giggity.
All right, so take your seat. You're still under oath?
Yes, sir.
As you're approaching your seat, did anybody talk with you about your testimony or discuss anything with you?
No, sir.
All right, sir, have a seat. For your purposes, from where you left off, I have overruled the state's objection. Mr. Taylor has some questions for you.
Sure.
All right, Detective Warren, I'm going to put your actual warrant up on the screen. The affidavit. You recognize it, no?
Yes, sir.
Okay. Are you able to see it?
It's a little blurry.
Okay.
Oh, Carol.
Yes.
Thank you.
Let me give you his actual copy.
Okay.
So that'll assist you. Now, this was the affidavit that you took to the judge, correct?
Yes, sir.
All right. So I've highlighted on that affidavit in that particular paragraph that you see, and I have a couple of things boxed in red, correct?
Yes.
All right. I want to ask you about them. Does it say that upon further investigation, hold on a second. All right, does it say, Detective, in the third sentence of the top paragraph, upon further investigation, a witness explained that Ashley had obtained the scratch on her right side the day before the shooting when she was inadvertently scratched when someone walked by her carrying a box?
So in the fourth sentence, I do see that it says that, yes.
All right, now, I'm going to pass to you a document and ask you if you recognize it.
Appears to be an email from myself.
Don't tell me what it is. I'm just going to ask you some questions.
Okay.
Does that document contain a proposed affidavit that was written by you?
There is an attachment to it. I mean, I can't say indefinitely that's the same one that was sent with it, but there is an attachment to it.
All right. Now, that document was sent on November 2nd, 2020 at 2:06 p.m. in the afternoon, correct?
According to the email you've provided me with, yes, sir.
All right. And if you would turn to the proposed affidavit that's attached to that
Was he wearing a shirt today?
document that I just handed you,
Okay.
not the actual warrant,
Yeah, correct.
the email of,
The alleged attachment, yes, sir.
yeah. All right. So if you would tell me, instead of it saying now, a witness explained, is in that proposed affidavit, does it say Barbara Russell?
Oh, I'm sorry. Yes. So on the second page, we conduct an interview with Barbara Russell.
Okay. Now, Barbara Russell, her name has been removed from the actual affidavit, has it not?
Yes.
All right. Does it also then say that Douglas Benefield scraped Ashley Benefield with a box?
It does.
Okay. And going back to your actual warrant, does it say Douglas Benefield in your actual warrant?
No, it says someone,
Someone.
which
Okay.
could mean Douglas Benefield.
All right. And does it also say in your actual warrant that that someone who scratched Ashley Benefield with a box did so inadvertently?
While walking by. Yes.
Now, do you remember, as part of your investigation, you obtained a waiver for you to be able to go speak with Dr. Russell?
That's correct.
And that included also a waiver for Dr. Quintal?
Yes.
All right. Is it not a fact that you admitted to me that in your conversation with Dr. Russell, before you filed this actual affidavit to your warrant, that she told you that Douglas Benefield had become increasingly rough and would body check Ashley Benefield with a box?
I think those were your words.
And did you not agree to them?
I'd have to go back and listen to the interview. I apologize, sir.
Did you prepare to come here today to testify?
I did, sir.
You chose not to listen to it?
Objection.
Sustained.
Do you recall being asked the following question on page 23, line 14? This is your deposition of May 16th, correct?
I don't know. I don't have a copy of it in front of me, sir.
May I approach the witness, Your Honor?
Yes.
May 16th of 23. Okay.
All right. You recall being asked the following question. All right. And does it say on there, starting on line 11, so she said, this is Dr. Russell, so she said he had become increasingly rough, like he'd pick up a box to move it, pass her in the hallway, body check her. Your answer, that's what it says. You want to see it?
No.
All right. Then the next question, all right, do you recall her making that statement to you? Your answer, vaguely. You recall that?
Yeah, I still vaguely remember that.
Can I just ask for verification of what you were referring to, the first question? The first question was, you said this excerpt says, what was the excerpt that you were looking at?
That Dr. Russell had, may I respond?
Yeah, you're going to have to because I don't know what we're talking about either.
The excerpt was that Dr. Russell had told the witness that Douglas Benefield had intentionally slammed the cardboard box.
Excerpt from what? Excerpted
from Dr. Russell's statement that this witness took. I was questioning him about the statement that he took from Dr. Russell. And I asked him, is it not a fact that this is what Dr. Russell told you? And that was the answer that he gave.
And this is where I was concerned. We're now impeaching with a prior inconsistent statement, conceivably. Statements that they were made in one version, but not the other version, and left out of another version, or changed in another version. And you're impeaching with a statement from an out-of-court statement from this witness received from a doctor who I haven't heard from that was made to her, presumably by the defendant.
No.
So we're just so far afield. And this is where I was saying, make your point and get out, because I've tried to give you that wide berth, but
I'm on my way out, Judge.
Okay.
All right.
I'm really confused with this defense lawyer.
Yeah.
I liked him in the beginning, but he seems like he's really grasping at some straws, and he's making really difficult. Maybe it's because it's almost 10 o'clock, but
Well, no,
Oh.
he's just harping on something that
yeah,
I
it
don't
seems
agree
really
that is so not a
irrelevant.
big deal. Like, it sounds like the same thing, just worded differently, but it's not any different. I don't know. Okay.
Yeah, and Marissa is looking for that case. They are actually giving opening statements in that case right now. So I think we're gonna today we're gonna finish this witness, and then I'll see if I play the rest of this tomorrow, or we'll start on the other case because they can't do much more than opening statements today. It's 6:30 and no 3:30 in Florida.
I get the point you're trying to make.
Yep, okay.
The point is, this witness has made multiple prior different statements.
Yeah, and again, it's triple hearsay. He wants the lead investigator to testify that that Ashley told the neighbor that Doc hit her multiple times when passing by her in the hallway.
Yeah, it was like body checking her with a box.
Yeah, body checking her. And that he put that in one report but didn't put it in another report. Didn't get Dr. Russell on the stand and let her testify that Ashley told her. But again, it doesn't prove he did it. It'll be he can put Ashley on the stage testifying that she told Dr. Russell. But again, it's triple, at least double hearsay.
Spoke with the state, changed it again, left out some what you believe to be material details. I get it.
Okay.
The message is clearly received if that's the point you're trying to make.
Thank you.
I just believe there's going to be numerous things like we're dealing with right now with this cross-examination.
Let's see how I do,
Grenade.
Your Honor.
Okay.
All right. When you bring an arrest warrant to a judge, are you ever asked questions before it's signed?
Excuse me, what kind of questions are you referring to and by whom?
Have you ever been asked questions by a judge?
No, this trial is starting Monday. This is a stand your ground hearing from last year. We're just watching it to get into the case because we didn't cover it the first time. Quick synopsis. Did she put 2 new holes in her estranged, kind of not estranged husband because she was afraid of him, or maybe because she didn't like him and wanted to put 2 new holes in him? That's the case summarized. They had an on-off relationship. There's 30 years difference between them. They got divorced, got back together, was maybe moving to Maryland, maybe not moving to. It's very confusing, and I've been watching it for 5 hours, and I'm more confused now than I was in the beginning.
About a warrant that you have brought for signature?
Sir, I've submitted numerous warrants. Most of the time we don't talk to the judge.
You've never been questioned by a judge?
Most of the time we don't. Most of the time it's submitted via e-warrants, which is an electronic system.
And it's never happened to you as your testimony?
Oh, I'm not going to say I've never talked to a judge. I just don't recall an incident off the top of my head.
All right. Let's talk about the wounds to Douglas Benefield and your perception of how they occurred. You stated, did you not, in your affidavit, that based upon the entrance wounds to Douglas Benefield, it does not appear that he was facing Ashley Benefield when she began shooting?
Objection is impeachment.
Sustained.
Did you draw any conclusion as to whether or not Douglas Benefield was facing Ashley Benefield when he was shot?
Do you want me to read the warrant?
No.
No, so this is just
Okay.
testimony.
Just answer the question.
So yes, based on my observations and the work of the team that was assigned to work this case, it appeared that he was not facing her at that time.
Okay. And you know that the medical examiner said that he was?
I don't know what the medical examiner said, sir. I wasn't in here.
Oh, you've never seen the medical examiner's report?
Sustained.
I have seen the medical
Hold on,
examiner's.
no, I sustained it.
Sorry.
It's improper impeachment to impeach this witness with the statement of an out-of-court statement of another witness.
Did you contact the medical examiner's office before you secured and drafted the final version of this warrant?
No. I did not. A detective would have been present at the autopsy, though.
Do you dispute now, as you sit here today, that Mr. Benefield was facing Ashley Benefield when he was shot?
Oh,
Relevance of his opinion.
Well, I think he's made the one conclusion. I think he could be asked, do you have the same conclusion today? So overruled.
Thank you.
I don't dispute anything the doctor said. He's the ultimate person that would give you that answer.
All right. Now, you also concluded that the wound to the right leg was from the outside of the leg to the inside. Is that correct?
Again, I don't recall ever hearing him testify to that fact. So I don't know where that's coming from. I have not heard this from his mouth.
Did you reach a conclusion as to the direction of the gunshot to the deceased's right leg?
No.
Objection relevance of his interpretation of the direction of that wound. The state is the one that filed the charge, not the detective. So.
All right, I appreciate it. Overruled. If you can answer.
Sure.
I'm sorry, can you repeat the question?
Did you reach a conclusion, Detective Warren, as to the gunshot wound to the deceased's right leg?
Okay.
Okay, yes, you.
As to the direction?
Yes.
So like I said, I would defer to the doctor, to be honest with you. I think he has the best opinion on that.
I understand and I appreciate that, but I'm interested in what your conclusion was.
So based on my observations, I wasn't there when he was there and I never saw him in person, would be that the right side of his body was facing Mrs. Benefield.
That's not the question I asked you, Detective. Did you not understand it?
Apparently not. Can you repeat it, sir?
So my question to you is, did you reach a conclusion as to the gunshot wound to Mr. Benefield's right leg?
Based on what I saw and everything at the scene, I believe that his right side was facing her. So that would have been what was struck first.
Did you state that the entry to the leg wound was on the outside of the knee and the exit was on the inside?
I could refer back to the warrant if you'd like, sir.
Please. If that helps refresh your recollection.
Sustained. Well, if he's refreshing recollection, that's a different issue.
Yes.
But
refer to your warrant,
Me
Detective,
too,
see if that
Goddess.
refreshes your recollection.
Oh, shoot.
So in my affidavit for the warrant, if one of the rounds entered the outside of the right leg and exited the inside of the right leg, that was based on what I was observing.
And as you sit here today, is that still your position that the entry wound was on the outside of the right knee and the exit wound was on the inside as opposed to it being reversed?
Based on my training experience, what I observed, sure. But like I said, I would always defer to the doctor. I would never argue with a medical expert.
So I would assume then you would defer to the doctor as well as it relates to the proposed wound to the arm.
Absolutely.
All right. So you got wrong. One, whether or not Mr. Benefield was facing Ashley Benefield when he was shot, correct?
sustained and
All right. Your conclusion was inaccurate.
sustained.
All right, moving on. You told us that you observed Miss Benefield that night, and you did not see any signs of domestic violence, struggle, or things of that nature, such as torn clothing.
That's accurate.
Okay. And is that, in your experience, always the case with domestic disputes?
No, not always.
All right. And you're aware that the shirt that you observed on Miss Benefield that night, where it came from?
I'm sorry, which shirt are you referring to?
You said that you did not observe any torn clothing on Miss Benefield that night.
I did not.
Like her shirt was not torn, her shirt wasn't torn.
I didn't see anything, no.
Okay. Where did the shirt that you remarked that you didn't see torn come from? Do you know?
I have no idea where she purchased the shirt or where she got it, sir.
Isn't it a fact, Detective? Now, you're the lead detective, correct?
Sure.
That shirt was brought to her by another deputy while she was sitting in a squad car, was it not? That would be Deputy
I wasn't at the
Hall.
scene, sir.
But wouldn't that be something you'd be expected?
I don't know if it is or not. Let him finish the question.
Wouldn't that be something as the lead detective you would be expected to know before you make the statement that you didn't observe any torn clothing, which is inconsistent with domestic violence?
No, and I think if you actually play it back, I already testified to the fact that she was wearing a sports bra.
All right. I want.
Marissa, Was it Ashley you saw at the house at the school today? This is a throwback 4 hours back when Marissa talked about sport bars.
Let me ask you a couple of questions about the home.
I remember
You
stuff.
drafted a search warrant for the house, correct?
That's accurate.
All right. And you drafted that search warrant pretty much immediately based on your experience of knowing that you wanted to get into the house to conduct the investigation.
I drafted that search warrant based on the other detectives on scene advising there was probable cause to assume that a potential homicide occurred inside. Yes, sir.
Okay. Now, I'm glad you referred it that way, because isn't it a fact that that warrant that you were drafting less than 75 minutes after the shooting, isn't it a fact that you didn't describe it as a homicide, you described it as a murder? Did you not?
I'd have to look at the warrant again, but that's
I'll be
possible.
happy
Sure.
to show it to you.
Yeah.
Understand the difference.
So what's the relevance?
I think the relevance is to show that this detective had already reached a conclusion that this was a crime rather than a homicide, despite his testimony that he wanted to do a fair and objective
I don't know. I think it will.
investigation over the course of an extended period of time, and that he was referring.
Like I said before, I get so confused because he wants to put in triple hearsay. He wants to put in stuff that's not in official reports. Again, working papers where you are spitballing ideas is not the same as your final product, and he won't let go of it. That's my biggest problem.
To it and
Yeah.
calling it a murder within approximately 75 minutes following the incident.
All right.
He'd already made his mind.
Detective Warren, can you step out in the hallway? It's easier if you step, we can send you out.
That's not a
It's easier
problem,
than having them approach.
Not a problem, sir.
The rules may revoke, don't discuss your testimony, don't let anybody talk to you about your testimony.
Yes, sir.
All right. So I don't think I have the search warrant, unless it was one of the attachments. I don't recall seeing it.
I'll give the court a copy.
Well, let me ask you this. So the point you're making is that instead of using the word homicide as the crime that's being investigated, the detective used murder.
Yes, and
So what statute would you have proposed that he should have used? Because as we know, a search warrant, what's the point of a search warrant? That a crime's occurred or is occurring or has occurred, and that there's probable cause or a reasonable probability that the fruits of that crime or the evidence of that crime is going to be found within the place. So I don't think I have the search warrant, unless it was one of the attachments. I don't recall seeing it.
I'll give the court a copy.
Well, let me ask you this. So the point you're making is that instead of using the word homicide as the crime that's being investigated, the detective used murder.
Yes, and
So what statute would you have proposed that he should have used? Because as we know, a search warrant, what's the point of a search warrant? That a crime's occurred or is occurring or has occurred, and that there's probable cause or a reasonable probability that the fruits of that crime or the evidence of that crime is going to be found within the place to be searched.
yes,
So a search warrant will list a crime or crimes that have alleged to have been committed. So what I'm saying is, what is your argument that he should have put as opposed to murder with 78204?
Yes, sir.
Yeah.
As opposed to 78204?
my argument is that every single member of the Manatee County Sheriff's Office but him described this as a homicide, including the medical examiner, rather than a murder. But that's not enough. This detective, in his deposition to me, believe it or not, under oath, said and represented that every homicide is a murder, and anybody who shoots and kills somebody is a murderer. That is his perception of murder. As opposed to an objective evaluation, what I am tying in is that within 75 minutes after this incident occurred, this detective had already decided that my client had committed murder. That's what I want to bring out.
All right. I appreciate all that. I'm happy to receive that. I'm going to respectfully, as you said today several times, suggest that there is a much more direct route to get where you want to go. There's no jury here, so, impeach, but,
Okay,
okay, so I think you
I got
can
it.
get there. I think we can be a little bit more direct about it.
yes,
Um,
I understand.
Almost there.
I'll go right to it.
I think, you want to say, hey, you said murder in your
Right.
search warrant. Yes, I did.
Yep.
That was within 75 minutes of being called out. Yes, it was. And then you can make all those arguments you want to make about how that was biased and his mind was made up and it was predisposed, how this was going to go. And I'll receive all of that.
Understood.
Okay. There was one other issue you were asking about.
But before we move on from that, just so I can understand from defense counsel is, because I'm looking at the actual search warrant and the only time it refers to murder is where it says the statute number. Is that the only instance in which he's referring, or is there some other? I couldn't find another one. I just want to make sure before we continue that we understand.
I assume that's the issue.
Okay,
Right.
thank you. I just want to make sure.
All right.
I think we can bring him in.
Yes, he's on his way.
Yeah, just ask, did you put murder in there?
All right, Detective Warren, take your seat back. Did anybody discuss your testimony with me, approach you, try and talk with you?
No, sir.
All right. So I have sustained the state's last objection. Mr. Taylor.
So Detective, you described.
When you
the-
have him when you have him sped up, he looks so happy when he's walking in. It makes me laugh.
incident that you were investigating within 75 minutes of it happening as a murder.
In the search warrant?
Yes.
Sure.
All right.
I think all of our search warrants actually are for the same thing when
You
we're
did the
investigating
same-
murders.
You did the same thing for 2 other search warrants.
Yes, sir. That's what our unit investigates are murders.
Now, did you tell me under oath that every homicide is a murder?
I believe I might have misspoke when I said that, but so basically the intentional killing, unlawful and intentional killing of a human being is a murder, yes.
Did you tell me, just to make sure that it wasn't a mistake, did you not tell me that anyone who kills is a murderer?
Well, there's differences in whether it being
Is the
justified or
answer to
not.
my question yes?
Objection, is this impeachment and is
I'm going to sustain.
Thank you.
Again, I think when we're impeaching with a prior inconsistent statement, we don't lead with the out-of-court statement that might be inconsistent. I would need to hear the testimony here today, what the answer is, and then I can determine if the prior statement is inconsistent.
Thank you
So
for
I'll
being here,
sustain.
Neil Mac.
Do you remember me asking you at the deposition the following question? On page 11, line 20, you could have a homicide that's,
objection and proper impeachment.
I'm going to sustain. I need the answer. I need an answer here in open court, and then we can discuss whether that's a prior inconsistent statement.
are all homicides murders?
The unlawful killing of a human being is a murder. Yes, sir. There are some cases where it may be justified.
It may also be excusable.
Sure.
Is everybody then who kills a murderer?
And that's a matter of opinion, I guess. But I mean, by the definition, a murder is the unlawful killing of a human being.
Is it your statement that anyone who kills is a murderer?
Objection, asked and answered.
Sustain.
I really like this judge. He's yeah, he gives them enough rope and then he reels it back. I don't know, Moon Goddess. I get confused.
Would you be surprised to learn that you were the only one
Objection.
Let the question finish, please. Go ahead,
in
sir.
the Manatee County Sheriff's Office throughout this case who designated it as a murder as opposed to a homicide?
Don't answer. Sustained.
I don't see him as being evasive, but I see the question being stupid.
Another
Yeah.
interview that
I don't know.
you did was of Dr. Quintal, was it not?
I did an interview with Dr. Quintal, yes.
And you conducted that interview pursuant to a waiver that was given to you by Ashley Benefield so that Dr. Quintal could share with you the health information that he derived from interviewing Ashley Benefield, correct?
Yes, sir. We were trying to gain an idea of what their relationship was like.
Did you learn during your interview with Dr. Quintal that Ashley Benefield was afraid of Douglas Benefield.
He may have made some statements indicating that she made some, or he had some feeling about that.
Did you learn that she was scared of violence from him?
I don't, like I said, he said a lot of things. He also said he didn't understand why Douglas was with her.
Did you learn that Dr. Quintal
A lot of lawyer arguing, and not really anything useful.
told you that Douglas Benefield was a controller?
Objection, this is.
Sustained.
Not offered for the truth, Your Honor, offered for what this witness learned and knew during the course of his investigation.
And that's.
Well, what does that have to do with, I'm not understanding what the relevance of that is. That a doctor told this witness that the defendant said the victim was
Not the defendant,
controlling.
Your Honor, that Douglas Benefield, the victim,
Right,
was a controller.
right. But the doctor would have heard that from the defendant?
Yes,
All
but
right.
it's also the doctor's opinion. He was giving this detective his opinion of Douglas Benefield, and he was describing Douglas Benefield to this detective. And there's a reason why I'm asking. I'm going to follow up with the question.
It sounds like you're offering that for the truth.
No, sir. I think you'll see why I want to show that this witness was aware of this.
Okay, I don't know, but we're going to see.
I will tie it up for the
Okay.
court very quickly. Do you recall Dr. Quintal telling you that he believed that Douglas Benefield was a fake who used God as a pretense?
I remember the topic of God did come up. I don't remember, like I said, every word that he said verbatim, which is why it would have been tape recorded.
And you have that recording, do you know?
You should have it as well. Yes, sir.
Yeah. And do you recall Dr. Quintal telling you that Douglas Benefield?
Yeah, listen, I'm really, sir, not understanding. I mean, what is the point of all of this?
Next question. If Douglas Benefield had a violent background, is that something that you would want to know?
Sure.
Is that something that would be significant for purposes of your investigation?
One of the things that we looked at was he violent with her? That's why we went through all of the reports. We wanted to know the background because, as I stated earlier, we wanted to do a thorough and accurate investigation before anybody was charged with a crime.
Would you tell His Honor, Judge White, whether you ever did a background investigation to determine whether or not Douglas Benefield was violent?
We did searches based on what was available through the Manatee County Records database. And I believe we also got some information from Charleston or somewhere up, one of those places up there where there were some allegations, but that was it.
Do you remember me asking you this question at your deposition?
Well, I don't know if it is yet. It might be inconsistent with the statement that was just made about the investigation that was done, but I don't know.
I asked the question. Do you remember being asked the following question on page 84, line 16? When you investigate a case like this, you told me that you don't recall whether or not you did a background on Douglas Benefield himself. Your answer was, I don't recall doing it myself. No.
You're talking about a background, meaning the criminal history. I don't recall doing a criminal history on Douglas Benefield to see if he was a convicted felon, but a background check, it's actually listed, I believe, in some of these other reports where we looked up Manatee County computer records databases and pulled those reports.
So is it your position, Detective Warren, that only convicted felons can have violent backgrounds?
I've overruled.
Thank you.
If you repeat the question.
Is that what you're telling us?
Can you repeat the question?
Yes.
Thank
The
you.
question was, are you telling us that only convicted felons can have violent backgrounds?
No, but there is a difference between doing a computer record check through our personal database and doing a criminal history check through NCIC, FCIC.
So let me ask you the question again, but perhaps you didn't understand it.
Perhaps.
Did you ever do,
It's the same.
did you ever do a background investigation to determine what you've told us you would want to know, whether or not Douglas Benefield was prone to violence?
Like I told you, sir, we did searches to find out what information was available. You can change the definition of background check all you want to. Yes, we did our due diligence.
Have you read, by the way, have you had an opportunity to read or discuss the stand your ground motion we filed with the prosecution?
I did, but it was months back, I'm sure.
There's a representation that Douglas Benefield grabbed Mrs. Benefield by the left hand to prevent her from leaving. Do you recall that?
No, not off the top of my head, sir.
All right. You, as part of your duties and responsibilities as the lead detective on the case, requested swabs, did you not, of
did.
various parts of Miss Benefield?
We did.
All right, and that would include her left hand, would it not?
It would have included the areas that we were explained by her attorneys to pay the most attention to.
Did it include her left hand, detective?
You would have to probably direct that towards the crime scene tech that collected the swabs.
Well, how about if I use your report?
Okay.
Objection, Judge.
Yeah, if he's just relating what someone else said or did,
No,
I'm going to sustain.
I'm asking if he requested that swabs be taken of her left hand.
Okay,
That was the
that question can be asked.
That was the question. Did you request swabs be taken of Miss Benefield's left hand?
I requested the swabs be taken of her arms, legs, hands, and neck.
Okay. As part of your duties and responsibilities as a lead detective, did you ever get the laboratory results of those swabs from FDLE, Florida Department of Law Enforcement?
Was it FDLE or DNA Labs International?
Actually, I believe it was DNA Labs International. I stand corrected.
Okay.
Did you get the results back?
Yes.
Did you learn that out of all the people in the world,
Objection to asking this witness about the results of it even.
Again, you can ask your question and then we'll have the objection. Again, I make this ruling because there's no jury here.
I know.
So if I sustain it, I sustain it.
But he's testifying by asking the question.
well, did you learn that of all the people in the world, only 2 people could not be ruled out for having left DNA on Miss Benefield's left hand? John Sant, the neighbor, and Douglas Benefield.
I would.
No, do you have an objection?
Yes, that calls for hearsay and
Sustained.
misrepresentation of the report.
I haven't seen the report, but it's hearsay. Absolutely.
All right, Detective, I have a few questions now I'd like to ask you about some areas that we discussed previously under oath. I had asked you at the deposition various things about Douglas Benefield. For example, in
I don't know.
I gotta say the question.
Yeah, so a deposition is an out-of-court statement, which is the first phase of hearsay. I don't know why it's going to be offered, but I don't know if you're refreshing our recollection, which is done a different way. I don't know if you're impeaching. If you're impeaching with a prior consistent statement, all I can say is, again, I need a statement here in open court, and then we can figure out if that prior statement was inconsistent.
Here comes the statement. Detective, do you have an opinion? How would you describe Mr. Benefield admitting that he shot a gun in the house, in the kitchen, to intimidate Miss Benefield to stop speaking?
Objection.
Sustained.
How would you
That's why he did
characterize
it?
Hold on,
She's talking
I
too
didn't
much?
hear the rest of it.
Yeah, I'm just asking him how he would characterize such an act.
Well, I was told you can't tell them, can you please shut up? It's just in your head.
You just shoot
So,
a gun off or oh shoot.
Probably a
Sorry.
better solution. So, yeah. Well, don't let yourself be convinced by the opening statements. Be convinced by the entire case. But yeah, it's going to be very interesting because if he has this style in front of the jury, I think it'll work against them.
Yeah.
I
We'll
don't
see.
know.
Yeah. Like a real
Of shooting a gun in the kitchen
real trial.
to
Yeah.
intimidate someone from speaking any further.
You want this witness's opinion about how he would characterize without any frame of reference. I mean, what do you mean?
Okay.
The judge was
Detective,
getting so
were you
mad.
aware that there was an allegation that Douglas Benefield had shot a gun in the kitchen ceiling of their home to stop Mrs. Benefield from speaking any further?
I was aware, heard that there was an incident allegedly that a firearm was discharged in the residence into the ceiling.
And would you describe that as a
She is a ballet dancer from Florida who met a 30-year older man, got married after 13 days, got divorced after 3 months, got back together with him. He had an undoing of his vasectomy. They got a kid. She moved away. They made a ballet school that should be all inclusive for everyone, and that went bankrupt in 3 months. Then allegedly she put 2 holes in her husband because she was afraid of him doing the final packing of the house they were moving to Maryland. She used to be a former Women for Trump in 2016 in Florida, leader of that.
Violent act.
I guess it all depends on the purpose and how it occurred.
Such as?
Objection as to his opinion.
Yeah, I'm going to sustain on and we're getting into a collateral matter, how this witness would characterize an act that he didn't investigate, he wasn't there for, he's heard about
You're not.
through some unknown source. So, no, with his opinion of that, I'm going to find is irrelevant.
All right. Were you aware during the course of your investigation, detective, that there was an allegation that Mr. Benefield would punch holes in the drywall of their home?
I believe that I had heard something like that, but I don't recall where that was from.
Were you aware that there was an allegation that Mr. Benefield had beaten his first wife up on their honeymoon?
Objection, Judge, what is it? It is irrelevant what this detective may or may not have known about his past.
Well, actually, Judge, this detective has testified that whether Mr. Benefield had a violent background is something he would want to know, that it would be significant to his investigation.
I mean, is this person going to testify though?
You know, I'm not
Like, if
taking-
she came out and said this? Because I mean, if
Well,
he beat the
he
crap
can get
out of his
he can get the
ex-wife-
ex-wife on the stand and testify he beat her up. But if it's just rumors,
That's what I mean. Like, quit going so hard on this stuff with other people. Like, why don't you just get the lady? And
yeah, it's always this hearsay.
Mm-hmm.
Did you hear the rumor about that rumor? And
Well, clearly that'll be a big deal if they bring her in. Like,
yeah, the American American National Ballet, but it was something like that. It lasted 3 months.
You need this for the truth of the matter asserted. You just, all you're asking is, did you hear this? It doesn't prove that those things happened.
I understand.
So I'm not sure why we're asking them this problem.
And that would be the second question is, so what's the relevance of whether he heard that the decedent may have been violent towards, I don't, would you say a first wife? I don't even know who that is. I don't know when they were married, how long they were married. I don't know the
First
nature of their
wife, Renee.
relationship. So I'm going to sustain that's irrelevant.
Okay. You are aware, are you not, of an incident where Mr. Benefield was seen by a
is
neighbor
that
at night standing in her yard?
Sorry. Yeah, actually, we discussed.
Yeah, that wife, I think she passed away like
Oh,
a
she
couple of
did?
years before he found this one.
well, that's
Uh,
unfortunate.
And Ashley said that his daughter really liked her because she needed a mother figure, but I saw her. She don't like her no more. Let's just say that.
that during the deposition. I remember because I had some questions about it myself.
There's a police report that accompanied it. Have you
Yeah.
reviewed it?
I did it one time, and I believe that the witness said that there was a person standing there. And I asked you how we got him identified because I guess they identified him by his voice, is what you told me, which I found odd because why would you sneak around and then talk?
Yeah, I heard it from the expert's wife who told that Jamie had told her that she heard from the expert that rumor.
What? You guys are ridiculous.
Kind of, you know.
Did you review that witness's deposition?
I did not.
It's Exhibit 5 to our standing ground.
I don't have access to those, so.
Have you ever placed a tracker on anybody's car?
Relevant.
I'll overrule.
Have you ever placed a tracker on anybody's car without the appropriate legal authority?
No, but I've done it with the proper legal authority several times.
I want to lastly ask you about some photographs of Miss Benefield. There were 2 sets of photographs taken you testified to, correct?
Yes, sir.
Some were on the evening of the incident And then there was a set that were taken a few days later.
Yes, sir, that's accurate.
So to cut to the quick, if we can, and not test what has up to this point been the judge's considerable patience, the scratches that were preserved in those photographs on Miss Benefield on the night of the incident, you saw them, did you not?
In the photographs later, yes.
Yeah, and they show as red and fresh, do they not?
They appear to be red, yes. I can't tell you how fresh they are. I'm not a wound expert.
Okay, well, they weren't scabbed.
Like I said, I saw a photograph later on.
Let me show you the photos.
Sure.
Let me just show them to you.
The one again that looks like just purple all over.
Thank you, sir.
I asked you 4 photographs that have been previously considered. Do they depict scratches on Miss Benefield on the evening of this incident?
They appear to.
Okay, and do the scratches appear fresh?
I don't think necessarily the one up under the sports bra appears.
Are they, what color?
Yeah, read up on it. It seems like a very interesting case. I'm going to do a little more homework too, but we might start up a new case tomorrow if we can do it before this one starts. Yeah, it's kind of like that. But then you can come back and give me the cliff notes. Then I don't have to do my homework, Jamie. It's just like school again. Well, I did have to do my homework. I just didn't do it.
Yeah, I read the basics. That's all I went into.
Did we miss the announcement that it's Roast Jamie Day? It's a day ending in Y.
David's over here trying to lure me over, saying he's got some juicy gossip. So I love gossip.
Are they? Are they pink?
Like I said, I'm not a color palette expert, but I would go with sure. They could be pink or red.
Okay, are any of them scabbed?
It's kind of hard to tell because they're so minute.
Do you see any scab?
No, and I don't actually even see an open wound on this one that would scab over. So
okay, let me show you the photographs that were taken.
So it's an abrasion.
Okay.
Thanks, love it.
I spent way too much time in Canton.
Why are these not marked? Yeah, if you're going to use photos, you either need to mark the ones you're using or use the ones that have already been admitted. Because we need to have a record of what you're showing the witness.
All right, let me have more.
Jesus. Well, I don't know if it's a blunt force abrasion if it's corner of a moving box. Do you call them moving boxes?
Madam Clerk, I'm fine if it's just defense 1, 2, 3, 4, 5, 6. You don't have to use the letter.
Yeah. I would say. Yeah.
All right, we're going to call these defense 1 through 6.
Very good, Your Honor.
Young Black, if you're a member in the Discord, Jess and Marissa is really good at finding all the papers. So get in there, read up on it, and we'll probably do a chat someday where you can come in and share all your knowledge with us. And I can do nothing again.
Yeah, join the Discord. We have docs and chat about it all the time.
Yeah. That's how every laceration and abrasion starts. Plastic discs.
All right, for the record, I previously showed you defense exhibits 1 through 4, correct?
yes, sir, that's correct. There you go.
I can say young black economist. If you want.
That's the name.
Now I'm going to show you defendants exhibits 5 and 6.
Thank you.
I'm going to ask you if those are the photographs that were taken several days later.
You would have to talk to the crime scene tech about that for proper identification, but I believe so. Yes,
All right.
sir.
And is the color of those scratches different than the color of the scratches in the photographs that were 1 through 4?
Well, the scratch that was on her hip, the red scratch that I said didn't have a scab, that's not even photographed in any of these, just so you know. It's actually gone. Other than that small little minute thing you can barely see, there does appear to be some scabbing, but it's very, like I said, very tiny.
Okay. Are you familiar with the concept of blading?
I am.
And tell us, educate us a little bit about what blading is in the sense of it being a defensive posture.
Are we talking about it in regards to law enforcement?
No.
Okay, well, I'm just, I'm not a jujitsu expert or anything, so.
I understand. I'm talking about with respect to minimizing the area of your body that is exposed to potential gunfire.
Okay, I guess if you were trying to minimize the area exposed, you would possibly turn your smallest side to it. Which would be your side? Sure.
Okay, otherwise known as blading.
If that's what you want to call it. Blading typically isn't a complete turn. It's more of a 45-degree angle or so.
Okay, again, to minimize the exposure.
Well, blading or interview stance, those types of things, blading is typically done like for our purposes. If I'm out interviewing a suspect, I'm going to blade my body and turn my gun sight away from them because honestly, that's more of a threat if they're looking at my gun while they're thinking about fighting me. I want to keep that away from. It also provides for balance.
Right. You want to make sure that they can't get the drop on you.
It's more of a safety thing than an offensive thing, at least in my opinion. But
Yeah, to protect.
like I said,
you.
I'm not an expert, so.
To protect you. As part of your investigation, you determined that the firearm that was used to shoot Mr. Benefield was owned by Ashley Benefield.
One of our detectives, I'm sure, did would have done that part of it. I don't recall doing that part myself.
All right, but you do recall it was lawfully owned by her.
As far as I'm aware, yes.
Yeah, and that she had a concealed weapons permit.
She may have. I don't remember if she did at that point, but it's possible.
I don't believe I have anything further, Your Honor. Thank you for your patience.
State, redirect. All right, can this witness be excused? Defense, can the witness be excused? Mr. Taylor, can the witness be excused?
Yes.
All right, Detective Warren, you're excused.
Thank you, sir.
Can you reach me those papers?
Yes, sir. There's a couple paper clips here. You want those too? Oh, yeah. Yes, sir. Yes, sir.
Mr. Taylor, I think these are your papers.
Jamie, I think I'm gonna end it here for today because we've been going for 6 hours, and it's 10:15 in the evening because Jamie wanted to start late today. Marissa and I are working a little bit. Either we'll pick up this again tomorrow and see the rest of it. There should also be a hearing, but that's just to excuse a witness because she was a judge's assistant, so she couldn't testify about anything she learned at the judge's office anyway. So I don't know why. It's the defense. They called her. But we're looking at another case that we might cover, which is another case out of Florida, Jacksonville, Florida. They just had their opening statements really quick, like 30 minutes. So if it's a weak case, so we can do this before this case starts, we might do that tomorrow and then continue to do it live because 30 minutes we can cover that and then get back to the case before the lunch break. Quite a bad case. Former radio DJ who studied to become a teacher, who allegedly was unalived by her baby daddy while I believe 3 months or 6 months pregnant. So he is accused of double homicide. But we'll have to figure out if I can finish that before this one starts, because now we started on the Black Swan. We're gonna try and keep up with that. But me and my team, I don't have a team. We'll look at that. And then we'll maybe do the rest of this if the other one falls through. But yeah, we'll do a little work behind the bars, behind the scenes is what I'm trying to say. Yeah, I've seen bits of it. Yeah, but Jamie, is that what we're gonna do?
Sounds good.
The other case is called. It's called. He is. I have it here. It is. Florida v. Bercy Armstrong, 2 counts of second degree. A man accused of unaliving a former radio personality in Jacksonville who was pregnant. He was 1 count of second degree, but then they found out with the kid. So yeah, the body was found inside her apartment with 2 young kids, 1 and 3 years old. So
The kids were okay.
yeah, the Warren states Young's mother told police that her daughter and Armstrong, whom the document lists as the father of Young's children, had a violent relationship with Young, telling her mother that Armstrong had held a pew-pew to her head 2 weeks earlier. They searched his cell phone, the Warren states, finding evidence of the volatile history of the relationship, including photos of a stabby stab and a pew-pew. Young sent Armstrong a text with the picture of a pew-pew and said, "This is the same pew-pew you held to my head," according to the warrant. The warrant notes that while researching Armstrong, there was a documented history of domestic violence, saying there was a felony domestic battery report written on May 2021, but the victim did not follow through with an injunction for protection. They searching his car and his residence turned up clothes that appeared to be bloody, a pew-pew, and ammunition. Yeah, so that could be a little bit interesting. So I hope hopefully it doesn't seem like the worst case, but they have like 16 witnesses, so it could be a bit longer. I'll have to go see the opening statements to see if we can figure out how long it's going to go. If that's okay with all y'all, because it's 10 o'clock. Time to get we shall see you tamale. That's a joke. It means it's a Mexican dish.
Well,
So, but I hope you enjoyed our day today. Now you go see what else is going on in the world. Probably nothing interesting. And we will look at either we do the last part of this tomorrow, because we played through 7 hours today, or we will pick up the other one if there's a chance we can be done by the time this case starts. Other than that, Jamie, do we have anything else to say?
not really. Anybody that wants to join the Discord, check it out.
Oh yeah, if you wanna hang out in Discord, talk about this case once all the documents, sit in chat, talk about nothing. We do that sometimes as well. Please reach out to Jamie, Marissa, Whiskey, or Irish, and they will send you a link. Or if you're a member, it's in the membership. I just refreshed the link today, and I remember to put in the link in the text where I put in new link.
Yeah.
We love to hear all kinds of crazy people in there. Iris talks a lot, and she is
the best.
Yeah, the best. And I'm only a little afraid of her. No, we have fun in there, and I hope you'll come have fun with us. We will stream again tomorrow, probably around 9 o'clock. Jamie won't be able to sleep in all day tomorrow again.
Never.
You were the one saying, "Can we please start late?" Because
Well, yeah, because I started work early, and then I wanted to make sure I got like a head start, and then so I could have fun with everybody. That's why I like starting later.
Well, tomorrow it'll be around 9 a.m. No matter what we're doing around 9 a.m. So we get the old rusty carcass back on the track and get ready
I'll
to
be here, or
live
I
stream again.
won't, or I'll be late. It's fine. It'll all work out. It'll be fun.
It's funny, after 2 months of covering a trial, and you take like a week off. Jesus, your back hurts again when you start doing it.
It is. It's a lot.
Yeah, I forgot how tiring it is.
Anybody that thinks actually sitting and streaming all day is like a piece of cake.
Yeah, well, it is a piece of cake. All the content is made for you. You just have to remember everything said and read the chat and answer all the questions that you get.
Yeah,
So
it's fun though. It's a fun
yeah,
time.
it keeps the squirrel running in the same direction,
Mm-hmm.
and that's the best thing you can have. On that note, I think Jamie and I will say, kan du have det rigtig godt, til vi ses igen. Ikke kysse alt for mange piger, når jeg nu siger farvel.
What exhibit are you referring to?
I'm going to make this 100, Your Honor.
All right, 100.
100.
Because it is 100%
100%.
correct.
Objection, Your Honor.
So you literally built a cannon?
Yeah, it's pretty awesome.
All right, I'm in love.
Go back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't care.
You wouldn't have cared?
No,
Did you believe he had slept with your wife?
no,
Did you believe he slept with your mother-in-law?
probably did. Everybody has.
So there-
Everybody has.